understand that you are part of the investigation team of the Commission.
That is correct.
Thank you very much for coming to assist us on this matter that requires, I think, unusual expertise. So he will help us to make sense of some of the things that we don't understand. Okay, please administer the oath of affirmation.
Please state your full names for the record.
Cecil Louwrens.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath binding on your conscience?
Yes, I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
Thank you.
Yes, thank you.
You may proceed.
Thank you,
Yes. Have you announced for the benefit of the public the area on which he'll be giving evidence?
Yes. So, sorry, DCJ.
Somebody was interfering with you.
Yeah, they were giving me notice that Prof Louwrens's oath was not captured by the recording.
Oh, okay.
Yes.
We'll redo that.
Yes.
I was asking whether you have already informed the public for their benefit on what aspect Professor Louwrens will be testifying so that they can follow his evidence. If you haven't done so, please do so before he starts.
Yes.
But maybe let's redo the oath.
Yes.
What was wrong? Because I don't think he was speaking too softly. They just didn't put on their machines. Okay, all right. Let's register. And Professor Louwrens, let's just redo the oath. Hang on. I think the technicians are making some gestures. Okay, all right. Okay.
Please state your full names for the record.
Cecil Louwrens.
Do you have any objection to taking the prescribed oath?
No, I don't.
Do you consider the oath binding on your conscience?
Yes, I do.
Do you solemnly swear that the evidence you will give will be the truth, the whole truth, and nothing but the truth? If so, please raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. Prof Louwrens has been called as an expert witness for a matter that has arisen before the Commission. That matter arose in the context of the affidavit provided to the Commission by Mr. Zitembe Khoza, in which an allegation is made that he had received 4 letters of suspension. He thinks that the letters were received from Mr. Tsotsi, but he doesn't know how. He has provided those letters with the metadata relating to each of those letters, in terms of which the author of the letter and of the letters and the last modifier of the letters are mentioned in the metadata. The Commission seeks to have established independently of what has been provided to it by Mr. Khoza, by way of an expert opinion or expert evidence, whether the author of the letter is indeed the person whose name is reflected on the metadata, and whether the last modifier of the letter is also the person reflected in the field for that name in the metadata. And Professor Louwrens is here for that reason, Chairperson.
Yes, no, that's fine. And as I understand the issues, his evidence also relates to whether there is any basis on which it can be said that somebody outside of Eskom had something to do with those letters of suspension prior to the 11th of March 2015. So the evidence revolves around the suspension of the executives. And if so, what is the basis for saying that? Or there might not be a scientific or technical basis. So that's part of what Professor Louwrens will assist us on using the pre-suspension letters that you have referred to. Okay, all right.
Correct.
Thank you. You may proceed.
Thank you. Prof. Louwrens, once again, thank you for your availability in assisting the Commission. Could you, please, by way of a background, just state your qualifications and your expertise relevant to the assessment that you have been asked to perform?
Certainly. So, I own a consulting firm called Quintessence Digital Forensics. I've had that for the past 5 years, and that's basically why I'm also involved in the Commission, because of my involvement there. But
You said you have had the consulting firm for how long?
5 years.
5 years?
Yes.
Okay, all right.
But prior to that, I was involved in the industry. I was in the military for a number of years, where I was in the military intelligence and also did not computer forensics, but computer security. And I then worked for a major bank as a Chief Information Security Officer for a number of years. In that role, I also managed the digital forensics function of that bank. And I hold the following qualifications. First of all, BSc or BA, military science. BSc Honours Computer Science, MSc Computer Science, and then a PhD in Computer Science.
You mentioned BA. Is it BA Military Science or is it BSc Military Science? I see in the affidavit.
It's BA.
It's BA, so that should be corrected.
That should be corrected.
Okay. And your consulting firm is in what sector? What does it do?
It's in digital forensics, so
Yes.
I do forensic investigations
Yes.
and analysis of criminal cases, civil cases.
Yeah. Okay. Mr. Slayer.
Thank you. Mr. Bergs, Professor Bergs, Louwrens, you have provided the Commission with an affidavit. The affidavit chairperson is found in Eskom Bundle 19, page 355. Are you there, Prof. Louwrens?
I've got it.
The affidavit runs up to page 370. 370. So you follow the black pagination on the left-hand corner, top left-hand corner. Okay.
You're speaking too softly, Mr. Slegger.
You found a page, page
Yes, I did.
370. The affidavit, well, on that page, a signature appears above the name Cecil Louwrens. You see that?
Yes,
You confirm that to be your signature?
that is correct.
The affidavit is dated 19 April 2021. You confirm this to be your affidavit,
I do.
and you confirm the correctness of the contents thereof.
I do.
Thank you. Chairperson, I beg leave to have the affidavit of
Before that, you want to let him confirm that it's got annexures and just to identify, to say from what page to what page the annexures run,
yes.
just so that I'm sure which ones are his annexures, which documents are not his annexures.
Correct. Prof. Louwrens, the affidavit also has annexures to it, starting from page 371. You see that?
That is correct.
Right. And there's a number of annexures to your affidavit, up to page 421.
That is correct.
You see that, which is the confirmatory affidavit of one non-Dumiso Zibi. You see that?
Yeah.
There is also a confirmatory affidavit on page 423. Currently, it is the unsigned one. We have the signed one here of Mr. Tsepo Moleko.
That is
You
correct.
see that? Chairperson, while we are there, we have the signed copy of Mr. Moleko's affidavit, confirmatory affidavit, which I shall beg leave to hand up
Yeah,
to replace
Okay.
the unsigned one.
yeah, that's fine.
Thank you. And so the last annexure, Prof. Louwrens, is then the affidavit of Mr. confirmatory affidavit of Mr. Moleko on page 423.
That is correct.
Is that correct? Thank you, Chair. Then, Chairperson, I beg leave to have this affidavit of Professor Louwrens admitted as exhibit U42, point 1. Chair, the reason I'm pausing is because it's already marked exhibit 42, U42.
Oh, but it should be 42.1.
Point 1. Thank you,
Okay,
Chair.
okay. Well, that correction must be made so that there is no confusion.
Yeah.
Okay, the affidavit of Professor Cecil Louwrens, which starts at page 355, is admitted as an exhibit and will be marked as exhibit U42.1.
Thank you.
Yes.
Thank you.
He had
Prof.
told us
Louwrens.
already about his academic qualifications.
Yes.
He had told us about his consulting firm and what sector his consulting firm is involved in. I think you can take it from there in terms of completing to qualify him as an expert.
Thank you. Thank you, Chairperson. Prof Louwrens, we see from your affidavit that you have also been involved in academics.
That is correct.
Yes,
I've been involved at the University of Johannesburg, specifically lecturing digital forensics at honours level, and also computer security, risk management, and computer project management.
So your background, and I'm talking educational, from an educational point of view, your career is in IT.
That is correct.
Can you explain to the chairperson, when you're talking about digital forensics, what exactly does that refer to?
It is a similar field than normal forensics. The same principles apply, but the techniques are different, and obviously we have to rely a lot on technology and specific tools. So that then means that you would investigate, say for instance, a hard drive, that's a computer disk, from a suspect or whatever the case might be, and the hard drive would then be analyzed in detail as in terms of the consistency, the metadata, and that is the data about data. So say for instance we've got a file or a Word document. That Word document is associated with other information or other data, which is called metadata, which in fact describes that document. So if we want to know more about that document and the contents, how it was created and who created it, the metadata can actually provide us with some information to that extent. And then if we have access to a computer, the whole disk, you could also then get corroborative information in terms of the file system, and you could then see if it's consistent, and if that is consistent, that would lead us to make certain deductions from that. But it's basically establishing the facts from digital media.
Yes, continue. I'll come back to this later, but I think continue to qualify him.
And so how long were you employed at the university?
I was employed as a visiting professor.
As a visiting
Yes.
professor. For how long?
15 years.
That is from when to when, the 15 years?
That was from 2004 to 2019.
Okay. 2004 to 2009?
19.
Oh, 2019.
19, yes.
Okay, all right.
Sorry.
Okay, all right. And throughout that period, were you lecturing on computer science, IT, digital forensics? You were covering those?
Yes, that is correct.
Okay. And some of the students that you were teaching were doing honors, were at honors level?
Yes.
And any students who were doing masters and doctorates that you might have supervised and promoted?
I did. I supervised a few master students and a few PhD students.
Okay, okay. All right, continue, Mr. Seleng.
Have you yourself written articles in the field of digital forensics and IT?
Yes, I did. Specifically articles that were presented at international conferences. And I also contributed to a chapter in one of the IFIP, it's International Federation for Information Processing a book.
Well, maybe you can just give us the title of the book, if you are able to, and then maybe the title of the chapter that you wrote,
Okay,
if you can remember.
I'll get you
Otherwise you can supply it
precise. Yeah,
later.
but it's about the latest developments in computer forensics, and the chapter was about the framework for evaluating digital forensics within that framework.
Okay. Other than the chapter, that chapter in that book, and papers that you delivered at international conferences, would there be articles that you have published in articles or in journals or that fall within the sector of forensics, the digital forensics, computer science, the field?
Specifically in computer science, I published an article on how to protect a computer by using, let's call it a biological model for computer security. So that it enables the computer to protect itself.
Okay, all right. Yes, Mr. Selega.
Thank you.
Or maybe just before Mr. Selega proceeds, just for the sake of completeness, what is the name of your consulting firm?
It's Quintessence Digital Forensics.
Yes, okay, all right. Continue, Mr. Selega.
Thank you. Prof Louwrens, then, talking of digital forensics, and which involves looking at the metadata and making an investigation, how often would you have done that sort of an investigation?
In terms of metadata,
I'm sorry, Mr. Selega.
Yes.
Maybe you should just cover what he has got to say under paragraph 4 up to 8, because it covers the other matters relating to his qualification as an expert. I think some you may have covered, but you can just check, make sure we cover all of them.
Yes.
Otherwise, he can just give that evidence.
Prof Louwrens, you see, to go back to page 355 from paragraph 4, you mentioned there that you have more than 41 years experience in security and related fields in financial services industry and military, comprising, and then you give a list. Let's deal with security, which I think is what you deal with in 4.1. When you say security, what are you referring to? Experience in security?
there are basically three types of security. The first would be physical security, which we all know, that's physical guarding, alarm systems, CCTV systems, and access control. Then there's the next one would be personnel security, which is screening of personnel, making sure that the background checks are done and that people are saying or are what they purport to be. And the third one would be computer security or information security, being used interchangeably, where it goes about the protection of computers, the access control to computers, to systems, to files, to be able to monitor what happens on computer systems, and to protect against viruses and malware.
And of the 28 years referred to in paragraph 4.1, how many of those years relate to the last parts that you said, computers and
Computer security.
yes?
I was Chief Information Security Officer since 2010. So
2010.
10 years.
Yes, okay.
But prior to that, I was always involved to a certain extent in information security.
Okay. Continue, Mr. Louwrens.
Then you mentioned in paragraph 4.2 that you have 9 years in intelligence and information security in military environment. I know that you did touch on the military environment. Could you elaborate a little more what the intelligence and information security in that environment would entail?
It was early years in the military in terms of computer security. It was a new field. I just completed my degree at Stellenbosch University, Saldanha, and I was then requested to write the first information security policy for the defense community. So I started off in information security in 1986. 86.
So you would have then been employed by the South African Defence Force?
That is correct.
Yeah. But what is it that you did when we're talking intelligence and information security?
In terms of information security, the first job that I had to do is to write a policy for information security, how to do it, what needs to be done, what the responsibilities are, etc. So the policy to govern information security, or computer security as it was called at that time. In military intelligence, basically, we monitored the external events, any threats to the country, etc. And also the computer security relates to that, because as we were using computer systems, it could have been threatened, and it could have been abused and accessed and hacked. Although at that time hacking was not a known term, it just became more known later on as progressed.
And then you have 5 years, you say, in digital forensic consulting, so you would have consulted in digital forensics, which you've already explained.
Yes.
Can you tell the chairperson which years are those, if you can recall?
Which year?
Yeah, you say 5 years. From
Yes.
which year to which?
2016.
Yes. And in paragraph 5, you say you have following digital forensic certificates, access data certified examiner, and NCASE certified examiner.
That is
So-
correct.
Yes, so what does this certificate mean? You are an examiner?
It means that I'm qualified to be an examiner using those specific products, and those are two of the more known products in the digital forensics environment.
And what products are you referring to?
The first product is access data. And the second one is in case forensics. So the Access Data Certified Examiner has the ACE qualification, and then the in-case Certified Examiner is the ENCE qualification. So both of those require examination, and you can only be certified if you pass that examination. It involves a practical component as well.
Are you able to give the chairperson insight into what is being referred to as access data?
Access data is one of the leading products in the digital forensics tools market. It provides you with a platform or the ability to analyze data, hard drives, data that you capture from other electronic media, and then to categorize it and to display it in a way that's understandable, and also to report on it.
So by a way of example, what sort of data?
So, say for instance, there's a question about if somebody did something on a computer, we could then access the logs on that computer and look at that event and see if that event correlates to the action that person is accused of or was purported to have done. We can also then display the actions, the time, specific time that it happened. We can also see from that computer was connected to any other computer on the network, any other drives that were connected to it. For instance, a USB stick. If you connect that, it is recorded, so I can show that what happened. I can also identify, for instance, that USB drive by the serial number that is recorded.
So the tool, is it a software or an application?
It's a software tool. So it's actually a suite of products. It's
Okay.
called, yeah.
And then the N-case, if you could also explain what it entails.
In-case is similar. It's got the same purpose, and it's got much of the same functionality. It's just two different tools. It's like having two sets of spanners. The one you use for this and the other for the other. So the reason why we would, in the digital forensic world, would like to use more than one tool is to verify our results, to make sure that it is actually correct. And if there are any anomalies, to be able to explain that. So In-case provides the same functionality. It has some certain strengths in certain areas, and it's less well versed in others, for instance. But if you use both of those tools, you would get to the correct answer.
In regard to the assessment that the Commission had required you to do, did you have to use any of these tools?
Yes, I did. I specifically used In-case because it displayed the information, the metadata that we needed to look at.
Then I'm ready to go into.
Yeah, no, that's fine. Before, I guess this would be the right time for me to ask. I see that in your affidavit, footnote 1, you tell us what metadata is. You say metadata is data that provides information about other data. In this case, it is data about the 4 MS Word documents in question.
That is correct.
Is that right? Now, if you are given a document and you have to establish in which computer or which computer was used to type it. Your expertise enables you to do that.
No, that's not that easy to do. It depends on the document itself.
Oh, okay. So in some cases you can,
In some cases you can,
in some cases you can't.
some cases you can't.
Okay.
And yeah, we can talk about this case if you want to.
Yes, yes. So we'll come to that. I think that's fine. Maybe let's talk about this case and then we'll take it from there.
Right.
Yeah, Mr. Selega.
Thank you, Chair. Yes, Prof Louwrens, you were given an email.
Well, I wanted to say earlier on, and I didn't say it, Mr. Selega and
Yes.
Professor Louwrens, that I hope Professor Louwrens won't feel embarrassed in any way by this. I wanted to say, well, some of the people have said that the commission has got some of the best investigators, and I just wanted to say, well, you look at these qualifications, you see why they say that.
Thank you, Chair.
It's a compliment, Prof Louwrens.
Yes. Yes, thank you.
Prof Louwrens, you were given then an email with 4 letters attached to it.
That is correct.
The 4 letters titled pre-suspension letters.
That is correct.
And you were, together with those letters, provided with the metadata that we also received with the letters from one of the witnesses.
That is correct.
Yes. You refer to those letters in paragraph 11 of your affidavit. And what I would like you to do for the purposes of evidence is to take us through each letter.
Well, maybe before that, Mr. Selega, I think it's important that he deals with paragraph 10, which is, I think, where he articulates what he understood his mandate to be in terms of what he was asked to do.
Yes.
Do you want to deal with that, Professor Louwrens, what you understood your task to be?
I will, Chair. So I've been tasked to conduct a digital forensic assessment of the metadata of 4 Microsoft Word documents that were submitted into evidence into the Commission. The 4 Word documents were attached to an email, and I've got the images of that attached to Annexure CL1 here. So the first part of the Annexure CL1 contains an email that has been attached and forwarded. The second part of the Annexure contains the email itself. In other words, the original email contained another email that was forwarded as an attachment. So it was an email within an email. And within the second email were 4 documents attached. And those are the documents that I've been asked to look at.
Take it from there, Mr. Selega.
Yes. Let's go to CL1 quickly while we are here, which is on page 371.
What's the page? 371.
371. Sure. So, Prof Louwrens, you say the 4 MS Word documents are attached to an email, images of which are contained in Annexure CL1. So on that page 371 is an annexure marked CL1. You see that?
Yes, I do.
Is this what you are referring to as images of which? Images of an email?
That is correct. So the top portion of that is the image of the email. That is the first email that contains an attachment. You can see the little yellow block.
Yes.
And that yellow block refers to the next page, which is 372, which is the email containing the 4 documents.
Okay. Is that yellow block the one titled Special?
That is correct. Specialdocs.msg.
MSG. And sorry, just carry on. You were saying the next page is?
The next page is actually that yellow block.
Oh,
That email is contained in that yellow block. So if you open that yellow block, you find the next one on page 372.
I'm sorry. Going back to page 371, just below the yellow block, you have got something written there. What is that, Prof Louwrens?
We've got the sender
Who is reflected as?
Khoza ZW at eskom.co.za.
Yes. And the subject?
Subject Special Docs.
And the message there. if
Then
you're
there's a
able to-
message ID, which is a long string of letters,
Yes.
which uniquely identifies that message to the mail system.
Yeah.
And then it's the to field is Benita at kleinink.co.za.
Yes. Okay, all right. What do you make of that information there? What does that information mean? Namely, what appears next to the yellow block as well as the information underneath that?
It means that the email was sent from an email box called Khoza ZW at
Yes.
eskom.co.za
Yes.
to an email box called Venita at kleinink.co.za.
Okay, all right. Yes, continue, Mr.
Yes.
Sileka.
so then you say when you click on the yellow box,
Yeah,
it opens up to what?
that is correct.
It opens up to, you were saying the documents from page 372.
That is correct.
And what do we find there in the yellow folder or box?
We have then an email that was attached, and the email was from an email address called September Khoza, which is then the same address as the previous one, Khoza ZW at eskom.co.za. And then we've got 4 Word documents attached. The little W in the blue boxes is very small, but you can make it out. Means it's a Word document. Then the documents, the first one is called pre-suspension dm.docx. The second one is called pre-suspension fd.docx. Third one is called pre-suspension jm.docx.
Is it MK?
Sorry, K. And the fourth one is pre-suspension.pm.docx.
This email you are referring to, could you determine where it came from, or who was the addressor and the addressee?
Yes, in this sense that we put through the evidence that we've got from in the Commission systems, evidence previously seized from Eskom, I could discover the same documents, and I could actually find this email in the mailbox of Forza ZW.
And who was he addressing the email to?
It was exactly the same here as Benita at Lane.
I see.
Yeah, that's it.
Yeah. And do you have the date for this exchange of email?
Yes, let me just go through this.
Is that the 14th?
14th of March at 2015 at 13:20. But that is Universal Central Time, so we must add 2 hours for local time.
I'm sorry, that date, that time is for what? For the sending of an email of what?
It was the email that is imaged here
Yeah.
was sent at that date and time.
Yes, that was on the 14th.
14th
March.
of March 2015,
Yes. And what time?
13:20,
Yes.
36,
Yes.
plus 2 hours. So in
Oh,
South
yes.
African time, it would be 15:20.
Oh, okay, all right. Okay. Thank you. You may proceed.
Thank you. Then, Prof. Louwrens, the documents, MS Word documents you have indicated as pre-suspensions DM, FD, MK, and TM, if you click on that, let's say the DM one first, what do you find?
It is a document that purports to be a pre-suspension document addressed to one of the addressees.
Just look at page 373.
Please say again.
Page 373.
373.
They are pre-suspension letters, is that right?
Yeah.
Okay.
Right. So if we look at CL2, the pre-suspension dm.docx, it's a document from reportedly Dan Marokane, Group Executive, Group Capital, dated 11th of March 2015.
You did say addressed to him, not from.
Yeah, addressed to
Yes.
Dan
okay.
Marokane. Yes,
And the date given is 11 March 2015 on the document.
correct.
Okay.
And it's an invitation to a pre-suspension meeting. And
Yes.
then few points follow.
Yes.
So there's the document reading, Dear Mr. Marokane, invitation to a pre-suspension meeting. Correct.
That is correct.
Yes. For the sake of completeness, because I think they are all the same, isn't it?
Yes.
I think let's read one into the record. Prof. Louwrens, would you please just read that one into the record?
The whole letter.
Yeah,
I'll do
starting
that.
from Dear Mr. Marokane.
Okay. Dear Mr. Marokane, invitation to a pre-suspension meeting. The company is presently conducting an investigation into allegations of misconduct allegedly committed by you. The allegations of misconduct, which will be investigated, relate to, amongst others, the following. 1.1, the chairman of the emergency committee as the chairman of the emergency committee, you have been negligent in the management of the electricity system during the times of emergency that resulted to unnecessary load shedding. 1.2, you were grossly negligent in managing the build program for Medupi that resulted in delays and cost overruns. 1.3, you acted irregularly in administering and managing the coal purchase contracts to the detriment of Eskom. 2, the company has not completed the investigations. The purpose of the investigations is to establish whether there are grounds for disciplinary action. Having regard to the 2.1, seriousness of the allegations, and 2.2, the possibility that your presence may jeopardize the investigation into the alleged misconduct. The company is of the view that you should be suspended on full pay pending the finalization of the investigation. 3, you are temporarily suspended until further notice. 4, you are invited to make a representation to the chairperson of the board of directors. 5, the meeting will be held on 12th March 2015 at 9:45. 6, during the meeting you will have the following rights. 6.1, you are entitled to be present at the meeting. 6.2, you are entitled to be represented at the meeting by a fellow employee or an employee representative. 6.3, you are entitled to have the facility of an interpreter if so required. 6.4, you are entitled to confer with your representative at reasonable times before, during, and after the meeting. 6.5, you are entitled personally or through your representative to question us as to the reasons why we believe that you should be suspended. 7, we envisage that our investigation should be completed within a period of 4 weeks. And then,
Yes, there's no name for the author, but there's a space, and then there's a sentence saying, I, Ken Morokane, acknowledge receipt of this notice to attend a pre-suspension hearing, and the space is provided for his signature and date, and after that, there is space provided for the signature of the person serving the notice, but those were not signed. Okay, I say that they are not exactly the same in terms of the allegations.
The allegations,
Yeah,
that's
but
right.
let's deal with this for now, and then this one, and then we take from there. Or unless you think we should just deal with all of them, and then you want to deal with all of them.
I think so, Chair.
Okay, then.
And the others,
Then continue.
Yes.
Then continue, Mr.
Thank you.
Selega, just proceed as you intended to.
Yes. Prof Louwrens, so that would be the first annexure to the email on page 372. There are 4 annexures. There's another one titled Pre-Suspension FD. Look at page 377.
that is correct.
Well, before you go to 377, would you let him tell me what the document at 375 represents, which comes immediately after the letter that he has read?
Page 375, we've got the metadata that are
Yes.
extracted from that document.
Oh, okay, okay. And that's the metadata that you use to interpret and come to certain conclusions.
That is correct.
Okay, all right, that's fine. And are they at 375 and 376?
Yes, what I did there, we've got 2 systems. The one is the one that I've extracted from the case, and on 376 is our system relativity.
Yeah,
I've extracted the metadata from there.
yes.
And what is important there is that see on 376 at the bottom the MD5 hash. I'll
Yes.
explain what the hash is. The hash is like a fingerprint for the document.
Yeah,
It's a unique number that represents a document. If one bit changes in the document, then that number will change.
okay.
So it's important that that number is the same as the number that the document that I actually investigated.
Okay.
So you would see that on page 375, the second line of that table is the MD5 hash.
Yes.
And then the last line of 376 is also an MD5 hash, and those hashes are exactly the same, which
Okay.
is important because that means that I've dealt with exactly the same document.
Okay.
And I also refer to that document if we come to the evidence later from the other expert report. They also use that MD5 to identify the document, so it's important to note that those documents are exactly the same.
Okay. Okay. Yes, Mr. Selega.
Yeah. So, President, I think we could go into the metadata
Yes, let's do that.
per letter.
Yeah.
Is that all right?
Okay.
So, Prof Louwrens, you were asked to conduct digital forensic assessment of the metadata. So, you are saying page 375, and we will deal with each letter at one time. Page 375 is the metadata in relation to the letter pre-suspension DM.
That is correct.
That is addressed to Mr. Denmarukani.
That is
Yes,
right.
but just before you proceed, just to make sure one can follow, you have said that you have confirmed that you were asked to conduct a forensic, a digital forensic assessment. Is that the correct
That is
term?
correct, yes.
Yes. When a person conducts that assessment, digital forensic assessment, what would they be looking for? You conduct that assessment in order to get what? To achieve what? What is the outcome of such an assessment?
In this case, I've only had the actual Word documents and obviously the email.
Yes.
So let's deal with the Word documents first.
And you must just take it that I know nothing about IT and so on, so don't feel that you shouldn't explain some of the basic terms to me.
I will do that.
Yeah.
So the Word documents, Microsoft Word is a product from Microsoft. It's part of the Office products, Microsoft Office. And it's widely used as a word processing tool or software. Now, what's specific about the documents that we are dealing with here is they are docx. If you look at the later part of the name, it's the name of the document, and then we've got a .docx. That qualifies that document as a certain type of Word document. DocX is the latest standard that is used in Microsoft Word. And it also then indicates that it's got certain metadata, EXIF, we call it EXIF metadata, which is embedded in that document, which you could then investigate. So by using digital forensic tools, like in case, for instance, you could then extract that information. The information is also visible, some of the information is also visible on the document itself. If you go into the document and you go into what we would call info, file info, it will display a page, and the page will then display who created the document and who last modified the document.
So you use some instrument to look at the document,
That is correct, yes.
and then you can see certain images and information.
Yes.
Okay. And
So-
that information could tell you a number of things, including who may have had something to do with the document in one way or another.
Yes.
Okay.
So
Okay.
if you look at the table on 375, that is the information that I would then extract, or could extract from the document. So I don't know if you
Yes.
want me to deal with that.
Using what we just talked about or using a number of instruments?
A number of instruments.
Yeah.
I normally use in case,
Yeah,
but as I said, I verified this specifically with another tool
yes,
to make sure that I understand it correctly, because it's also a bit open to interpretation. They don't always give you all the information. Maybe they say, for instance, you get a value of 3. The question is, what does it mean? Then you have to corroborate that with other tools to see it's 3 minutes, for instance.
okay, all right. Continue, Mr. Louwrens.
Prof. Lawrence, just before you move on, does it mean if I don't have the NCase tool in my computer, I wouldn't be able to generate this information or to come up with, to pull out this information?
No, you could use various other tools to actually do this, but the in-case enables you to do that.
Yes. Just say that, okay. You could what?
You could use a number of other tools also to extract it, other
Yeah.
than in-case.
Yes. Well, what I'm asking you is, take my standard laptop.
Yes.
I buy it from whichever shop. I have the normal word processing, Microsoft, but I don't have the tools you're referring to. Does it mean without those tools, I wouldn't be able here to extract this information?
You would be able to extract some of the information, not
Some of
all
it.
of it, because Word does actually display some of the information.
I see. So then, let's get you clearly. In this case, you were given the emails and you were given the attachments to the emails. You were then asked to do or conduct digital forensic assessment of the metadata. In relation to what you have been given. Tell the chairperson what then, what should we understand you to be doing when you conduct a digital forensic assessment in relation to the documents that you were given? Do you know what, well, firstly is what we understand you to be doing, and secondly, what is the objective in your exercise?
In this case, it was specifically to look at who created the document and also who last modified the document. But also, if we look at any analysis, you would also always look at time, when it was done. Does it make sense? For instance, was the document created before the email was sent, because it's impossible to have it created after, and if it was created after, as in one of the, or some of these metadata indicates, you could maybe look at why the dates are inconsistent, and then you have to know a lot about the file system, how it actually creates dates, changes dates if you move files from one drive to the other, and also if you access the file, how it's updated. So you look at all those things, ancillary things as well. But what's important to note here, these are the values recorded. How they relate to real life is something different. So in this case, the values recorded for the creator was Suzanne Daniels. And the last modified field.
And what was the date when she created the document? Or you are still going to come to that? It's fine if you are still going to come to that.
I can give it to you.
Yeah.
I wouldn't be able to say if she created the document.
Or you can say when
I
the
can give you the
document was
create
created.
date of the document.
Yes,
Yeah.
okay, okay.
So the create date of the document was 2015. That's 10th of March, 1639. And that is also then Universal Central Time, so plus 2 hours, so it's 1839 South African time.
Okay. Yes. Continue, Mr. Slugger.
Yes. Okay. Prof, we will come to that. Let's just lay the groundwork relative to your investigation or forensic assessment. Please go back to page 357.
357.
357. So your first task is what?
I just mentioned Mr. Selega for what it's worth. I was hoping we would finish within an hour. I will be having the witness for today in due course. I had said he should be here at 10:30. So, but it's important that we cover this properly. Yes, but I thought I must just mention that because when we previously spoke, today was vacant.
That's fine.
So I just wanted to know that
Okay.
we don't have a lot of time, but we must do Professor Louwrens' evidence properly.
Yes.
Okay, let's continue.
Yes. Prof. Louwrens, page 357, just to lay the groundwork. Paragraph 10, you have already stated what the first purpose is, or the first requirement to you was in regard to the documentation that were given to you. And then in paragraph 12, you also say that you have also been asked to express an opinion on the forensic report issued by a company called Cianre.
That is correct.
Okay. Let's go to paragraph 13. We will come to your opinion in regard to that opinion of Cianre. Paragraph 13 says, the evidence that I examined was forensically acquired and processed. When you say forensically, what do you mean quickly on that?
What I mean is that we've got a principle that whenever you acquire or source evidence or data, you take care not to change anything. So when it is then acquired, that media or disk or whatever is right protected so that you can't change it. And the tools actually enable you to verify that it's not been changed. So it's an exact copy of the data.
Yeah. So this will be your, again, computer-related tools.
Correct.
So you then say, I have examined the chain of custody documentation associated with the evidence and found it intact. The chain of custody documentation, what does that mean?
Chair, it means that whenever we seize data or source data or acquire data, we fill in a form which tracks exactly who is involved, what the source is of that data. We get the signatures, the timing, we note the media, the serial numbers, etc. on that form. And then that documentation accompanies the evidence to the point where we sign it into our secure storage facility, and we can then verify that the data or the evidence was not tampered with, and we know exactly what every handoff would be from one person to another.
So that you confirm in this case was followed and it was found to be intact.
That is correct.
turn to page 358. Paragraph 14, you say the email in question was sent from the mailbox of COSA. You've already testified on that. On 14, let me read the bracket. COSA zw@eskom.co.za. The COSA email mailbox on 14 March 2014 at 36 p.m. UTC to Venita at klaininc.co.za. Paragraph 16, I did not find an email received by the COSA email mailbox with the said documents attached to it on the Commission's e-discovery platform for the purposes of performing my assessment. Yes, the question is, given what you're saying there, could you see where did Mr. COSA obtain the documents?
No, not from the evidence that I had. I could not see that. There are many other ways that he could have gotten that other than receiving it through his email box. Like, for instance, another email or a physical USB drive.
So, are you saying there is no indication that his email to Ms. Venita was an email he was forwarding from somewhere else and then sending it to Ms. Venita Klein?
That is correct. I couldn't find.
You couldn't find it?
No.
So he would have been the creator of that email and then attached the letters to it to send to Ms. Venita Klein.
That would be correct.
I just want to make sure I understand that. Did you have access to his computer, and is that what you would need to have access to see whether he had received the documents from somebody else?
Yes, Chair. I only had access to the mailbox, the image that we collected from his mailbox.
Yes.
If I had access to his computer, I might find more information relevant to this.
Yes.
For instance, if he had other email addresses,
Yes.
or if that document resides, or those documents resides on his computer.
Oh, okay.
But at this stage, this is all I have. I cannot say.
Yes. Okay. And about the creator of the documents, you say there is a possibility that it could have been created in his computer, but you don't know that for sure.
Yes, for the reason is that the creator and the last modified metadata can be changed. It's very easy to change, and if you know what to do, you can actually change that. So you cannot rely on that on its own. You have to have corroborative information or evidence.
Yes. But if it's not been changed, it would be giving one information about who created it, if we knew that it had not been changed.
If we knew it was not changed, it normally picks up the user of that computer. In other words, if you have an account on that computer, you've got a username. That username is then reflected in those fields. And if it's not changed, it's normally the username.
Okay, all right. Thank you.
So the username will be the name of the person who uses that computer or who owns the computer.
No, I wouldn't go that far. It would be the username that was assigned to that.
I see. So So my computer could have SLK as the username,
Yes,
as opposed to Pule as the username. Is that what you're saying?
that's why I say you can have Mickey Mouse as the user.
You can have Mickey Mouse as the username.
Correct.
But if your computer reflects that, or if a document reflects your username, let's say your username is Bucks. That doesn't mean, does it, that that email was necessarily created in your computer? Someone can use another computer and just put in that username.
Correct. You
Okay.
could do that.
But if that username, which happens to be your username, is reflected in relation to a document that is found in your computer, is that not a sufficient basis to say, until somebody comes up with evidence that somebody else interfered with this computer, with your computer, you must be the person who created that document? Is that not a basis to say this document is found in Professor Louwrens' computer? It reflects Bex as the username. Bex is the username that Professor Louwrens uses. Therefore, until somebody tells me otherwise, I should take it that he created it. Is that something that scientifically, technologically is sound or not?
Not from a technological point of view, but it's a reasonable assumption if you look at, say for instance, if it was a corporate computer, where the usernames were defined, and where there are specific rules and policies not to share password, and not to allow access to that computer, then it would be reasonable to hold that person responsible for the actions on that computer. So, yes, in that sense, forensically, there's nothing that I can tell other than if those policies were in place, and I can't say that from the documents.
And when you refer to policies, that's the corroborative evidence you are talking about in your opinion, your affidavit?
Yes, that is correct.
Yes, yes. So you look at what a forensics provides us with, and you look at surrounding evidence,
Yes.
and then you use the two, and based on that, you might be justified to reach a certain conclusion.
Correct.
Okay, all right.
Thank you. Thank you. Prof. Louwrens, you mentioned having access to the mailbox of Mr. Khoza, but you didn't have access to the computer.
That is correct.
Maybe you need to explain to the chairperson, how does that work?
And what difference it makes to have access to the mailbox but not to the computer?
Chair, it makes a huge difference. What we got was every big company, corporate environment has got its own mail management system, mail service, and so on. So what we've got is a copy of the mailbox on the server, not the mailbox on his personal computer. So I only had access to the mail-related evidence and not to any other system-related evidence that might be on the computer. Now, on the computer, we would find logs, we would find the master file table. It would provide us with a list of documents on that computer, events, etc., that we can corroborate. We could also look at the specific setup of the users, the access rights of those users, what they could and couldn't do. So that would make a huge difference in evaluating if anybody tampered with a document or if somebody created a document. We could also look at the templates for the document if that resides on that computer.
Okay. Mr. Smith.
Yes, so his mailbox, Mr. Khoza's mailbox, were you able to access it from the Eskom server?
No, it was actually seized by our investigators and then subsequently loaded onto our relativity database or e-discovery platform, and I could access it from there.
So it was seized from where? It was seized from where?
From Eskom?
From Eskom.
Yes,
Is that what you're dealing with?
in the chain of custody documentation.
Say again?
In the chain of custody documentation.
The chain of custody document. So page 360, you may tender quickly. 360 from paragraph 21 to 25. Is that what you're dealing with there about obtaining this Mr. Khoza's mailbox from Eskom ultimately to the Commission?
Yes, that is correct.
So you say in paragraph 21, I've located an alternative source of the 4MS Word documents in the email mailbox of Khoza, email mailbox on the Commission's e-discovery platform, Relativity. So you call it an alternative source. Well, explain to the chairperson.
Chair, the primary source was documents that we received relating to the submission of those 4 documents to the Commission, and also...
So that means the actual documents as provided by Mr. Khoza?
No. I didn't get those actual documents.
Yes.
I got paper copies of the documents.
So the Eskom workstream provided you with those documents?
The electronic copy, yes.
And you're saying that's the primary source?
Yes,
And then the alternative source is what you're referring to here?
correct.
So you went, in your exercise, you didn't just rely on the documents given to you, you took a step further.
Yes, I did, because in terms of electronic analysis, I needed electronic copies of those documents.
Yeah.
And as I said previously, Setlhomamaru, the other company, provided us with the MD5 hashes for those documents, so I could find the exact documents. So I knew I was working with the same documents.
So that's right. Then paragraph 23 explains further. The Khoza email mailbox was subsequently forensically extracted and loaded onto the Relativity e-discovery platform, and you refer to Annexure CL8 for the Relativity container path and unique evidence number recorded on Relativity as, and you give the whole number there. A copy of the chain of custody document for this unique evidence number, as well as its entry in the DFT Digital Evidence Register, is contained in Annexure CL9, here to and reflect the following. The evidence was collated on 22 February 2019 at 14:04 a.m. from one non-Dumiso Ubi. I've seen from the confirmatory affidavit that the
Maybe.
spelling should be corrected. Zibi, chairperson, Z-I-B-I,
Yes.
the Chief Information Officer, and also she said she was the acting Chief Information Officer. You saw that, Prof Louwrens? At the Eskom head office by another DFT, that is Digital Forensic Team member, Mr. Tsepo Muleko. The evidence was collected on a 1 terabyte Western Digital hard drive with the serial number, which you give there. See the second page of Annexure CL9. The evidence was signed into the DFT Commission's Digital Evidence Register as number 104. And you refer to the annexure. From there above, the COC, what does COC stands for?
Chain of custody document.
Chain of evidence.
What does it represent? What does it mean?
Chain of custody.
Oh, okay.
Yeah. That refers to the process undertaken to obtain the information forensically. Is that correct?
That is correct.
Yeah. So from there above, the COC or chain of custody seems to be intact and the evidence can be relied upon. And you attach the confirmatory affidavits. Okay. So you are confident that the Commission can rely on this information?
I'm confident that the chain of custody is intact and that the evidence is what it purports to be.
Is what it purports to. Thank you. So then, in the interest of time, maybe
But
you...
remember, Mr. Silliger,
Yes.
we've got to do it properly. So the interest of time mustn't compromise.
Yeah, thank you,
the-
Chair. Prof Louwrens, let's go back to page
Yeah.
358. Thank you, Chair. Paragraph 16, 1.6, you say, my examination of the metadata of the 4 MS Word documents attached to the email in question revealed that all 4 of the MS Word documents were created from the custom offers templates folder using the letterhead template Gen 2015.dotx template on a computer with a username Daniels M.
I'm sorry, where are you now, Mr. Silliger?
Paragraph, page 358, paragraph 16. Sorry. Yeah?
Okay, all right.
Yeah.
But also just remember to let him give the evidence.
Yes.
Yeah.
Prof Louwrens?
Well, at some stage we were on the metadata relating to the first document.
Yes.
I thought that might be quicker if he says, this is what the information that has been revealed, this is what it means
Yes.
about the first document, that pre-suspension letter. Maybe would it not be easier that way, Professor Louwrens?
Yes.
Because
agree.
as I understand it, you looked at that first document,
Yes.
pre-suspension letter, and that document that comes after it is the one that gives you, that tells you what you found.
That is correct.
Is that right?
Yes, that is
So,
correct.
so if we deal with that,
Yes.
he will tell us what he found, and then we take it from there.
Correct.
I think let's do it that way. Then we can do that with each one of the letters.
Yes. And Prof Louwrens, not because I thought that paragraph 16 was also important, but you will address it in the course.
You can do paragraph 16.
Yes. Just explain that, what you're saying there in paragraph 16 to the chairperson, just before we go
Yeah.
into...
Chairperson, it's important, the template that was used, that's like a format for that type of document, was stored in a computer which the username is Daniels M. So that is the closest connection I can make to a computer and a user. Obviously, I could not say if the user, Daniels M, is Suzanne Daniels.
Yes. So all you can say is your assessment or investigation of the document revealed this name as the user.
Correct.
On the face of it, and you must just tell me if I'm putting words into your mouth, on the face of it, it means, unless there is evidence to the contrary, one can read it to mean it's Daniels who created it, without saying it's Susan Daniels who, or you say whoever created it used this username. Or is that not correct?
To be correct, the template that was used
Yes.
came from a computer with that name. Does not mean there's no connection between the creator and the template username.
Okay. The template used
Yes,
to create the document had that username.
yes.
That's as far as you can go.
That is as far as I can go. So if I can explain it to you, if I send you a template,
Yeah.
that template would reflect, or the metadata would reflect that that template came from me.
Yeah.
If you then use that template to edit a document or create another document,
Yes.
it would reflect your name.
Yes. Okay, all right. But if you have sent me a template reflecting your name, can I alter it before I send it to somebody else, not to reflect your name, but to reflect Mr. Selega's name?
Only on the creator data or the last modified data. The other data, the template folder name is embedded, so that
I can't change
you
that.
can't change. Well, I can't say you can never change that.
Yes,
but it's
generally speaking.
generally speaking, you can't change that.
Yes. So if you have sent me a document using your particular template reflecting your name, generally speaking, if I forward this to somebody else, it would still show that it came from a template with your user.
Yes.
Okay. So, therefore, is it correct? And you must just tell me where, when I'm asking you something that falls outside of your expertise. Therefore, what you can't say is that it was Professor Louwrens who created the document.
That is correct.
That you can't say.
That I can't say.
But what you can say is that the template on which it was created, if that is technologically correct to put it like that, the template on which it was created had this particular username.
Okay, yeah, at a particular
Yes.
username.
And then it's up to somebody else to determine whose username was that.
That is correct.
That's something else.
Yes.
Okay. No, that's helpful. Yeah. Okay, Mr. Sullivan.
Thank you. Is the template, or did the template in this case, Prof Louwrens, remain the same?
It's impossible for me to say. I can only say that if you compare it to other documents that look the same, it does not have necessarily the same template name, then there is a small difference in that the address block below where the names of the directors were reflected. That was absent from the documents that I looked at.
What was absent?
The address block, if you look at the directors below, at the footer of the document,
Yes.
then normally a list of directors. And in the documents that I examined, those were absent. So that's all that I could maybe pick up. I couldn't tell if that was part of the original document or not, template or not.
Okay.
Chair, could we quickly go to Eskom Bundle 12, Chairperson, just
Yes.
to exhaust this point? Page 50. Prof Louwrens, I want to show you something, and you can explain this to the Chairperson. On Eskom Bundle 12, page 50.
I continue.
Yes. There is a document there, Prof Louwrens, which appears to be a template as a date, inquiries tell, say, dear, it's on Eskom logo, says, intention to suspend pending an investigation into allegations of misconduct. And the details are there. Eskom has received information in terms of which it is alleged that you committed various acts of misconduct. The allegations relate to the following. A space is left open there to fill in. In the light of the serious nature of the allegations of misconduct against you, I believe that your presence in the workplace will have a negative impact on the organization and your contractual duties. I've therefore taken a preliminary decision to suspend you from work with full pay pending the outcome of the disciplinary hearing. My preliminary decision to suspend you is informed by the following. Then a space is left open to complete as well. This appears to be a template. It goes on to page 51 with information to be filled where there are open spaces. Now, could you explain to the chairperson what were you talking about in regard to the information that is not, or that has been excluded from the pre-suspension letters that we are talking about?
If we refer to page 373,
Of Eskom Bundle 19.
you would see that, that there's an image of the pre-suspension dm.docx. And at the bottom of that page, the bottom left, is a black line, a vertical line. And right next to it, to the right, it's open space, nothing there. If you look at the Eskom 12, page 50, the document handed to you now, at the bottom of that page.
Okay, we are now comparing the document
Yes.
at Eskom Bundle 19, page 373, and the document at Eskom Bundle 12, page 50.
That is correct.
Okay.
You would see at the bottom of the page 50 document, there's Human Resources Division and the address, etc. And if you
That was
compare it to the other one,
excluded.
it's absent.
Yeah.
That's the only
Difference.
difference that I can see from the template.
Well, I guess that that's one set of information that is not there. But of course, the information, the content of the two documents at least the way it is structured doesn't seem to be the same. It may well be that the substance is the same. Mr. Selek, I don't know if you have had a chance to compare them in terms of substance.
Yes, Chair, in terms of particularly the rights of the employee to be legally represented, to make representations, the gist, well, the wording seems to be the same.
Well, the heading on the one at page 50 is intention to suspend pending an investigation into allegations of misconduct. The one at page 373, the heading is invitation to a pre-suspension meeting. Yeah, okay, all right.
Yes, the person you will see what comes before this particular document is an exchange between certain Eskom officials and the attorney's
The document at page 50.
Yes,
Yeah.
the document at page 50 is a correspondence of emails starting on page 43 in Eskom Bundle 12, where instructions have been given to Bowman Gilfillan, and they had requested to be provided with the suspension policies and the suspension process. And this is what they were provided with. Amongst others,
And what date is that?
it's from
16 March. I see at page 43,
correct, Chair.
emails dated 16 March.
Correct.
Yes.
And the suspension process. From Mr. Neo Tsolanku to Jerry Kapu.
I see that there is an email at page 44
Yes.
of Bundle 12
Yes.
from Elsie Pule to Philip Mashefo, dated 11 March 2015 at 09:27, which says, please urgently compile a step-by-step process to follow when suspending an F-ban.
Correct.
Yes.
And when you turn the page, 45, you see suspension process,
Yeah.
and they give the process there. Then on page 47 is what appears to be a template of an intention to effect the suspension pending investigation.
Yeah.
Then you have on page 48 a notice of suspension, which is also, on the face of it, appears to be a template.
Yeah.
And lastly, is that also what appears to be a template on page 50, which is an intention to suspend.
Yeah.
So these were exchanged within Eskom and then ultimately with the attorneys, Bowman Gilfillan.
Yeah. Okay. Okay. Let's continue.
Prof Louwrens, let's deal then with the metadata. When you performed the forensic assessment of the metadata, and you can take the chairperson to whichever relevant page you wish, particularly in respect of the first letter, and explain your findings in respect of your forensic investigation.
Thank you. If we turn to page 375,
Yes.
pre-suspension dm.docx. And I won't go through all of the metadata because all of them are not relevant to this case. So I'll
Yes.
deal with what is relevant in my opinion.
Yes, okay. And the document at 373 to which the metadata relate is a letter addressed to Dan Marokane, Group Executive, Group Capital. Yeah, okay.
That is correct, yes. So I've dealt with the MD5 hash previously, so that is just to verify that I've been working with the correct document and it was not changed by anybody.
And when you say it's the same document, that is now the same document that came from the mailbox of Posa dot whatever.
Yes.
Yes,
But
okay.
that and also the same document that Henry, the other forensics company, evaluated.
Okay.
Right. We've dealt with a template, and you can see that the path there, the template path is users, and the username in this instance is Daniels M /documents.
Just tell me where about on the page that is.
It's
Always says template.
template, yeah.
Yeah, okay, all right.
Okay. It's /users, and after that, normally the username is listed, the user that's registered on the computer. In this case, the name there is Daniels M /documents /custom office templates /letterhead template Jan 2015.x. Now the .x is different than the docx. .x means it's a template, so you can use it to create your own documents, but using a template as a framework. It's also important here, if you go down to application, it's about 1, 2, 3, 4 down.
Yes, I can see that.
The application is Microsoft Macintosh Word. That's important.
What does application mean?
That means that the software that created that document was Microsoft Macintosh Word, with Apple computer. It runs on the Apple computer, Macintosh Apple computer. So,
Okay, you'll have to just speak up a little bit more so that we hear this very important part of your evidence and it can be recorded properly.
so it means it was created on the Apple computer or Macintosh computer, and the application or the software that ran and created the document was Microsoft Macintosh Word. And why this is important is I've looked at Ms. Daniel's email box and documents that are found in her email box, and that was created by Microsoft Word and not Macintosh Word. Okay, so there is a difference.
Okay, that's the difference.
Yes.
So it's consistent with the username.
Yes, but what it means is the documents I found on Mrs. Daniels's
Mailbox.
mailbox
Yeah.
was not created on the same computer as this.
Oh, okay, okay. So her ones are not Microsoft Macintosh.
That's correct.
And her ones are what? Her one is what?
Microsoft Word for Windows.
Or not Microsoft Macintosh Word?
Yes.
Okay. So you say from that the conclusion is what?
Well, I can infer that it was not created on the same computer.
On the same computer?
Yeah.
Okay, okay, all right. Yes, continue.
So, sorry, Chair, Prof Louwrens, just by way of illustration of the two different computer products.
Yes.
I have an Apple computer on my right. And here on my left is a Dell computer. This one uses Microsoft Word.
Correct.
And the Apple computer uses
Macintosh.
Macintosh. So what you are saying to the chairperson is the creation of the document in terms of the metadata, or just before that, the software in the two are different,
Correct.
used by two different companies.
That is correct.
And that's why you're able to see that Macintosh Word, you can ascribe it to an Apple computer as opposed to a normal computer that uses the Word software.
That is correct.
So what you're saying to the chairperson is, according to this metadata, the application Microsoft Macintosh Word, which shows that the letter would have been created by an Apple computer, that would have been a different product altogether.
That is correct.
And what you find in the documents you find in Ms. Daniel's computer are from the MS Word and not the Apple computer.
That is correct.
You couldn't find any document, is that what you're saying to the chairperson, in her, is it her computer or her mailbox?
Her mailbox.
You couldn't find any document that is created on an Apple computer.
I couldn't say that. I didn't do an exhaustive search on that. I only looked for similar documents.
Now, if I have two or more computers, they could obviously be different. One could be Microsoft Macintosh Word, another one, another Word.
Yes.
You would have to examine mailboxes in all of them to exclude me completely from, or to exclude the possibility that the document was created in one of them.
Yes, I would
You would have to
I
examine
have to examine
the
both, yeah.
mailboxes in all of them. Okay, all right. But what you are able to say is, if you have examined the mailbox in relation to a particular computer, you are able to say, if there is no correlation between the words, then it's not, it wasn't created in the particular computer.
That is correct.
Okay. Okay. Mr. Siliga?
Yes. Thank you. Prof. Louwrens, you may carry on in your explanation of the metadata. So
The next point of interest is that it says titles of parts, basically the heading, which is the business unit or division. That's the bottom part of the document. It's just the title of that placeholder. And the company that this computer has been registered to is Eskom. Okay. Then,
What does that mean? That the company that's registered as Eskom, is that the company that is registered as the owner of the Microsoft?
of the software, yes.
Of the software.
Yes.
Okay. And I take it that from that you can safely infer or conclude, and you must just tell me if that's not justifiable, conclude that an Eskom computer was used, or Eskom software was used, whether it was an Eskom person or somebody from outside, but it was Eskom, or can you not say that in terms of technology?
It depends how the software was registered, but when you register your operating system, the company is entered there and it's part of the licensing agreement.
Yes.
So it's reasonable to assume that it's part of Eskom.
So it's reasonable to, is it reasonable to infer that the document was created using an Eskom computer? Or that's going too far?
That's going too far because this relates mostly to the template
Yeah.
and the software and so on. But I think we could infer that it definitely leans towards Eskom.
An Eskom, yeah. Yes.
Otherwise,
Because what are the chances that somebody...
You have to register your own
Yes.
computer if you're not part of Eskom as
Yes.
Eskom.
Yes. So we can say an Eskom computer was used to create it, in all probability. Is that fair to say?
That is fair.
Yeah, okay.
Yeah. Prof Louwrens, I see there's a little bit of hesitation there. Let me ask the question this way. You have said the template, I mean, the document used here is a template.
Yes.
They would have used a template to create a letter. Then that template is, or is it not, in an application that is owned by Eskom, a computer application owned by Eskom, or I can make that.
No, you can't make that distinction.
Okay.
What normally happens is that a company would create templates for use by its staff.
Yes.
And those templates would then be stored on the individual computers
Yes.
for use, and you could then edit those templates for your use.
Yeah.
So it's not to say that the person that edited the document was part of Eskom.
I see. Okay. I see what you're saying. So are you saying then, with my computer, which is not a MacBook, which is not an Apple computer, I could have stored this template and send it to my junior who has a Mac laptop, and she could then have used the template to create a letter, and that's why the application would then reflect her computer application and not mine.
Yes.
Is that what you explained?
That is correct.
Okay.
Okay, all right.
Yes.
Continue.
But in the field that's very important here is the creator field. And the value in that field was Suzanne Daniels.
I'm sorry, whereabouts are you on the document, on the page?
It's page 375 in the
Yes.
table. It's near the bottom, the creator.
Theater, yes,
Yes.
okay.
So that was what was recorded as the creator. As I said previously, it could have been picked up by the system from the user, but it could also have been edited. Very easy to edit. I can change the creator to whoever I want.
Okay. So you say that part, one can't rely a lot on its own,
On its own, you cannot rely on that.
but you can rely on it together with other information.
Yes. Yeah.
What if information about application. From that information, you said we can say that probably the template or the letter that was created on an Eskom computer. Is that right?
That is correct.
So then we can say, well, there is somebody called, or there was somebody called Susan Daniels at Eskom at the time, but you are saying that on its own is not terribly helpful, because somebody who is not Susan Daniels, if they want to falsely implicate Susan Daniels, can easily tamper with the system to make sure that it reflects her as the creator. Is that right?
That is correct, Chair.
Yeah. But I would imagine that somebody who does that would obviously be seeking to implicate somebody. If I interfere with the system so as to make sure that the creator of the document is Professor Louwrens in circumstances where it is not, and I know it, I would be seeking to falsely implicate Professor Louwrens in being the creator of the document. Is that right?
Yes, that would be the, if you do not understand how easy it is to change that field, you would be led to believe that that person created the document.
Yes. Could it be changed negligently?
No.
You've got to intend to change it.
You've got to intentionally change it.
Yes. And if I change it, I have to know what it was before I changed it, isn't it?
No, not necessarily.
I might not know.
It is displayed, so you would know in any case what it was. And then you, specifically on this field, what you would do is you would then add another creator, type in your own name or somebody else's name, and then you would remove the original creator.
So, but is the position that if we go to the true creator, the one who created the document, when he or she creates it, it's reflected that that's the person who created it?
Yes.
If somebody else, if it's sent, the document is sent to somebody, or somebody else comes and uses this same computer, they can change it. But when they change it, they know who the creator was immediately, was reflected as immediately before they changed it.
Yes.
There's no way they would not know.
That is correct, because you have to replace that name or that value.
Yes.
So you cannot just delete it.
Yes.
So you can't negligently just remove it.
You have got to have the intention to change it.
You have to add another one,
Yeah.
then remove the previous one.
Yes. So which therefore means that I can only change the original creator to effectively distort the position. Otherwise, I have no reason to change it. Is that correct?
Yeah, I would suppose that is the inference.
Yes, because why change who created it? Yeah. Okay, all right. Mr. Siller.
Yeah. Prof. Louwrens, so we have the template, and then we have the creation of the letters themselves. Could it be that the template would show, for instance, in this case, Ms. Daniels as the creator, not of the letter, but of the template?
If we have the template, if we have the computer, and we could access that template, then we could see what the creator is.
I see.
So, yeah, I think that is basically
Yes.
the only thing that we can say.
Okay. So you will need access to the template or the computer which has the template
Yes.
in order to determine who the author of the template is.
Yes,
In this case, this author is the author not of the template, but of the letter itself.
correct.
Is that what? Okay.
That is the creator that we're talking about. It's the
Yes.
creator of the letter,
Creator of the letter.
not necessarily of the template.
Correct.
Anything else on?
Yes, the next, just below the creator on the same table, last modified by, the value there is Salim Issa. So again, the last modified information is also easy to change, but you cannot do that directly. What you have
Just repeat that, please.
you-
It's easy to change,
change, but
but
you cannot do it directly. So you
directly.
can, yeah, directly. You have to go to another screen to actually change that value. So you go to the option screen and you do personalization of that document. And then you can change the name. Now, the name reflected in the personalization options is usually the name that is connected to the user. So that's where it picks up who the user is. So I can then change that user to somebody else. And when I save that and I apply it, the next time I save that document, the last modified would then be reflected as that new user that I've changed.
So what do you make of the fact that here the information or what you found is that it said last modified by Salim Essa? Well, what do you make of that?
Well, firstly, as with the previous creator, you cannot rely on that solely because it can be changed to any value. But if the user was called Salim Issa on a computer, it would pick it up as Salim Issa. But on its own, it's very easy to change. That's all I can say.
Yes. Now, this information last modified by Salim Essa, that's part of the information you get by examining the letter itself. Is that right?
Correct, the metadata on the letter.
The metadata on the letter.
Yes,
But the metadata doesn't tell you where or in what computer the modification happened.
no, it doesn't. Unfortunately, in this case, we only had the Word document itself
Yes.
to analyze.
Yes.
So I don't have that information.
Yes.
The only the relationship to the computer was or is the application used, the Microsoft Macintosh Word,
Yes.
which then was the last application used to modify the document.
So the modification, are you able to say, as you did with regard to application, are you able to say whether the modification, the last modification, was effected in a Microsoft Macintosh Word or the other?
Microsoft Macintosh Word.
It's the,
Microsoft Macintosh Word.
it was, the modification took place in that,
That
was
the
effected
last,
through that.
Yeah, saved.
So, does that mean that one can infer reasonably that the letter was probably created using an Eskom computer, and that the last modification was also effected using an Eskom computer, or not?
No, I would not say that. The fact that the software belongs to Eskom,
Yeah.
that
That's
seems to
given.
indicate Eskom, but it could have been edited on another computer,
Yes.
and could have been modified and sent. And so it does not mean it's necessarily an Eskom computer.
Yes. What would you need to look at in order to be able to be more precise on, for example, what computer was used, or is that something that you can't, computer as Eskom computer or non-Eskom computer? What would you need to be able to reach a conclusion on that, or is that something that's difficult to achieve?
I would say the best option would be to have access to the computers involved or seemingly involved.
Yes.
The analysis of those computers themselves.
Yes. Yes.
Without them, it's very circumstantial in the sense that it can be easily changed,
Yes.
and forensically I can't support
Yes.
anything more.
Yes. Okay. If you were to get the computer that, or computers that maybe Ms. Daniels, while she was at Eskom, was using, having access to those computers, would that help in one way or another, seeing that she's alleged to have been the creator here?
That would definitely help.
Yes.
I can't say if it would definitively give an answer.
Yeah, but it could help.
Could help, definitely, yes.
Yes. Okay. Has that been tried, Mr. Seleka? Are they?
Obtaining her computer, I don't know offhand,
Yes.
Chairperson, but I know they have imaged her hard drive,
Yeah.
something to that effect,
Mm.
even during her disciplinary hearing,
Yes.
which information has been made available to the Commission.
Yeah.
I'll follow up with the investigators to find out.
Mm. Do you need the actual computer, or as long as you have,
If I have a forensic image of that computer, that
then
would
you
be
should be
fine,
able?
yes.
Okay. So I think that should be pursued.
Yes.
Yeah. Yeah. And then I guess the same can be done in regard to Mr. Koza's computer.
Yes.
Yeah. Okay, all right.
Yes. Prof Louwrens, will it help to find out from Eskom whether during this time, 2015, March 2015, Eskom would have provided its employees with Apple computers?
Yes, it would.
It would
It
help.
would definitely help, yes.
Because as you say, the last modification was in an Apple computer.
That's correct.
Okay. Then you have, obviously, the last three columns is about the dates, or last three rows, it's about the dates when the letter was last printed, created, and modified.
That is correct.
So the date of creation of the letter, date of
Modification.
modification, date of printing. How certain can you be that those are the dates you give, or the dates that appear here, are definitely the dates?
Can only be certain to the extent that the computer's clock was
Yeah.
set correctly.
Yes.
So
So assuming it was set correctly, that should be,
that should be.
yeah. Well, that suggests to me that in the absence of any evidence that it was set incorrectly, that you would be able to say the probabilities are that the creation and the modification of the letter and the printing was on that day.
Yes, we
Is that-
could probably that if it's a corporate computer, the time and date settings are normally managed centrally.
Yeah,
So the user would not be able to do the
Change
settings on
it,
their
yes.
own, or change it on their own.
yes,
So if this was a corporate computer, chances are that the dates are correct.
yeah,
If it's not, then it can be anything.
yeah. Okay, so maybe you could explore all of those aspects, because then I think you would need to come back to say, I've done this part as well, and in the light of this part, this is what I'm able to say. Yeah. Okay, all right.
Prof Louwrens, I see that. Let me give you a chance to. I see that the times, that there's a discrepancy of some interest there in respect of the creation date and modification date time. The document, the dates are the same. The 10th of March 2015, all three. But I see the dates for creation and modification, I mean the times, I beg your pardon,
Yes,
are identical, 1639, 1639.
yes,
But the last print time is 1625,
correct.
which is before 1639,
Before it was created.
before it was created.
Yes.
So what do you say to that?
Yeah, that's an anomaly that is within the Windows file system. If you copy a file across from one volume to another, in other words, from one drive to another, it assumes a creation date of that time that you copied the file.
Yeah.
So the file then would have existed, and in this case, been available to print, but then the file was copied across to another drive, and then it assumed the new creation date, and that explains it.
Okay.
Yeah, okay.
I-
So you say it's an anomaly.
Yeah.
It's a anomaly, it's a peculiarity. I don't know how to explain that. It's not something that you would expect. You would expect that the creation date would stay the same, but it does not work that way with Microsoft Windows.
So there's nothing strange about it.
Nothing strange about it.
Okay.
Okay, I think, Mr. Slaker, we should stop here, because obviously there is a need for Professor Louwrens to come back,
Yes.
so that we can do the rest when he comes back.
Okay.
So let's stop here. How long do you think it might take you to be ready to come back after doing the the outstanding part that,
It's difficult to say, Chair, but if I've got access to the information, a couple of weeks maybe.
oh, is that so?
Yeah.
Okay, maybe 2 weeks,
No.
or maybe more than that.
Maybe more than that, because
Oh.
nothing
It takes
works,
time.
yeah, works out as it should.
Okay, no, that's all right. Okay, let us say, as soon as you are ready, you will let Mr. Slager know, and he will tell me, and then I guess you'll have to do a supplementary affidavit, I think, and then we can call you. Yes.
Thank you, Chair.
Okay, all right, but thank you very much. I'll excuse you now, but you will be coming back. Thank you very much.
Thank you, Chair.
Thank you.
Thank you, Mr. Senator.
I'm going to adjourn to enable the PRASA workstream to come in, and then I will continue with them. We adjourn. So I apologize for that. Let's continue. Yesterday's oath will continue to apply today, Mr. Montana. Okay, office.
Basically. Mr. Montana, I now want to deal with the allegations made by Ms. Martha Ngoyi in her affidavit of the 17th of February 2020. That affidavit appears in Bundle E1 as Exhibit SS7B, and it starts at page 277.
Through you, Chair. Sorry, Mr. Soni, I just decided to put one matter on record, emanating from yesterday, Chair.
Yes, yes.
I think that we dealt with the issues of the companies, and I kept on referring to one company as Mashonisa, that Mr. Molefe referred to as Mashonisa. The name of the company is Mazwe Financial Services.
Okay.
So I wanted to put that on record.
Yes.
The second thing, Chair, that I want to put on record, there was a report that was placed before me. I think the report was written by Mr. Jabulile Majola. And Chair, I did raise a concern with one of his conclusions. At that time, I didn't know, and on inquiry, I found that, well, this was, in fact, the junior chap who wrote that report. In fact, some of the people had indicated that the chap is not even capable of writing such a report. Now, it was placed before me yesterday, Chair. So I wanted to ask the Commission to, of course, confirm the position of this chap with PRASA, number one, so, and confirm whether that is their report. Because if it is, Chair, I'm considering exercising my rights in terms of Rule 3.4 to apply for cross-examination of I think Mr. Majola. I don't know him, but I think that Chair, from what I could gather, people have said, look, there's just no way you would have written this report, and so I want to confirm that formally and exercise my right, Chair. Thank you.
Yeah.
Sorry, Mr. Soni, I just wanted to deal with this.
Okay. I don't know how much you know about the author of that report, Mr. Soni, but if you don't, then the information can be obtained in terms of what his position is. Is he still at PRASA? What was his position at the time of writing the report? And any other relevant information about him.
We will make this inquiry.
Yes, I guess another issue would be, why would he have been identified as the person to conduct the investigation or to do the report? Is that because of the position he held, or why was it? And then that information can then be shared with Mr. Montana. And it may well be that because it's just a report, it may well be that consideration should be given to whether he should not be required to post to an affidavit and say whether that is his report, and say how it came about that he did that report or did the investigation, blah, 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 blah. Yeah. Thank you. Of course, with all of that in mind, Mr. Mr. Soni, there would also be the question of what the place and role of that report is in these proceedings,
Yes.
or whether it was attached simply because somebody who was deposing to an affidavit had to mention that there was some report that was put together, and this is the report, or whether it's going to be relied upon much for purpose of these proceedings. You know, when people do an affidavit, they can attach a lot of things, and not everything they attach is important for particular proceedings.
Yes.
But you could reflect on that.
I will. Sir.
Yeah, okay.
Mr. Montana, can we then go on with Ms. Ngoyi's allegations? I want to start at paragraph 8, which is on page 279. The page numbers are on the right-hand side in red. She says, I've been asked by the Commission to provide information on maladministration at PRASA, of which I am aware insofar as it relates to state capture. And then in paragraph 9, she says, in dealing with these matters, I consider it will be helpful to begin with the following observation. In my respectful view, maladministration and possibly corruption are quite widespread at PRASA. This was particularly while Mr. Montana was the CEO. Do you want to react to that?
Chair, I totally reject that. I think, in fact, she starts with that view from paragraph 6 of a affidavit. I reject that, Chair. I think in my testimony, I will show, in fact, that Mrs. Ngoye was herself at the heart of some of the issues that have been made here.
And then she says, she finishes paragraph 9 saying that there were certain entities and persons who were known to be close to you, and at paragraph 10 she says, among those are two individuals, Mr. Roy Mudley and Mr. Mackenzie Mabunda. You want to react to that?
Chair, I dealt with these matters yesterday, that entities were identified, linked to me, and those that they were doing work for them, who were even appointed regularly, were being championed. So again, Chair, I'll be consistent with that view.
Yes, I understand. It says the entities with which Mr. Mudley was alleged to be associated are Siangena Technologies, Strawberry Walks, Royal Security, and Prodigy. Can we accept that Mr. Mudley was associated with those four entities?
No, Chair. I do not want. I know that with Royal Security, yes, he was. But when I was still at PRASA, there was no relationship. I don't know of any relationship of Mr. Mudley with Strawberry Works. I don't know of any relationship, and I think I'll deal with Strawberry Works in much greater detail, Chair. And I read after I left PRASA that there was a close relationship between Siangena and Mr. Mudley that didn't happen when I was there. I wasn't aware of it at that point in time. We dealt with Mr. Mabunda, Siaya, and I think I explained that in great detail about our relationship with the Germans, Chair, and he's involved them with them. They don't make them my entities closer to Mr. Montana. They were appointed by PRASA and its board.
And of course, Prodigy we dealt with yesterday.
Yesterday, indeed, Chair. Yes.
All right. Can we look at paragraph 11? She says, these are individuals and entities which have benefited most handsomely from contracts that were dubiously awarded to them or implemented in a highly dubious manner?
One of the companies that benefited handsomely from PRASA was Worksman Satins. And Mrs. Ngoye deposed to an affidavit when she was aware of the facts. So you can see, Chair, this is the same kind of thing. So if you look at, again, Mr. Soni, to go back to paragraph 6 of her affidavit, if you read what she's saying there, consistent with what Mr. Molefe said, consistent with what Mr. Dintwe says, that these are people who project themselves as so clean, who want to point fingers at other people, but 4 fingers, in fact, pointing at them, Chair. It's so false. And I think, Chair, that we have to deal with the individual contracts. I think yesterday we dealt with Prodigy. So this broad brush is not going to help the Commission to actually get to the facts. I'm interested in the facts rather than the broad brush.
Yeah, we'll deal with them. Yeah.
And then she says most of these contracts are the subject of litigation. And I just mentioned those that have come before the Commission and have been dealt with or will be dealt with. One is Swifambo, we know. The other is Siangena, which we are going to deal with when we deal with the rest of Ms. Ngoyi's affidavit. Then there's Prodigy, which Mr. Dingizwaya dealt with. And then the CIA matters, which, as we know, it was in your absence that there is litigation between them, between PRASA and them. And I can perhaps just deal with one matter. You're aware that PRASA has refused to pay CIRDB, and you in fact testified at the liquidation hearings. All right. Can I then ask us to go to paragraph 14? It says that she's going to deal with the following matters. How she became, this is Ms. Ngoyi, how she became aware of the influence of Mr. Roy Moodley and her interactions with you as CEO, and the dispute between Strawberry Walks and CIA Group. We are not going to deal with the CIA Group here for different reasons. So these are the matters we will deal with.
Well, Chair, I would like the Chair to note the fact that in almost exactly the same formulation is what you find in Mr. Dingiswayo's affidavit. So you could see Mr. Molefe says traverse the same route. So it's very interesting, Chair. But again, I think a focus on facts will help us to deal with the matters properly.
Yes, no, that's fine.
Now, she says in paragraph 15, which I'm going to deal with in some detail. When I say detail, I just want us to establish the extent to which you dispute what she says. She says she first encountered Strawberry Works while she was the CEO of Intersight. She was, in fact, the CEO.
That's correct. That's correct, Chair.
And she says it came about as follows. First, on about the 23rd of July 2011, PRASA, through Intersight Assets Investment SOC Limited, which is a wholly owned subsidiary of PRASA, and Umjanji Media, concluded an advertising agreement following an invitation for companies to submit proposals for media broadcasting, advertising, and broadcasting services in respect of various assets held by PRASA. You accept that as a general?
Yes, sir.
And then she says the agreement had commenced on the 1st of June and was for a 5-year period unless terminated or renewed by the parties. Is that correct?
That's correct, Chair.
And she says, but on the 31st of August 2011, and I'm just going to point out, it's not in her affidavit, it's about 5 weeks after the contract was concluded, and with the consent of PROSA, Umjanji ceded portions of its rights under the advertising agreement to Strawberry Walks. And another entity called Siatembana Trading. Are you aware of that?
Chair was aware with them ceding to Strawberry Works, but I wasn't aware. I'm hearing about Siatembana trading for the first time.
But can we accept that that may have happened? Or?
It may be, Chair, but I wasn't aware personally.
No, I understand. Okay. Then at paragraph 15.3, she says, although Intersight and not PROSA was the party to the agreement during the contract period, we at Intersight received instructions from Mr. Montana on how to deal with the advertising portfolio, more specifically the Strawberry Works contract. But she's making 2 points there. Firstly, she says that the contract was between Umjanji and thereafter Strawberry Walks and Intersight. That I understand is correct.
It was between, the main contract was between PRASA and
Umjanji, and that was ceded to Strawberry
No,
Walks.
part of that.
Oh, sorry,
contract,
part of it, yes.
Part of that, the outdoor advertising part of that contract is what was ceded to Strawberry.
Yes. Now she says that they received instructions from you how to deal with the advertising portfolio and particularly Strawberry Walks.
Well, Chair, it was not. I never gave such an instruction. There was a draft that was submitted to me on how the relationship between Umjanji and Strawberry was going to be structured on our portfolio. So I'd written notes to say, no, it can't be dealt with in that way because we'll lose money as PRASA. And Chair, I want to make I think that after I present, I want to make a more detailed response to what Mrs. Ngoe is saying because the facts are being somehow twisted a bit to present a particular picture. But I think let's distinguish the facts first and then before I make my comment.
Well, I guess you will have a better feel, Mr. Soni, whether it's better that he should deal with that now or whether a little later. He's saying at some stage he would like to give a more substantive response. Yes. If it's more convenient for him to do that later, he will do that later. But I'm just saying, yes. Be aware that he...
No, I understand perfectly.
Yes.
It may be better to follow the affidavit.
Yeah.
Know the extent to which Mr. Montana disagrees with what, or disputes what Mr. Ngoyi is saying. Yeah. And then in regard to any inferences or any allegations that Ms. Ngoyi makes about improprieties, we can deal with that at the end of what it has been agreed are the basic facts on which there's common cause.
Okay, so where would that put us at the end when you are done with the affidavit or at some stage?
It will be at the end of paragraph 15.
Oh, okay, all right, that's fine.
She says that at paragraph 15.4, she was once summoned to a meeting with representatives of Strawberry Walks. Now, I take it and she's not making allegations about you on this. Are you aware of this meeting?
No, Chair.
Okay.
No, Chair.
And but she goes on in paragraph 15.4, I was given instructions by representatives of Strawberry Walks on how I ought to manage the advertising portfolio and how I was expected to take instructions from them. Are you aware of that?
No, I was not part of the meeting, Chair.
I was even told that they have the power to remove the portfolio from Intersight. I take it that you don't know about. Is that correct, Mr.
Chair, I was not part of the meeting.
Yes.
Just looking at it, I can see that this is, afterthought. It makes people draft things that, but I was not part of the meeting, so for the
Yes.
record,
Yes.
I wouldn't confirm or deny
Yes,
if I was not
yes.
part of the meeting.
Yes, I think, Mr. Tony, you can go on with the paragraphs that relate to what was discussed at meeting, but he doesn't know anything
No,
about
no, I
it, yeah.
understand.
But you
It
can-
is a necessary, because
Yeah.
it has a consequence.
No, that's
And,
fine.
and I can understand why Mr. Montana is saying this is an afterthought,
Yeah.
because there's a thread that's followed through thereafter.
Yeah, no, that's fine.
Then at paragraph 15.5, she says that she was told that there were instructions from Mr. Montana to remove instructions we had given to our legal representatives, Hogan Lovells, who were representing PASA in a litigation instituted by Prime Media challenging the advertising tender process. Now, I just want to deal with two things, Mr. Montana. Did you give instructions, or did you say to Strawberry Walks that you were going to remove Hogan Lovells as PASA's attorneys of record in the dispute
No, Chair,
with Prime
Chair,
Media?
Chair, that is not correct, but I think she's saying it is, she says it's still part, it's at the meeting.
Yes.
Which I was never party to. So I don't know who said that to her specifically. She doesn't mention, she just mentioned that she was told by a representative. She mentioned three representatives, Mr. Maraj, Mr. Ajvir, Mr. Selvin Moodley. Those are the three people who were part of the meeting. She doesn't say, so this person said this. She says representative. So it's so general, I don't even know. But I never, probably at this time, because she's describing the earlier period of the contract, I hadn't interacted with any of these players in the industry.
I hear you, Mr. Montana, but I just want us to, if you just bear with me for a moment or two to deal with another allegation and then come to the extent to which she says she communicated with you. So let's deal, I understand you say you didn't know about this, you were not part of the meeting. Then she says...
Sorry, Mr. Soni, I accept that, except that I'm not saying communicated with her. I'm saying I've never communicated with Strawberry at the time that she's describing.
Yes, no, I understand.
Yeah.
She says, I was told that Mr. Montana had instructed that I terminate the mandate of Hogan Lovells and appoint BBM attorneys. I take it you'd never told anybody from Strawberry Works that that should be done.
Yeah, I had a legal advisor who was dealing with this particular matter, other than our group corporate function. In my office, I had a legal advisor who would consider quite a number of things. And this was one of the issues, precisely because there was a major litigation issue on this matter. And probably I would have discussed with, but I can see that my legal advisor was not even part of the meeting that is mentioned. So the question still arises, who said all of those things to Mrs. Ngoye? And that is why I say, I don't know, I was not part of the meeting, but for me it sounds like a good afterthought, Chair, for an affidavit.
Right. Now, I just want to make this one point. She says that whether you said it or not, BBM attorneys were not on process panel of attorneys at the time. Is that correct?
Chair, I wouldn't know.
You wouldn't know.
I wouldn't know. In the same way that I also learned that the workmen were part of the PRASA panel. And when I checked at that time, they were not. So again, here's someone who picks up on this one and ignores onto this one. So, Chair, I don't deal with panels. I don't even, in my entire period, I never knew who was on the panel, who was not.
And she says at paragraph 15.6, I did indicate to Mr. Montana that the move would amount to wasteful expenditure and that I was not willing to account for that, and further that it was not possible to appoint a firm that was not on the panel. Now, is that correct or not?
You know, Mr. Soni, Chair, I did Bantu education as well. But sometimes the style of writing becomes very important so that you follow a sequence. This person is told by someone at the meeting. But in paragraph 15, 16, he says, you indicate to Mr. Montana, who was never part of this meeting.
Yeah, well, I noticed that, Mr. Montana, that she was telling us in a few paragraphs about the discussion at the meeting, and she didn't include you as one of the people who were in that meeting. And as you pointed out, she didn't say who among the people who were at the meeting told her that you had instructed that she should terminate the mandate of Hogan Louwrens and appoint BBM attorneys. And then in the next paragraph, 15.6, she says, she did indicate to you that the move would amount to wasteful expenditure. But she doesn't say when in relation to the meeting. But in the paragraph that comes after that, she is talking about what happened after the meeting. So I don't know whether it's just a question of the arrangement of paragraphs or whether it's something else.
Chair, I think if you look at the previous paragraph, the underlying message is that the firm was appointed outside of the panel. I think the question will come, who appoints people to the panel, how are they selected in all of that? I was not, that is why I was checking. My legal advisor, if she was part of the meeting, I would have said maybe she reflected discussions she had with me, but she was also not party to the meeting. And I wouldn't say what the other people said at the meeting specific. She doesn't also specify who said, and unless if the commission is provided with perhaps a record of that meeting, an actual recording of that meeting, so that we should know. So there are three people, and it's her, it's Mr. Hulele, was Mr. Hulele's, what was his role in the meeting? All of those things, Chair, that I think that they raise a lot of questions and answers, as it were. But, Chair, there was never, even subsequent to whatever meetings that were held, any discussion about wasteful expenditure. That is not consistent with my own narrative, which I will present after Mr. Sonia dealt with paragraph 15.
Okay.
Mr. Montana, can we just now, I just want to put a question directly to you. Did she speak to you about the fact that there was a suggestion that Hogan Louwrens be removed as process attorneys of record?
No, Chair. I think my legal advisor at the later stage did, when we're dealing with this what is it called, Prime Media's review application.
Okay. When you say your legal advisor did, you mean did talk to you? Did talk to her, Ms. Ngoye,
No, sorry, did talk to me, Chair.
about?
But about the, our team in respect of the litigation that were
Yes.
involved with Prime Media.
Yes.
And I think that's a separate matter to this, Chair. That is why
Oh.
I think, that is why I'm talking about afterthought. I can see
Yes.
issues are being, because somebody's in the organization, she's aware of what is happening, but she structures this thing in a way that supports. But that is why it doesn't speak to each other. And I'll deal with the issue, Chair, when I
Yes.
respond after this
No,
paragraph.
that's fine. But I think what you are saying is that there was a time when, in connection with the litigation relating to Primedia, when your legal advisor in your office spoke about changing the law firm representing.
That is correct, Chair.
Yes, that's what you are saying. yeah.
Exactly, Chair.
Okay, all right.
Well, not only spoke about it, but a decision was actually made and implemented to remove Hogan Lovells as Ross's attorneys of record. Is that correct?
Chair, I think so. I didn't know who was ultimately our team there, but I think that that decision was
Was made.
taken, and it enjoyed my full support, Chair. And I'll
Yes.
explain why.
Okay.
She says then at the end of paragraph 15.6, oh, sorry, your legal advisor is Ms. Molyneux Naidu, is that correct?
That's correct, Chair.
Now, Mr. Montana, just, and you must accept that we try to keep in our minds all the goings on. When you made application to the Secretary of the Commission to bring a delegation, one of the people whose names you mentioned in the letter to the Secretary was Ms. Molyneux Naidu?
That's correct, Chair.
Now, it's also said that the last group of attorneys who handled the matter for PROSA were Mirage attorneys. Are you aware of that?
No, Chair, I'm not aware.
Because she says then that they coincidentally were the attorneys of record of Strawberry Walks.
Attorneys of record on which matter?
In the Prime Media matter.
Is it?
Yes.
Chair, I'm not aware of that.
Okay. Can I just ask you as a general proposition, though, and I accept, and it would be improper for PROSA, where there's a dispute raised by Prime Media against PROSA and perhaps Strawberry Walks, to have the same attorney as Strawberry Walks.
No, Chair, it will be improper, unless if the parties
No,
agree and there's no conflict of interest there, but generally you want to separate these teams.
absolutely. All right. Paragraph 15.7, she says, after the meeting, Interside continued to manage the portfolio, but under very difficult circumstances, as threats were constantly received about the mandate being removed from Interside. Now, of course, that's not a matter that concerns you. I mean, she's not making an allegation that the threats came from you. She's saying the threats came from Strawberry Walks.
But Chair, I think you see, she makes that point, and then at the end it says, but we told Mr. Montana that he was required to provide a resolution from the board. No such reason was provided to Interside. I don't know where this discussion took place. Chair. And what I think is happening here, Chair, is that Ms. Ngoye may be, because she was a member of the executive, she may be aware of a matter taking place there. So she had conveniently brought these things. So for example, when she talks about the issue of a panel, or when we have a discussion about Prime Media, she then conflates that to support the view that she wants to advance. So I want for us to disaggregate those issues. If we deal with Strawberry, we deal with Strawberry. We deal with prime media, we do so that, Chair, we can separate fact from fiction. Because I think that's what is happening here. So all things are put in there, and here's a hero, a heroine. I told Mr. Montana. So the meeting takes place, I'm not part of it. I told Mr. Montana. And I think, Chair, the only matter that she discussed with me, by the way, was when Mrs. Hope Zinde, the late Hope Zinde, may so rest in peace, had gone to her office because they took some files from there. And she said that was not done properly by the two respective people. And she raised that with me. She wanted to inquire whether they were sent by me. I said no, and she'll explain. Again, the matter doesn't relate to this a completely different context. And I supported her because I said it can't be done that way. So again, Chair, it said because we're going to discuss a matter, and Mrs. Zinde is late, he can't even dispose, and I wouldn't want to discuss that matter of someone who's no longer there and able to defend herself. Not that I was going to speak ill of her, no, that's not what I'm saying. But I think that Ms. Ngoye is stretching at straws, trying to mix issues, and I want to separate them so that this commission has a clear picture. I mean, yes, she's trying to chase Mr. Moodley, but I think she's doing it in the wrong way, Chair.
All right. Let's just look at the part you've dealt with in paragraph 15.7, the second sentence. She says she told you that you were first required to provide a resolution of the board, but there was no resolution that was provided. Now, I'm going to ask you a direct question on this. Did she raise the issue of the threatened removal of the oversight of the contract from Intersight to PRASA with you?
No, Chair. Again, Chair, perhaps maybe, let me see, this paragraph 15 is long, and some of the issues that I need to deal with, I think I want to address them in that context. Chair, there was no such a discussion, there was no such a threat. I think that Ms. Ngoye is confusing the issue of us creating a new division, which is called PRASA Corporate Real Estate Solution, in short called PRASA CRES. Now, this is a new division that handles our properties. So because Intersight historically was what you call Intersight Property Management Services, we changed its role so that it became Intersight Asset Investment. And the new company that we created was then was then going to manage the property portfolio with everything that goes with it, including advertising on those properties. Okay. The reason why we took that decision had to do with it was a tax efficiency issue. Because what happened is that PRASA would pay Intersight a management fee, but because Intersight was a subsidiary, it was paying tax when its parent company was not paying tax. So we paid them 50 million to manage our properties, and it paid almost 18 to 20% of that money back to SARS. So we get a subsidy from government, and we pass the 50 million or 100 million, whatever amount, in the form of a management fee, and it goes back to government in the form of a tax. So we wanted to ensure that we maximize our revenues, our income. So that is why I'm saying Ms. Ngoye is confusing all these issues into one. To say, no, these things were happening, not because of the strategy of the business, but to support strawberry works. In fact, Chair, the facts will show evidence that I'll put before this commission, which is part of my thing. The notion that we manage the portfolio under very difficult circumstances is actually so false that Ms. Ngoye worked with Strawberry. The agreement to cede this contract to Strawberry from Umjanji or Proventage, the entity that won the contract, was signed by Mrs. Ngoye. So she says there in the closing paragraph, let me go back to to paragraph 15 point, I think this 15.2. The conclusion of that paragraph is that at the time I was already the CEO of Intersight. You see, that's where you find dishonesty. It doesn't say at the I signed this agreement to seat, signed between her and Strawberry as the CEO of Intersight. She says at the time I was already the CEO of Intersight. Now the chair, of course, you look at that, it doesn't tell you the story, the truth. Part of my annexures, I provide where she signed, and I've got chairs, volumes of emails, which shows, for example, the nature of the interaction between Intersight under Mrs. Ngoye's term, and more specifically, her right-hand person who was managing this at Intersight was a chair by the name of Mr. His name is Chauke. Mr. Chauke managed that. The emails that exchange is one where our subsidiary was actually working and forging this relationship because they had to do that. Now she comes 5 years later, the country has got a commission on state capture, corruption. She changes tune, she doesn't remember the facts. It's part of my annexures.
Sorry, Ms. Montana, and I don't want to. You might remember, I think on Friday, what we agreed on is when you have a version which may be contained in your affidavit, you will set it out here, so we don't have to be looking in different places. So I'm going to suggest, Chairperson, that Mr. Montana refers or sets out his version on these matters here as agreed on Friday. Otherwise, we're going to be all over the place. I don't want to stop him. I'm just saying that we're going to be back and forth on the same question.
I am not sure that I follow. What I do remember is that on Friday, one of the things I said was that he could tell me what is in his affidavit without referring to
Yes.
the paragraphs, just tell
Yes.
me
Yes.
what I will later find
Yes.
in the affidavit when his affidavit is sorted out. I'm not sure whether that's what you're talking about.
That's exactly what I'm saying,
Oh,
Chairperson.
okay,
It's
okay.
That instead of now saying it's contained in my affidavit, but not saying what is said in the affidavit, I've got no in fact, I want to hear what Mr. Montana's version is, so we all have it. We know what.
I think the reason he may be doing that, but he's here, he can say, maybe is that you remember in regard to the issues under 15,
Yes.
the arrangement that has been made is that when you are done with paragraph 15, he'll then get a chance to give a substantive response to what Ms. Ngoye has said under paragraph 15. I take it that's why he has not gone into details, because that's the arrangement.
That's correct, Chair, and that is why I even said it seems paragraph 15 is very long.
Yes.
Because I realized that Mr. Soni was then, he wanted the answers.
Yeah.
And I want to, and I think perhaps it's better, Chair, I suggest I make that input now.
Yeah.
And so that when Mr. Soni then takes me on, takes these issues in later paragraphs, he's fully aware of what my view is on this particular matter.
You're suggesting an amendment of the earlier arrangement.
Of the arrangement, that I do it now.
I've got no difficulty.
Is that
with
fine?
Yes. Yes.
Okay, all right. That's
Chair,
fine.
Chair, thanks very much. I think this matter is dealt with, of course, in detail in my affidavit. And I think it was done so, Chair, as a direct response to Rule 3.3. Because at that time I suggested to the commission, I'm going to do an omnibus, but
Yeah.
I'll specifically indicate where I'm dealing with a response to a particular allegation.
Yes.
Chair, PRASA did issue a tender on advertising. I think it was in February 2010. This tender was then later awarded to a company called Proventage Stroke Omjanji Consortium. If you look at the rate, one of the issues the public protector mentioned, Chair, is that you have this Proventage, which put a bid, and it doesn't, the public protector, we don't understand how Umjanji as a consortium comes in there. So I think that is a context that the matter is raised in the public protector report. Chair, what has happened is that Proventage, I think that there were 19 companies that then responded to the PRASA tender. PRASA then had a team that evaluated this, and the head of that team, Chair, was none other than Mr. Tiro Hulele. So Mr. Tiro Hulele led the team, and then they selected Proventage Stroke Umjanji Media as a company to do all of that. This tender, Chair, was mainly not only about advertising, but it was for media and broadcasting services. It was advertising, advertising, media, and as well as broadcasting. They were all under one tender. Now, what happened, Chair? Strawberry, I think, was one of the companies that put a bid. It lost. That's the first issue. It lost, Chair. It had nothing to do with Roy Moodley. Lost the bid, but what happened is that bidders, as they do, they then agree to themselves, among themselves rather. My strength is on this, your strength is on that. Let's work together on this. So after it's signed, PRASA has signed a contract with Proventage. Proventage came back to PRASA. Proventage Stroke Umjanji came to PRASA and said, we want to seed part of the work because we want to bring a company that will help us to manage because they've won the tender. The right on broadcasting, advertising, and media, they've got that right. They were awarded through a proper tender. So they said, no, we want to bring Strawberry. So that matter is elevated because when they want to bring a company in terms of, or to seed part of the contract or subcontract, our SCM policy provides that they must then formally apply to PRASA so that PRASA can satisfy itself that this company has the capacity to meet the obligations that are there. So, Chair, it was done, they applied. Then the agreement, the draft agreement was presented to us. That what Strawberry will do will then will work on the portfolio, pay Proventage, and then Proventage will pay to PRASA. I said, no, but if you allow that model, it means therefore that Proventage or Umjanji will take a cut before passing on the money. If they want to sit, then they must agree that Interside must have a direct relationship so that you don't have a middleman in that process. So when she said she spoke to me, Chair, it was not me actively going. As a CEO, I'm approached to say, here's an arrangement. And as a CEO who acts in the best, she says in affidavit, we must act in the best interest of the company. Yes, one instance where I act in the best interest to make sure that the revenue for outdoor advertising doesn't go anywhere else but comes to PRASA. Then I said, no, that's how we should structure the contract. So I think the commission chair should, of course, go to Proventage and ask them questions other than relying on the affidavit of one conflicted individual who signed and who wants today to dissociate herself. And ask Proventage and Strawberry, under what circumstances did you guys enter this agreement? Who initiated it? And all of those things, Chair. There are many letters that are part of my annexures, but I think that we'd agree that I should put those things now. Now, Chair, so that is the one part of it. So Proventage wins the tender and then later on decide that it will seat. It selects amongst the 19 people, that the 18 other companies, Chair, and the names I've listed all of them. Outdoor Network, I don't want to go into detail about these companies. Who chaired that, who recommends that this team should be managed is none other than Mr. Hiro Holele, who recommends that, no, we've gone through that, we've selected this company. Mr. Holele was also here, Chair, and he didn't remember this thing. He spoke about other things, but this fact, he doesn't tell the commission, Chair. In the same way that they withheld such information on the Sufambo matter. Now, Chair, why then did you go out on tender? And I know later on, when we discussed judgment, a month ago, or a few weeks ago, there was a judgment on this issue, on the outdoor issue. Prime Media succeeded, Chair, even though this thing comes 9 years later. The contract had expired. So that judgment is of an academic, it's academic in a sense that it doesn't have an impact because I think that time has passed, the contract has expired, PRASA is dealing with the matter in the manner that it does. The big issue, Chair, is that, and I elaborate onto this, what is the issue and why were we fighting over who represents us on this matter and why my legal advisor was that? Because we calculated the numbers, Chair. And the numbers were very clear. Prime Media, Continental, were the two leading companies, Chair, onto the PRASA network. They were making more money than PRASA itself, Chair. So as a CEO of PRASA, I'm required, and I never accused Ms. Ngoya that you are acting in the interest of this. But we're already seeing instances of collusion. Okay. And one of the major issues when I read the recent judgment on this Prime Media issue, I think that the court noted the fact that PRASA didn't oppose. And why did it take 9 years, Chair? You know what? Because it took 9 years, precisely because when the review application is on the table, the beneficiaries, the people who had occupied PRASA sites, continue to make more money on the sites than PRASA itself. So here we've got an instance of a state-owned enterprise that is being robbed of much needed revenue. I come as CEO, I say, no, these guys have been here for long, issue a tender, and let's get the benefit for that. If you look at the numbers, you'll be shocked, because both Prime Media and Continental, Prime Media occupied 29% of the sites that PRASA had. Continental was the second biggest one, but if you look at the amount they were paying, the smallest companies were paying us a higher amount. Okay? So they were paying us, some of the companies were paying us over 1,000 per site. Continental, the Prime Media were paying us even 200 per site. Yet they were on the property. So there was no way as CEO I would allow that situation to persist. And that is why we saw, for example, that our own people colluding with these companies that has made money on PRASA's things. And that is why when you look at some of the companies that were there, and you look at the role of my legal advisor, it is things like this because she's not performing the function. She's not managing cases for PRASA, but she was a CEO. Here's the direction that you take. Now, these people, Chair, will not come and testify that they go and talk about strawberries, okay? And when we look at the arrangement we had with strawberries, it was giving us more money than even the companies per site, Chair, when you look at each site, okay? But if PRASA goes to court, Chair, and say, we're not going to oppose the Prime Media's thing because they're fighting, it was awarded under Montana's term. Who drafted the affidavits and the statements? Mrs. Goye, Mr. Holele, the very same people who were at the heart of this thing, and the one washed their hands and said, no, it was an irregular contract awarded by under Mr. Montana's, during Mr. Montana's tenure, okay? They don't take accountability and say, this is our role, this is our role. What is my role as CEO? To act. The primary responsibility to act in the best interest of PRASA is with me, Chair. Now, when we created PRASA CRES, and Ms. Ngoye doesn't say that in her affidavit, our property, I think we changed the mandate. We changed the mandate a bit earlier, but we had to then separate these functions. And Mr. Ngoya then, of course, she brings suspicion. She said, all of these things, no, Chair. In fact, I had meetings between Prasa Crest and Interside, a subsidiary and a new division, because they were refusing to cooperate. There were instances where their collaboration was very important for us to achieve our goals, as it were. So it's got nothing to do with Mr. Moody. It has to do with the fact that we had a property portfolio, or rather an advertising portfolio, where Prasa was not making money, and two private companies were making money at the expense. Again, Mr. Soni, I want to bring to your attention that when you look at the documents, because I went and asked someone to go to bring me the entire file, and they brought the file. The figures are mentioned there, they're shocking, Chair.
Somebody from Prasa?
Yeah?
Did you ask somebody
No,
from
no,
Prasa?
no, someone, a lawyer. A lawyer said, say, can you get me that file? I want to look at that. Chair, the numbers there are shocking. We're looking at state capture. We say state-owned enterprises do not work. But here are big private companies who are having a feeding frenzy on the assets of these companies. And so that relationship, I took that on. And I didn't leave that chair. I think it was the right decision. When you look at the papers that have been filed, you look at some of the numbers, you'll actually see, Chair, that one of the papers mentioned the numbers and say Prime Media and Continental made 300 million rands out of the portfolio. Prasa only made just a mere 70 million. So the owner of the asset gets 70 million rands. Okay? The private companies who hadn't even invested in that asset, other than to put a board, they make almost 300 million rand. And I read in the judgment that particular fact was not even challenged in that testimony. I'm not saying that you must accept it here. I'm simply mentioning the fact that in my affidavit, I deal with this issue that
No, but Ms. Montana, we've agreed that whatever is in your affidavit, you'll present now.
Yeah, no, Chair, I'm not changing that, Chair.
Yes, he's not changing it.
I'm just simply
He's
saying
just
that
mentioning that
I'm not urging, I'm not saying
Yes.
that the commission should
Yes.
accept the, what is it called,
Yeah.
the court judgment. That's what I'm
Yeah.
referring to.
Yeah.
But I'm elaborating on the point as agreed.
I think maybe to clarify, because I think I can see what may be causing Mr. Soni concern. My understanding is that when you say in your affidavit, you are not saying that where you need to state what is in your affidavit, you are not stating it because we will see it. You are not saying, you just
I'm not saying
mentioned
that,
that.
Chair. I'm dealing with it now.
Yes,
I'm
yes,
dealing with it
yes,
now.
yeah, that's my
I'm
understanding.
dealing with it now, Chair, so that,
Yeah, I think Mr. Soni was concerned that we had one agreement earlier on, and if you deviate from it, it shouldn't just be left like that. But I think you have clarified. Yeah.
Chair, in my affidavit, Chair, and you remember I submitted this to the commission in October last year.
Well, I don't remember when, but
Yes,
last year.
it was in October, the 15th of October. This is almost 4 months before this court judgment. Chair, I want to indicate that I state in my affidavit that Prime Media and Continental together occupy 55% of the sites, advertising sites of Prasa. But they paid only 33% of rental income. Whilst companies that occupy 45% of sites paid almost 67% of the rental. So on average, these companies were paying 1,100 per site. But when you look at Prime Media and the other companies, they were paying 200 rands. So it's a huge gap. Now, and I make a calculation that if we were to increase...
Now, let me just to recollect the whole context about this. This is a transaction in terms of which a company that wants to advertise on property belonging to Prasa or its subsidiary,
Yes.
they put up whatever they want to advertise, it's on PRASA's property or the subsidiary,
Indeed, Chair.
and they, as long as that advert is there, they pay per month, is that right?
They pay per month, Chair.
Okay,
Yeah.
okay.
So Chair, you'll see that, and I say that if they were to pay the same amount, Strawberry, Prime Media and Continental would basically increase the revenue income for PRASA on the advertising portfolio by almost 122%, Chair. And these numbers correlate exactly with what is contained in that court, that litigation that was unfolding, Chair. But the court, I think, I'm not saying made the wrong decision, but the court, if PRASA doesn't oppose and say, PRASA, Mr. Holele is there, Ms. Ngoy is there, they allow Prime Media to go to court, and then PRASA ultimately doesn't file. And you see my legal advisor say, but this law firm that is representing us is giving us advice that we think is actually not protecting our own interests. And we think we should change, we should change that. So these are the factual issues. And I thought if someone was fair, like Ms. Goy, who says we must act in the best interest of the company, should raise all those issues. And if she feels that Strawberry, Chair, there's no evidence, I've listened to this thing, I've never had one evidence that says the relationship between Proventage, Stroke, Mjanji, and Strawberry. If someone says, well, that relationship was started by Montana, he's got interest in it, then we'll be having a discussion here. Nothing of that sort. What we have is insinuations. You know, I met Strawberry after the contract had been signed. At that time, we'd also now shifted the portfolio to PRASA Crest, not to PRASA Corporate. Chair, this is an ongoing thing. Ms. Ngoy was part of discussion on when I went to the board of PRASA in 2010. I said three things to the board, Chair, which is relevant to this matter. I said, we want, after the World Cup, we want to have a different organization. So we're going to do three things. One, of course, was to recapitalize the asset of this company. The second thing was, of course, to sustain rail operations. But the third one, Chair, was to ensure that we maximize income from the properties and the assets that we have, and that will then separate PRASA Intersite and create a new division. The other one will continue being a subsidiary to invest in assets. For example, the assets that include telecoms lines, so that we can rent that to telecommunication companies, and they pay a fee for that, to access that. But the property portfolio, our landlord will become a PRASA, a CRES. And that is why to this very day, I understand that portfolio is still being managed there, Chair. But at the heart of this thing, Chair, is the fact that we have people who project themselves as revolutionaries, anti-corruption busters, but in real terms are actually protecting the interest of established companies that are making money at the expense of PRASA. Strawberry, Chair, I don't even know who's the shareholder there. Chair. I've never, the only time that Mr. Modley would speak to me, he'll want to talk to me about security, either what work they're doing and all of those things. Not Strawberry, Chair. It's not one of the companies, and I think the commission is obliged, Chair, to go and obtain an affidavit from the CEO of Proventage, or what is the consortium that was called Mjanji House. How did you come to that? But the documents that I have, Chair, including the many emails, it shows that Mrs. Ngoy is making a major U-turn, creating a story when email evidence at that time suggested that she was working. That is why she can't even tell this commission that the agreement to seat and that Intersite to enter into an agreement with Strawberry as a result of that cessation that PRASA approved, and was signed by me as the CEO of Intersite. And she must then say, I didn't want to sign it. I was forced by Mr. Montana. Chair, at that time there was none. Now she's trying to think about it to bring it, and that is why she can conclude 15.2, Chair, by saying, at the time I was already the CEO of Intersite. She doesn't take it to its logical conclusion. At the time I was already the CEO of Intersite and accordingly signed the agreement between Interside and the thing. So it's about Lucky Montana. Lucky Montana was captured by Roy Moodley when the facts are very clear, Chair, and that's what I'm outlining. And she never, this affidavit, Chair, it's so disappointing because the entire affidavit doesn't, it talks about a law firm that is removed. But the most important issue is PRASA as a public entity getting value from the portfolio it owns. It's not even being dealt with. And I think that's where the problem is, Chair. So
Yes.
that is my, Mr.
Yes.
Soni, my submission. And this submission, Chair, you'll find it's when we deal with my affidavit later on,
It will
I
be
elaborate on the details in there.
Yeah, okay, all right. So that's what you had to say about paragraph 15 and its subparagraphs.
Indeed, Chair.
Yeah, okay. I see we're at 20 past
I
one.
didn't want to interrupt.
No, but it's fine. Maybe we should adjourn now. Let's adjourn now, and then we will resume at 20 past 2. We adjourn.
Montana, can we go on with what Ms. Ngoi says? And I think we were at paragraph 15.8 on page 284. It says that the threats of removing the portfolio, that's the Strawberry Walks portfolio, were carried out on the 20th of May by Ms. Naidu. This is, I think, Ms. Malini Naidu, your the legal assistant in your office. That's what it. Were you aware of that?
Chair, I think that there are two separate issues here. I earlier on spoke.
I'm sorry, let me first establish which paragraph are you on?
Oh,
Mr.
sorry, Chairperson. 15.8 on page 284.
Oh, okay, all right, yes. Yes, Mr. Montana. Your
Sorry,
mic.
your mic.
My apologies. After lunch. The legal advisor in my office didn't have such authority. She wouldn't have done anything of that sort. We had the general manager who was running what you call public affairs, and that's the late Hope Zinde. They didn't move the function. The movement of a function is a corporate function, is a structure of the company. They wouldn't do something like that. But there was, of course, the issue of the files in respect of Prime Media and Continental. And I think that's what I confirmed. She called me about and said, they came and they took some files here. And I said, look, that is not the right way to do it, where people pitch and pick up and took and remove files from a subsidiary. That's not how we should do it. We should do it. But the issue of the movement of a function from Intersite, it's got nothing to do with these files. It has to do with the strategy of the business about this portfolio and where we allocate some of these functions, of which Mrs. Ngoy was party to. So I think for me, she's conflating those two into one, to make the arguments that because she had taken a different position, and Chair, I think all evidence will show that at that particular point there was not even a dispute between Intersite under her leadership. I think a guy by the name, I said Chauke, Mr. Martin Chauke, she had written a lot of emails on her own behalf, on behalf of Intersite and the CEO, confirming how they're going to work with Strawberry. Now, Chair, you remember we are discussing advertising portfolio. What Janji seeded is not the whole portfolio. They've seeded the outdoor part of that advertising portfolio. And I think it's very important that we emphasize that particular issue. So she's talking about Mrs. Ngoya's affidavit. She's saying the advertising portfolio in total. But I don't know if taking out that entire advertising portfolio, that speaks to Strawberries, because that speaks to only one part of the entire function.
I just want to understand, Montana, if I understand your evidence correctly, you are drawing a distinction between removing the function relating to advertising from the files concerning Prime Media's complaint about the unlawfulness of the award. Is that the distinction?
Yeah, I'm saying that they are related, but they're not one and the same thing. Chair, so I think in her affidavit, she's basically taking a position. Let's say we talk about Prime Media, or we talk about Strawberry, or we talk about changing of these functions. She says the function was changed because it was aimed at benefiting Strawberry. And I'm saying, Chair, that is incorrect. Her starting point is that she's listing entities that were entities that belong to Mr. Moodley. Now, we haven't even been presented with evidence that who owns Strawberry, who are the owners of this company, that is this particular company. And I think those facts are lacking in here, Chair. So my view is that I'm saying some of the things she's saying may be true, but they belong to a different context. Yet she has conflated them to support her own argument. And I think that is why I'm making a distinction in those matters.
So you said that she called you in relation to
The
the
files.
removal of the files,
Yes.
and you told her that what they had done was wrong. That was not the way to.
The removal of the files.
The removal
would
of
not-
the files.
Indeed, Chair.
You were with her on that.
Exactly, Chair. Chair, I'm in agreement with that.
Yes, on
I
that.
still do, but
Yes.
she's now taking that. Okay, and you'll see that there's been ongoing conflict there that is confirmed in even emails. Fights that were there. Now, when people have fights among themselves as officials, someone then elevates her position and make it as the absolute truth that no, this is what is right. I'm acting in the best interest of the business. The others are not. And I'm saying, no, it can't be. We have to look at that. For example, I'm saying, if you look at the argument, Chair, and I analyze this affidavit, and I look and say, what was facing PRASA at that time? It was the fact that it's not about this legal firm that we said is being changed. The primary issue from someone in leadership position is that are we achieving our strategic goals or objectives that we've set ourselves as a business? Are we making money, maximizing the revenues from the advertising portfolio that we have? Throughout, in this affidavit, she's so preoccupied with something else. But the primary, she loses sight of the much bigger picture that we're trying to achieve. And I think that's part of why you had some of these files, and she's confirming that. So she's trying to put it in two contrasting lines. You are dealing with good people, and she's part of the good people, and you are dealing with bad people. And Montana was supporting Moodley, and they're supporting Strawberry. And I'm saying there's a false dichotomy that will not help the commission, because it doesn't provide the facts. So what I was trying to do before we went on to the break, I was trying to say, here are the facts of the matter. Did we go out on tender? Who tendered for that? Who won that tender? Who signed the letters? And those are the facts that I'm providing, Chair. And they don't support the line that she's taken.
So to the extent that Ms. Ngoye says that Ms. Naidu said she had been instructed, I think I saw something along those lines, but I don't think she said she was instructed by you.
She's in the last sentence of that paragraph.
She said she had strict instructions from Mr. Montana to remove the files. So you say you were in agreement with Ms. Ngoye that the files should not be removed either at all, or should not be removed in the manner in which it was
No, the
done.
manner is being done, Chair.
Yes.
And I think the fight had to do with how there was a dispute between the legal advisor and how Intersight was dealing with the issue of the litigation, the prime media litigation.
Yeah.
So I'm saying it's a specific issue.
Yes.
And within one organization, just imagine, Chair, as CEO, I agree that files are taken in that way. There's no proper handovers of things. We're going to have chaos. And you're creating a precedent where people can just go into, especially a subsidiary. Because a subsidiary, even though I was a chair, it required board resolution to make even decisions like those. So Chair, I agreed with her in that specific matter.
Yes.
But she's now saying we couldn't manage the portfolio because we manage it under very difficult conditions. And I'm saying that it is not correct, because if you look at the very documents, emails that are available, they actually show that you manage the portfolio and you interacted with the very strawberry as Intersite, not at the instigation of anyone. You signed the contract. The executive at Intersite was managing this portfolio has written where they are making arrangements on how they should implement the outdoor, what is it called, the outdoor advertising role that is there. Now, and I was going through those emails here to try and pick up whether there was any area of disagreement and dispute. There was none, Chair. Okay? And it is at a particular point that Ms. Ngoye take and that is why I kept on using the word afterthought. That she wanted to find out, how do we support this story that Moodley was running the show? Let's bring Strawberry. Now, does Roy Moodley control Umjanchi and Proventage who won the tender? And if that is true, the last point, if indeed he controls those, the people who made the award, now who made an accusation against Moodley that is controlling things? It is Mr. Hulele. Now, Mr. Hulele, if Proventage works with Strawberry after being awarded, was he aware of that? At what point did he become aware of that? Was he controlled by Mr. Moodley? So, Chair, we need to find out. It's either these people were given instruction by me to say, award this thing to Proventage, and Proventage then, after being awarded, I say, work with Strawberry. None of these people are saying that. But we are seeing a story that says Moodley was involved by association and not by evidence check.
Okay, now just to get clarification, you were against the way in which the files were sought to be removed, but did you give an instruction that they should be removed, but some people just did it the wrong way, or you had not given any instruction?
No, I haven't given any instruction in
About the
that
removal of
It
files?
didn't require any, what is it called, even an instruction from me.
Yes.
This was an interaction between our teams on this particular matter. And I don't know whether it was requested, the others removed, and the others decided to use their own strict approach in getting these particular files. But it
Okay.
had nothing to do with the function, and it didn't come from me, because the function issue about where and how this portfolio should be managed is far beyond Strawberries or that thing. And that is a decision that we made as a company, as an exco,
Yeah.
as well as a board chair.
Yes, okay. Mr. Soni?
As you please. So if, and I know you were not there, if Ms. Naidu said to Ms. Ngoyi that she had instructions from you to remove the files, and I know the distinction you draw, so let's not go back to that, Mr. Montana. She would not have been reflecting what you told her, Ms. Naidu. If she told Ms. Ngoyi you had instructed to remove the files, because you
Sure.
didn't instruct her.
Well, I would say Mrs. Ngoye would have a legitimate right to believe that that comes from me, Chair, particularly from a legal advisor, but she also would want to confirm that with me. And if she has got a different view, she'll do exactly that. But you'll see in this submission, Chair, that in a affidavit, the meeting where all these things are said is a meeting attended by three representatives of Strawberry, Mr. Holele, and Mrs. Ngoyi. The legal advisor
No,
is not even
Mr.
there.
Montana, I'm sorry to trouble you. This is a very separate meeting. This is now the 20th of May, 2013. The meeting
what
that we are
what page are we,
talking
sorry?
about is in 2011, 23rd of July, 2011.
It's page 284, paragraph 15.8.
I'm sorry, I'm in page 22.
I'll go to Ms. Ngoye's affidavit, which starts, these are red numbers only, there are no black numbers.
I do, Chair.
Starts at page 277. And then you go to page 284.
Then I lost it. Okay, I'm there. Sorry, Mr. Soni. I'm at the right page now.
Okay, so I'm saying to you that at 15.8, Ms. Ngoyi is talking about an interaction that happened on the 20th of May 2013. The meeting you are talking about was in July 2011. So my question now is directed to the last sentence in this paragraph, where Ms. Ngoyi said Ms. Naidu told her that she had instructions from you. I just want to confirm you didn't give those instructions to
No,
Ms.
not at all, Chair, no.
Okay. He then says at 15.9,
Before you move, Councillor, Chair, I just want to, as you can see in 15.8, the point I was making, that there are two issues here. There's a removal of the files, and there's a threat of the removal of the portfolio. And they are being used as one thing, and that's the point I was trying to clarify.
Yeah,
But I think we
okay.
can proceed.
we've
Mr.
got that.
Okay,
Councillor.
yeah.
All right, and at 15.9, she says, I immediately called Mr. Montana, but he did not respond. Then she called one of the independent directors. That doesn't concern us. Carries on, though, in the last sentence to say that Ms. Naidu removed the files. Now, when did you become aware that Ms. Naidu had removed the files?
Chair, you'd recall I said earlier on, and I'm surprised we're talking about, unless if we're talking about two different things. I spoke about Ms. Naidu, who was a legal advisor, and we're talking about the late Ms. Hope Zinde. Now, and I was told that Ms. Zinde, accompanied by Mrs. Naidu, removed the files. Who was Ms. Zinde was a general manager for our public affairs, for the public affairs portfolio. Now, throughout, Chair, the submission, there's not even any reference to Mrs. Zinde in the file. I don't know if it's out of respect for her, but I think that that very same day, she did call me and we spoke, and I said, I agree with you that that is not the way to go. So
Okay.
when
I'm asking a different, because Ms. Zinde is mentioned in paragraph 15.10. I just, you know, Mr. Montana, we're not going to make much progress if we don't answer questions. The question I asked is, when did you become aware that Ms. Naidu had removed the file?
But Chair, that is an issue of dispute. It's not a factual issue. I'm saying that the issue that was there, and that is why the people who removed the files, I'm saying that in my understanding, it's supposed to be Ms. Zinde, Hope Zinde, accompanied by Ms. Naidu.
Oh.
Okay? Now, that's a factual issue. And I'm saying that now I wasn't aware that she's mentioned in the next page, but there is mentioned in the context of a meeting, not in the context of the removal of files.
Let's take this bit by bit. To your knowledge, were the files ever removed?
Chair, I was told when she called me, yes, she confirmed that they came to remove the files.
So when she spoke to you, according to her, the files had already been
It
removed.
had already been removed, Chair. I think it was
Yes.
late. It was late in the evening when she called me He
Yes.
said, look, I was trying to reach you during the day. And I
Yes.
spoke to the lead independent director. This
Yes.
is what happened. So we spoke over the phone on that.
So it was on the same day?
It was on the
which-
same day, Chair,
same day.
but late.
Yeah, late, okay, all right.
When you say she called you, you're talking about Ms. Ngoyi.
Ms. Goye, sorry.
She says then, and I understand you drawing a distinction between who was present when the files were removed. I understand you to say you thought Ms. Hope was also there. Sorry, Ms. Zinde was there. Can I ask you this? Is it correct that, as Ms. Ngoyi says, a board meeting was scheduled for the following day? Is that correct?
The board meeting of Intersite.
That's what it seems like. And she says she confronted you with this issue at that board meeting.
No, Chair, I can't recall such a conversation, no.
All right. Okay, let's just look at what you agree with and disagree with. You can't recall if there was a meeting on the following day, that's the 21st of May.
Of the board, no. I assume this is a board of Intersite, Chair.
Yes,
I
but you
can't recall it.
Okay. And then she says,
Well, there seems to be a problem, Mr. Soni, because in paragraph 15.8, Ms. Ngoye says the
meeting
the
took place
removal of the
on
file
20th.
seems to have happened on the 20th of May. And then in paragraph 15.10, she says a board meeting was scheduled for the following day, but then she says 27 May 2013.
You'll recall,
Unless it's an
she
error.
corrected that when she gave it.
Yes, okay, so it's meant to be 21.
It's meant to be 21st.
Okay. No supplementary affidavit was filed? It's
She
always
corrected it
easier.
when she was here, Chairperson.
Yeah, no, I'm saying even if they correct it here, it's always convenient if a supplementary affidavit is done.
As you
So that in the bundle, one can say, oh, this was corrected. So that could still be done.
Yes.
That could still be done. Yeah, okay. So that's 21st. Okay, you may proceed.
She says, at this meeting, she asked you why you had not told her of the instruction to remove the file. Now, I know you say you didn't give that instruction to her. I just want to know whether you recall a conversation with Ms. Ngoyi about the removal of the file,
Chair,
except on the phone on the previous night.
No, Chair, only on that night when he spoke about it on the phone. Yeah. As in 15.9.
Yes.
Yeah.
So can I take it that as regards the rest of paragraph 15.10, you say either you can't recall or it didn't happen?
Well, Chair, I don't recall having a discussion for 15.10, 15.11 with Ms. Ngoyi, no.
All right.
And
She
the
said-
meeting she's referring to.
Yes. She says present at the meeting where Ms. Hope Zinde, Ms. Naidu, Mr. Holele, yourself and herself. I take it that those will all be the board members of Intersite.
Those would be?
The board members of Intersite, the people whom she names there.
No, they're not. She was the CEO of Intersite. The other people were at the PRASA corporate office.
Oh, I see. Okay. Oh.
So there were no board members at all involved in the discussion.
Well, she, in the first line of paragraph 15.10, talks about a board meeting. And now, of course, she doesn't specify whether that's PRASA board or Intersite, but one might assume that because at that time she was CEO of Intersite, that she talked about the board of Intersite.
And she was also not participating in the board of PRASA. So
Yes.
I'd agree, Chair,
Yes.
that
That must be intersite.
it should be intersite board, Chair.
Yes, okay. But would Ms. Zinde, Ms. Naidu, Mr. Holele normally have been entitled to attend board meetings of intersite?
No, only myself, because I was chairing the board at the time,
Yes, yeah.
and Ms.
Ms.
Ngoy.
Ngoye as CEO. If these were to attend, they would attend per invitation or something.
Sorry,
Chair.
Chairperson, can I am the cause, that's why I want to intervene.
Oh, okay.
You will see on the 5th line, this is something because I was trying to use a broad stroke to deal with 1510. She says, at the board meeting, she asked Mr. Montana to schedule a meeting with all the relevant parties so that the matter could be dealt with. He scheduled the meeting for a few days later. So these are two different,
Okay, these are two different
brought
meetings.
about that.
Okay,
Yes.
okay. No, that's fine. That's fine.
I'm sorry about
No,
that.
that's fine. Okay, you may proceed.
Now, can you recall a meeting, now we know it's not the board meeting, where the 6 of you discussed, or the 5 of you discussed? No.
Not at all, Chair, no.
Is when one looks at the contents of paragraph 15.10, is it possible that she is mistaken about the day when that discussion took place? Maybe it took place over the phone on the evening when she called you? Or-
Chair, I think so, Chair. I think, and that relates to 15.9.
Yes.
She did make a call to me. We
Yes,
spoke of that, I remember vividly.
yes, yes,
And she was unhappy about that.
yes.
The board meeting, of course, if she raised it at the board meeting of the 27th, of course, that should be reflected in the minutes. And the other meeting, I can't recall whether
Yes.
there was there was a meeting to discuss this
Yes.
specific issue, Chair, no.
Yes.
But so that's the point I'm making, Chair, that
Yeah.
some of these things are mixed and that's, I think that's a bit of a problem that I have also with the sequencing of what she's trying to portray. But I think let's deal with the affidavit as it is, Chair.
Because she does say in paragraph 15.10 that your response when she asked you why you had not told her about your instruction that the files should be removed from Intersite, she does say you responded by saying that you had nothing to do with that instruction and that you did not know what she was talking about. Now, that might not be exactly in the same way you put it, but it reflects, it's consistent with what you said. You know,
Indeed, Chair.
you say you had not given instruction, and that's what you told her. And then the only next thing is the question of the suggestion of a meeting where the people she lists there would be present. You say you don't recall.
No, I don't recall, Chair.
That
I'm
part.
not denying it, it's
Yeah,
possible,
yeah.
but I don't recall us having that meeting, Chair, no.
Can I just put to you, and I understand your answer, just put to you, and we know what your answer is, so that you've fully responded to everything that she has said. Because she says at the meeting, and it hadn't even gone on for 5 minutes, when you accused Mr. Holele and her of not following your instructions. And I'll just tell you what those instructions are. That, Mr. Holele then said, you had no authority to just remove the mandate of the advertising portfolio from Intersite without a proper board resolution, and thus he could not have carried out that instruction. Can you recall that?
Chair, no. But let me also say that this very point is made earlier in the earlier pages, where she said to me that she's asking for a board resolution and none was provided. Later on in the affidavit, Mr. Holele says that. Chair, I'm not sure if Mr. Holele would disobey a lawful instruction from me, unless if he stated it and said, look, I can't carry. But this prasa that is described here, Chair, it really shocks me that this Mr. Montana was so haphazard. He just arrived and said, remove a function. You know, a function, Chair, let's park the files a bit. A function is a big thing. It has to do with budget and a number of employees. Chair. You don't just come and say, move the stuff there. And I think Mrs. Ngoye, because of what she's trying to portray or present to the commission, she's dealing with the issue of files and elevating that to the issue about the function. And I think here, possibly what she was trying to do, she was trying to debate about how PRASA was dealing with the issue of the litigation of Prime Media. Okay. And so that's what my thinking is, and that is why I have a problem with all of those things there. Mr. Hulele never said that. I don't remember sitting in a meeting where he said that to me. And if you look at it, Mr. Hulele was still at PRASA, corporate office, not even at Intersite. And I think at this time, Chair, you'll see even the stuff that he was writing, that he wouldn't even express such a critical view. Chair, he became so vocal when I've taken disciplinary action against him, Chair, for other wrong things that he's done.
Yes, Sono.
As you please, Chair. Ms. Montana, I don't want us to enter this debate. I'm saying to you, when one reads 1511, the one thing that is quite clear, because I accepted the distinction you drew between removing the file relating to the case that Prime Media was going to bring and removing the advertising function in relation to Strawberry Walks. But if nothing else, 1511 makes that quite clear, because Ms. Ngoyi says that you said he told you you had no mandate to remove the advertising portfolio. So I accept the distinction you draw. I'm saying that they are not mistaken about it. They know the two. She says they removed the files on the one day, and now she is talking about the removal of the advertising portfolio as well. Chair, I don't want you to react to it. You've given your view.
Sure.
I'm just saying to you that based on this, that's not consistent with what's contained in Ms. Ngoyi's affidavit.
No, Chair, I know that, but I don't agree with 1511. That's the point that I made.
Yes, no, I understand.
Chair, let me say, Ms. Soni, you keep on confusing, I think probably even the Chair, because you then say, and I think you've corrected it now, advertising portfolio, and then earlier on you were talking about removing the Strawberry portfolio. So I think that sometimes when I respond, it's because of the thing. I don't think it happened consciously, but I think then when I respond, I just wanted you to note that point.
Okay.
I'm just again saying, I know you say that you can't recall that this happened or probably didn't happen. And she says that 1512, I was taken aback by this approach. I thought the purpose of the meeting was to deal with the alleged instruction which he had denied giving. And then she says, Ms. Naidu accused her of fraud and maladministration of the portfolio, and that she was preferring other media players over Strawberry Walks. Can you recall whether it happened at this meeting or some other meeting.
No,
Can you, no.
No, Chair. I think that the Chair, my advisor is my advisor. My advisor doesn't perform, or speaking as if Chair, at that time, an advisor doesn't perform executive function. She advises me. She interacts, pull out the right kind of information, and she wouldn't make, Chair, I don't know, but I think the relationship between Ms. Ngoy and Ms. Naidu was not it's clear it was not a good one. And you can see that how she's pumping this issue. But Chair, if she were to say that to an executive, I wouldn't, she'd rather say that to me to say, so and so, I think is guilty and I fear the fact. But if I sit with my executives and she says that, I'll never accept that, Chair, because it will be a disrespect, not of the executives themselves, but for me as a CEO, and I will not accept that. So I don't think, I think Ms. Naidu, the great professional, sharp legal mind, I think she did tremendous work for us. The fact that on this one within the business, there was this big confrontation, and that there was, and I think this was in fact, unfortunately, the timelines are not in this affidavit. It will even make us understand at what point we were. Okay, so yes, things were not smooth. There were those type of tensions and conflicts between people. But I think Ms. Ngoy had made a choice to put them to say, no, this will happen into suppose Strawberry is supposed to be linked to Mr. Moodley. That's the point she's making, Chair, even if the facts. So she's trying to harness the facts or the particular experience to support that view. And I don't share that view, Chair. That's what I'm saying to Mr. Sonny.
Right, but she says something quite significant thereafter at the top of page 286. She says, I told Mr. Montana to put me on suspension if he believed the allegations against me so that he could conduct an investigation unhindered.
Yeah, this didn't happen. It didn't happen. The only time that Mrs. Ngoye dared me to do that, you know that she left Prasa. When I tried to speak to her, and she showed signs of insubordination. She disrespected, in fact, the meeting, the fact that I was having people there. And I said, look, I hear your concerns, and this related to Mr. Dingiswayo. So if she had dared me in that way, if there was such a meeting, Chair, I know that I would have acted immediately without any hesitation. Didn't happen, Chair. So I think that for me, it's in line. I know that it's in line with the narrative she wants to present. I'm saying it's not the truth, and the commission will evaluate whether what she's saying and what I'm saying, once my affidavit is presented, Chair, what actually could be the truth in this matter.
Then she goes on in relation to that proposition to you that she be put on suspension. She says, however, instead of taking steps against Mr. Montana, outraged as he was, instructed the manager who was responsible for the advertising portfolio at Interside and had recently been moved to report to Ms. Zinde, Mr. Martin Chauke, be suspended with immediate effect. Now, she's dealing with a lot of things here. She's talking about different people. But the essence, as I understand it, is she is saying, you then instructed that Mr. Chauke be suspended, having regard to the call on you to suspend her pending an investigation into the allegations Ms. Naidu made.
Chair, it's unfortunate that Ms. Zende is not with us, because I know the reason why she wanted to take action against Mr. Chauke, and I think at that time, if I remember, she had reported that to the ER department at PASA on why there should be such an action. Again, a separate activity, which is linked to support the narrative that she wants to make. I think that, Chair, I've never made such an instruction. Mr. Martin Chauke, when I was at PRASA, I think he was a senior manager, Chair. He was not even a general manager. I only dealt with group executives and general managers. So I don't think, Chair, it was right to present it in that way. And Chair, also, I do not like with the way in which Ms. Zinde comes to the picture. Remember, before I saw this paragraphs, I spoke to her in a different role. And now she comes out there and she's acting under my instructions, and I was outraged. That's what she's saying. Outraged as you are. It takes time for me to be provoked. And surely that I don't know what Mrs. Ngoy is describing here, Chair.
I think, Mr. Soni, to the extent that this may not have been done before, it may be necessary to obtain the affidavits of Mr. Holele and Ms. Naidu to give their version about what happened at this meeting.
Yes.
Obviously, if Ms. Zinde is late,
Yes.
there's nothing we can do about it. But I'm sure Ms. Naidu can be found somewhere, and Mr. Holele is there. We don't have an affidavit from Mr. Holele about this.
Mr. Holele, you'll recall, Chairperson, he was the first witness in PASA. He made a general statement, besides dealing with what Mr. Mudley told him. He made a general statement that he had read the affidavit of Mr. Ngoyi and Mr. Ndizwayo, and he confirmed the correctness of those allegations insofar as they concerned him. But obviously this is now a different issue. It's not just simply a confirmatory affidavit. We would have to give details about it.
Yeah. And then attempts can be made to find Ms. Naidu as well.
Yes, well, Mr. Montana, I'm sure will help us.
That's assuming they are still in touch.
Well, you recall, Chairperson, I asked earlier if he had asked if Ms. Naidu could attend these proceedings.
Oh, okay. I didn't know that.
Yes, that is the Ms. Naidu
Context or
Yes, Chair, I'd wanted to invite her, especially because the matters.
that relates.
I'd asked a number of people, some of them former PRASA employees who remember the details, and I consult with them on this issue. So I'll speak to her, Chair.
Yes, no, that's fine. And then you can give her number to Mr. Sonia or somebody, or Ms. Rangata. Okay. All right, let's continue.
Right. Then she goes on to say, this is Ms. Ngoyi, Mr. Montana then instructed me to call Mr. Chauke and tell him to bring back all PRASA property that evening, as he was suspended with immediate effect, which is obviously, now this is the 27th because it's a few days later.
So can I see the copy of the letter?
There are no letters, Mr. Whatever we have, Mr. Montana, we've presented.
And I'm saying Mr. Chauke is still there, Chair. He received a letter of suspension. Can we have that letter? Was it a letter signed by me? Was it who signed the letter?
Can I ask you, and I don't mean to be disrespectful, Mr. Montana, this is an investigation into a whole number of allegations. If you want to deny it, and we will talk to Mr. Chauke, but we can't keep saying, can I see this and can I see that? It's not going to be progress.
No, Mr. Sonny, no.
Chair, I won't pursue it. I just want to say.
Hang on, Mr. Mr. Montana is not a lawyer. He has denied some of the things that are being said by Ms. Ngoye. I suspect that if Ms. Ngoye says Mr. Chauke was suspended, in the light of the fact that he's denying some of the things, if he wishes to see the letter of suspension, I think that that's fine. But if we don't have it, we don't have it. So if we can find it, that's fine. But if we can't find it, then that's what we can just tell him. We don't have it, or we can't find it. And then it may well be that there's something that he wants to look at there, which might help his version, or it may well be that there is nothing. But let's see if we can find the letter from Mr. Chauke.
The reason I'm asking for it is not to argue. I'm saying I just want to remind himself, because here in the, we're dealing with a factual issue, which is very important, Chair. Because we are told that two people handed the letter to Mr. Chauke. But the letter, so that is why I'm saying it will help me to make even a recollection and what was the context. Was the letter signed by me, signed by somebody else? We are told it's been handed over, but we are not told who signed the letter, who suspended Mr. Chauke, and what was the specific transgression that he was suspended. So I just wanted to do that to assist the Commission Chair, not to argue against what Ms. Ngoye is saying. It's possible, but I don't want to discount that, Chair. Hence I was asking for the letter. But I will accept it, Chair, if the Commission doesn't have it, but noting that Mr. Chauke is there and is deposed to an affidavit. I think on the matter of Mr. Moodley. He probably has a copy of that letter and he could share it with the Commission Chair.
Okay, all right. I think, Mr. Son, let's just, somebody, maybe the investigator can check, and if it's there, it's there. If it's not there, it's not there.
Listen, I was not being short with Mr. Montana. I'm trying to get a version out of him, and I said, if you didn't do it, tell us, then we know that we need to go and look. But it was not intended as anything else but to extract from Mr. Montana an answer to the allegation that you instructed that he did. That's not proof.
Yes.
But we just want a version on record so we can say that
Yes.
that's the allegation, that's the response.
Okay, maybe it would have been more helpful if Mr. Montana had started by saying that's not true, and then he could inquire about the letter.
I understand.
Okay, let's just
but
keep on
we're
trying.
at that point, Chairman.
Yes.
We know we must try and get the letter to
Yes.
the extent that it's
No, that's fine.
I accept.
That's fine.
But, Mr. Montana, and please, I'm not being disrespectful of you. As I say, if you can't remember, or you say, look, I don't recall it, but if I'm shown the letter, I don't mind. But at least we know what that's your reaction.
Chair, I think that's what I was trying to say.
Okay.
Yeah. Thank you.
And then but can I ask you this just as a general question? Do you know if whether you suspended him or not? Do you know if Mr. Chauke was suspended?
Chair, I do not know. I do not know. That is why I need to go and verify exactly that information.
Because it said that he was suspended with full pay for 2 years, but he was brought back, that's at 15.15. But obviously, if you don't know that he was suspended, you can't meaningfully react to that at 15.15.
I see that, Chair, I see that, yeah.
All right, now,
Would you have known, would you know whether he was charged or not charged?
So I don't have the details.
You don't know, yeah, okay.
The only thing, Chair, that the 15.15, the first part, I wouldn't, but I take note of what is said in the following lines. He was one of the employees who was brought back to the office after the board of Mr. Popo Molefe instructed that all suspensions of employees be investigated. I also record that the Auditor General noted that several past employees were on suspension for very long periods without any charges and that this could constitute wasteful expenditure.
yes. Now, at 15.17, she makes the
Mr.
point.
Soni, sorry, Mr. Soni. And, Chair, just to, why I read that part is because at that time, Ms. Ngoye herself was suspended. The paragraph that she's describing on how she came back. And I think it was Norton Rose or one of those law firms which came back. The things were, I think, after I left Prasa. But I've seen where a lot of employees who were suspended, not in one center, in divisions everywhere. Ms. Ngoye, recall, she was suspended. Amongst the charges she was facing was the issue of the regular payment or approval of a variation of 58 million to SA Fence and Gate. She was suspended by me, Chair, for a number of things, including that. And that immediately after I've left, she was one of those people that were brought back through the same process. Chair. And a lot of people were not, didn't take accountability as a result of that. So I'm reading it, Chair, because it then tells you that if the board, I'm not sure if the board of trust had taken specific decision and say that specific person, but people were brought back, and some of them are issues that I'm pursuing with the commission that, in fact, these people should be held accountable for some of the actions.
Right. In regard to 15.7, you've made this point before, Mr. Montana, that there is no evidence that you have seen linking Mr. Moodley to Robbery War. That's 15.17.
Chair, with what we've discussed, I agree with you, Mr. Singh.
Yes.
With what we've discussed about these meetings and everything, it actually tells us about the ongoing battles within a public entity at a particular point. I thought that would be shown, Isandla Semfen, the hand of the one that is manipulating this. And there's no evidence that does that, and then a conclusion is drawn.
Remember to translate that, Mr.
Yes,
Motor.
Hand, what is it called?
I'm not going to help you.
If
Mr.
there's
Soni must hear what you are
manipulating
doing.
hand, we always say it's a monkey's hand, Chair. It's a saying that you can't translate. Sandra Semfen changing this. We haven't, Chair, we've dealt with fights between Prasa people. Okay? We've dealt with ups and downs. And then at the end, with a stroke of a pen, this shows how Mr. Moodley, surely we can do better than this, Chair, in terms of evidence. I thought, Chair, because the meeting where Mr. Moodley was said, and I've seen the affidavits, where Mr. Moodley was said to have interacted with Prasa, was 2017 after I left. I left in 2015. He's interacting with Prasa in 2017. So maybe became powerful, Chair, in 2017 or after I've left Prasa. And when him and the chairman of the board were playing golf together or arranging golf trips all over the world.
Mr. Sonny, did you skip 15.16 deliberately, or was it oversight, or I didn't hear you deal with it?
Chairperson, in my notes, I didn't think it was relevant, but
Okay,
perhaps
maybe
I
let
should-
me
I
clarify,
should-
or maybe let me
yes.
clarify. You see at paragraph 15.16, Mr. Montana, Ms. Ngoye says the effect of moving the advertising portfolio from Intersite to PRASA is that the management of the portfolio was not in the interest of PRASA, and PRASA benefited little, if anything, from the portfolio. Now, I know that you have said a lot about the distinction between removing the portfolio and removing the file. It is clear from this paragraph that Ms. Ngoye's version is that the portfolio was moved. Now, I want to ask the question whether, while you were there as Group CEO, was the portfolio ever moved from Intersite to PRASA?
Chair, indeed, the
It was
portfolio was moved.
Okay,
At the point, I think I admitted to that at the beginning,
okay,
but
no,
I
missed
said
it.
the reasons for moving the portfolio
Yeah.
has nothing to do with the fight she's
Yes,
fighting.
you
here.
said it
That's
was
the point
about,
I'm making, Chair.
it was about the strategic objectives of the company and
Indeed, Chair.
whether the company was making money out of this
So
portfolio.
in fact, when I was there, I think the portfolio was moved probably twice. But it
Yes,
had nothing to do with Roy Mutley, as she wants to
Yes.
complete in
Yes.
1517.
in terms of timing, is it possible that the two of you are talking about the moving of the portfolio on the same occasion? You just differ on the reason why it was moved. Do you think that might be the position?
No, Chair, I think there are two things from where I sit. The first one is that we both know the objective reasons why the portfolio moved and why there were changes in all of it. I think that's, and this was not a secret if you look at PRASA's corporate plan in particular for the years that we're discussing here. You'll see that there's a lot of discussion about that and what we should get from the advertising portfolio more specific. Now, there's also a separate issue that there were fights, and these fights didn't start at the beginning. Just as I said, that the emails show that it didn't wake up at the beginning and there was this big fight. Excuse me, this big fight about advertising, or rather, let me put this big fight relates to how we deal with the litigation of Prime Media and which law firm should represent PRAS and all of those things. Now, 15.6, Chair, I said earlier on that-
15.16 or
15.16, the one that you just said,
Yeah.
did we jump in, Chair? I do not share the view, Chair. I think that what is the interest of PRAS in that, except to maximize revenues from its own portfolio, and it didn't get any of that at that time. And that is why I spoke about even the judgment that I shared, and shared some of the numbers that I dealt with. So, Chair, I think what I think could be happening is that when Ms. Ngoye was recollecting some of those things, she may then have confused some of the dates and some of the processes. But I think for me, the biggest thing that she's trying to do is in 15.17. So she's trying to harness these things towards supporting the point she's made, because that's you remember when we started, Chair, on the other side, she mentioned companies that were favored, and we got into strawberry. And then and she says, I submit that what I've narrated denotes just how powerful Mr. Roy Mutley was at PRASA. And I'm saying, but Chair,
Well, you have
it's
addressed
under self-fair, and we didn't see at all in this thing.
Now, at some stage, when you were talking about the issue of moving the portfolio, I understood you to say something along the lines that Ms. Ngoye would have been part of a discussion of such a matter.
Indeed, Chair.
When the decision was taken to move the portfolio, as you say, was she part of that decision?
Chair, Ms. Ngoye was part of all these meetings. These were discussions at our EXCO. They were not secret meetings. And she had my support, Chair. And that is why when her name came up to be appointed as CEO of Intersight. Firstly, when she was appointed, the CEO of Intersight at that time spoke to me and said, I think that when we transferred some of our businesses, Metro Rail, Sociolosa, from Transnet to Prasa, the person on the other side was negotiating with us to understand the portfolio. I'm not referring to the portfolio, but the assets would be Ms. Ngoye. And I think that we should headhunt her. I supported that. When he left, or he went to become a CEO of a different division within Prasa, and they said, we think that we need to bring a woman into that leadership position, and Ms. Ngoye was nominated. I supported her, Chair. The fight started when Ms. Ngoye was moved from Intersight, and she came to Prasa. And let me say one other thing, Chair, by the way. When there were these changes, one of the biggest fights was not about this, was about the creation of Prasa Crest. I had to sit with the team from Intersight and Prasa Crest, who didn't want to cooperate, Chair, to implement the decision that was now not even a decision of the CEO, but was now a Prasa board, that we are now going to have a division managing our property portfolio and advertising, and we're going to have an Intersight focusing on asset investment. So you can see, for me, I won't write and say it shows that Ms. Ngoye was bad. Because CEOs and their managers fight for their businesses within a group. I was a group CEO. Sometimes I have to manage, and sometimes this one win over this one, sometimes vice versa. I had to play a balancing role. But what she's trying to do here, Chair, she's, it's one thing when she says, I didn't agree with Mr. Montana's strategy and all of those things. She is trying to say, this was the leaky of Mr. Moodley. But the evidence she provides, or the events, her narrative doesn't even support. I haven't seen the hand of Mr. Moodley. I'm still waiting for it, Chair. Maybe as we proceed, I'll come across it, Chair.
So should there be minutes of an Eskom meeting where these decisions were taken, which would show that she was present? You would expect such meetings to exist at
No, Chair,
Prasa?
they exist. In fact, one of the things we did, I think I took the entire Intersight and Prasa Crest teams to, I think we went outside because of the fights. I said, guys, maybe we need to think, the breath of fresh air, let's go and sit. We went to sit together, and we crafted what became known as the Prasa Real Estate Strategy, which teams from both sides drafted, presented, and I was happy with it. We took it to the board and everything. So both minutes and other things will support all of that, Chair.
Yes, but in particular, because you said it would have been EXCO which made this decision.
EXCO discussion, Chair, we would have all of that.
There should
and
be
Mrs.
minutes.
Ngoye would have participated. I think if we call for those years, for the minutes, they'll show that these were EXCO discussions, especially when we're preparing and drafting the Prasa corporate plans.
Okay. Mr. Soni?
We will try and see if we can secure it. The part of the problem, of course, and I'm not saying we won't try.
Yes.
That the lockdown has created a serious communication issue.
Yeah.
Because many of their senior employees still work from home. In respect of matters that we've been trying to get, it's been a bit difficult. But in respect of our access to Prasa itself, until Mr. Dingizwayo was suspended, He was one of the contacts, and then Ngoyi is now under suspension. I'm not raising difficulties. I'm only explaining that we may face challenges.
Yes, no, that's fine. I guess that in their absence, you just have to either approach the company secretary or the CEO or the chairperson of the board. Yeah, okay, all right.
Mr. Montana, I just want to understand, just finally on the issue of the removal of either the files or the portfolio, the advertising portfolio from inside. Now, there were differences between you and Ms. Ngoyi. Would that be correct? Or am I missing something, that she's inventing those differences now in this affidavit?
Well, Chair, with what you submitted, yes. I'm not sure if when you translate that to a broad strategic area, I'm not sure if we've had. And we've had, I think on the bigger issues, we've debated issues, people were given their views. But on the specific issues raised, I think clearly, Chair, we stand on opposite sides.
But that's always been the case from at least 2013, when she complained about the removal of the files. And you say she did phone you. So at least from that time, you knew that she held a different view, not necessarily with regard to the movement of the advertising portfolio, but in relation to the movement of the prime media or the file relating to the prime media dispute.
Yes, Chair. Chair, you know, for me, removal of a file, if somebody say I wasn't happy, Martha said she wasn't, Ms. Ngoyi rather, said she wasn't happy with the way this thing was done. Now, a CEO managing a big asset, will I get angry with that and say we've got a different of views, Chair, about files? So I'm saying, Mr. Soni, that, and you will see till 2015, notwithstanding all the to and fro's and the files, you'll see, in fact, I think she says it in the next page, about the nature of our relationship that was there. That is why I view many of the things that she writes as manufactured lies, Chair, more than anything else. And I say she even take an event and then she subjected to 15.17. That's the point I'm making. So, but if we go to paragraph 19, Chair, or rather paragraph 18 and 19, I think that it tells you that that I didn't treat Ms. Ngoyi and the manner that way. So I don't think the differences were profound until I formed a view. I explained that I formed a view that Ms. Ngoyi and Mr. Diniswayo were not working in the interest of the company. And that was only in 2015, after I've come back from Cape Town, Chair.
Now, this, I wanted to ask this, the removal of the files, did it happen prior to December 2015, when you recommended that she should, 2014, you recommended that she should act in your absence when you're on leave?
Yes, I think this happened 2-3 years earlier.
Oh, okay.
So you can see, Chair, that
Yes.
We all have our own personal irritations and everything.
Yes.
But for me, it was not a matter that I should be furious or angry about. I asked her to act because I thought, and I explained yesterday, that when somebody acts in a position, it was an opportunity for them to, as part of developing their leadership skills, to have an opportunity of what it means. Because they get submissions, they've got the full powers and authority that I have as Group CEO. They have to make those decisions in my absence. So Chair, I think to answer Mr. Soni's question, I don't think until that time there was this big difference there. And at that time, there was not Mr. Moodley's hand. It only came when now the explanation comes about why certain contracts should be investigated and to be linked to certain people. That's what the story is all about.
In terms of who would be appointed to act as Group CEO in your absence, with whom did that power lie? Did you make a recommendation to the board and the board made the decision, or would you make the decision yourself? Did you have the power to make the decision yourself?
Chair, I had, well, I think answering it, I have to look at the delegation of authority.
Yes, but your recollection.
My recollection and the practice, Chair, was that it will be my decision, but I'll consult the chair of the board.
Yeah.
So that has been the practice.
Yes.
And in this particular case, I did consult with Mr. Molefe, because when you leave, particularly I was going for a relatively long period of time.
Yeah.
So I had to inform him that, look, so-and-so will be acting in that position, and if the chairman has got a problem, he'll say, but I think we agreed, because we had one-on-one meetings with the chair. And then I'll sign documents, including forms that I'm going on leave, and who authorized my leave is the chairman of the board. And then I'll indicate who's acting in that position.
I guess one of the points either that you are making or would be entitled to make is that, at least from your point of view, as at November, December 2014, you didn't view your relationship with her as being negative. Because if you viewed it as being negative, it's unlikely you would recommend that she should act in your position, or that you would get her to act in your position. Because when you are going to be away, you can't take your enemy and put them in your position.
Well, Chair, later on, I agree fully with what you've said, Chair. I fully agree with that, but I think later events were to prove that I've actually taken an enemy and put it in that position, Chair, which then resulted in a situation that culminated on the 15th of July when I left PRASA.
So she might have a different version about the relationship between the two of you. What I was pointing out is that you probably are entitled to say, if I thought that there was a bad relationship between the two of us, why would I make her appointed to act in my absence?
Yeah, I agree, except that there's one moment when we, in 2014, and I think that still support the point you're making. When Ms. Ngoye left Intersite and I moved her to PRASA, to her current position, I had one-on-one meetings. And I think many of the executives would testify to that. When you meet your executives one-on-one, other than in executive meetings only, these were happening sometimes on a monthly basis. They were scheduled, sometimes because of the demand of the business, that they wouldn't take place. Others would get angry and say, yeah, no, but he doesn't want to meet with me and those kind of things. So I met with her in respect of Intersite and had to convey to her the view of the board of Intersite about her performance. I know that in a reply she says, yeah, but I got bonus and all of those things. So the board of Intersite was very unhappy. And we had a structured PRASA chair. We had a structured PRASA where, because I was a group CEO, we then appointed what you call lead independent directors for each of those subsidiaries. Because there are certain things where independent directors will have to sit and discuss, even without me, Chair, where they sit on their own, so that where they realize that there may be issues between PRASA and Intersite, they say, Group CEO, you are chairman here, you are Group CEO, you are conflicted. So that relationship was managed, Chair. So she mentioned Mr. Benib Shielo here. And then at Autopex, we had, I think it was Ms. Lulu Letlape, to make sure, Chair, that I don't use my position, abuse my position, and impose a view on the subsidiary. So there was a system of control, which is in line, guided by what the Companies Act provides in that respect. So we had that in place. And Chair, the board was not hostile to Mr. But they will say, look, you as chairman of the board and as group CEO have to take a view because we think there's a, and I then sat with it. I say, and they said, look, let's take it through a process of non-performance. I did convey to you in the meeting. I said, we do not want to do that. Considering where you are coming from, we headhunted you from Interside, from Transnet, brought you into Interside, you became CEO. But we said, we see that you are not achieving those goals. You are not performing at that level. And I said to her, I advised the board of Interside that, no, I think I must speak to the board of PRASA that because we are restructuring our risk, compliance, and legal portfolio, that she comes in. So in a meeting, of course, she was not happy, Chair, because in terms of profile and everything, being a CEO is more important than being a group executive. And Chair, she was, I don't know the word upset, not upset, but, and there were tears, Chair. She cried, and I know, Chair, then she then consulted the chairman of the board of PRASA, Mr. Buthelezi, and says, look, I'm being removed from my position and everything. The chairman summoned me, and I explained the circumstances. I said, look at the numbers. We think we are not winning with her, but we don't want to be fair with her and take it and make an appraisal thing and then get rid of her. I suggest, so she's where she is, Chair, today. Because, you know, one of my weaknesses is that even where people have made big mistakes, I've always remained human. Think of their families and say, how do I support them? And if Ms. Ngoye is fair, she will tell this commission and say, look, indeed, what Mr. Montana is saying is true, Chair. Now, afterwards, a few months later, Chair, it brings us to the moment you just described about December, when I had to go and leave. And maybe, Chair, I was trying to close the bridges, and I said, Mrs. Goyam should act. And Chair, I nearly use a word which is inappropriate here, that we use in Mamelodi, but Chair,
this is not Mamelodi.
It is not Mamelodi, Chair, I agree. And then she showed me flames, Chair.
Yeah.
Let me put it in that way. She showed me flames. They used that time of acting, Chair. And I was to discover only later, not at the time, Chair. And I think, Chair, the point you're making is supported by paragraph 18 and paragraph 19.
Okay, Mr. Soni.
As you please. Just want to understand that. Ms. Ngoyi says that she didn't want the legal advisor in regard to the Prime Media matter, that's Logan Hover, to be replaced. Was it your view that they should be replaced?
Okay, yes, I think that when I got the report at that time, what we were being told, if I remember the details very well, Chair, I think that my biggest instruction was that, look, we are not going to win this matter as long as Prime Media and Continental still occupy side, because they make money and fight us with the same money that they make out of the portfolio. And they were trying to suggest a completely different route. And I need to think, Chair, I think in the course of the discussion, what they were proposing. So it was presented to me, Chair. I think it was at the time when some draft affidavits were being prepared for court. I think that some of the scores and everything. And I think they felt that my legal advisor was taking a more aggressive approach in respect of in respect of that litigation. I think, Chair, they appointed one of the counsel, I think it was Ms. Wali Twala, who was representing us in that matter, which was an instructing attorney. I can't recall the exact details, Chair. They were not appointed by me. But Chair, I think that we did come to a determination at that time that Intersite, in fact, they were following an approach on advertising that is not consistent with what we're trying to achieve. Now that may have given rise to this war that we're talking about, that we're describing in these pages, and that I would accept that. But Chair, I think when people go and pull files and do all of those things, I'm not part of that file. And that is why Ms. Ngoe had to call me, or as you say, raise it to me, raise with me. She says, I'm saying she called, she says, of course, at the board meeting, she raised that matter with me. So I think, Chair, that we had differences on that issue. But did it affect our relationship? No, Chair, until probably around January 2015, I think we still had a good relationship. And I bumped into him numerous times. We were pleasant, we exchanged pleasantries, Chair. We talk about things, and we also recognize, we say, hey, she says to me, yeah, you are really fighting me. And I said the same, Chair, and this thing, Chair, is like a wheel, isn't it, Chair? Maybe in coming battles, we'll become great friends again, Chair. But for now, we stand on opposite sides.
Yeah. Okay. Mr. Sonny?
As you appreciate it. And I just want to finalize this issue because I want to understand, was Logan Hovels effectively less firm on its opposition to Prime Media's case than you and Ms. Naidu would want?
Chair, look, my view, I've taken a very hardline stance on the issue of Prime Media. They put a bid, they lost the bid, and I said to the team, the main reason why they are taking this route is for them to continue to remain inside. And I had actually given a specific instruction that they should be thrown out of the site because they are unlawfully there. Okay? And I remember this was one of the issues that we fought about in this matter.
You and Ms. Ngoyi?
No, I'm referring to me, Ms. Ngoyi, and all the people that we describe, that she describes in her affidavit.
Is it, okay, so that was the difference, that you wanted a more aggressive stance to opposing the application by Prime Media as opposed to what Logan Hovels and Ms. Ngoyi wished.
My view was very clear. Those who lost the tender and who have been dominating this portfolio for how many years? I think for years, must be thrown out of the portfolio. And I think somewhere Ms. Ngoyi says, Mr. Montana says we didn't follow his instructions. But what she does in that paragraph, I'm answering your question, but I want to clarify this thing. Ms. Ngoyi links it to strawberry. Whereas the instruction that we're talking about was that there must be an order where these entities are actually thrown out of the PRASA portfolio. And I remember at that time, both Intersite and the law firm, I didn't remember their name.
Hogan Lovells.
Yes, I think that they were not in favor of that approach. And I was unhappy with that. But that was not the only reason, Chair. I think that there were a couple of reasons in those matters.
But you say that difference between you and Ms. Ngoyi was not the reason for what the removal of the file.
No. Chair, Ms. Ngoyi and I, even with the differences that we had, I wouldn't describe at that time that our relationship had collapsed where I would do that. And I was the chairman of the board, and she presented reports in the board. And I think that, in fact, to confirm what I'm saying, an assessment of the minutes of the board of Intersight, where she was CEO, you'll actually see.
You were civil to each other.
So we're civil, but I was supporting her, Chair.
Yeah.
I was supporting her throughout. It's not like we differ on this issue. She said we differ on this issue because for her, as I said, 15, 17, I'm saying that no. There's a much more dynamic environment. There were other issues involved, and let's deal with the issues for what they are, and not trying to feed them into what I call Isandla Semfene, which hasn't actually played itself out there.
Why then remove the files? Why don't you just instruct her? I'm telling you to remove Hogan Lovel, and if you don't obey that instruction, it's going to constitute insubordination.
Yes, I could have dealt with it in that way, Chair. But again, I'm saying, she also agrees with me that I've said I've never instructed for any files to be moved. There were wars between these people, Chair. And you can even see how she described Mrs. Naidu in this page. So it's people who are at war with each other. It drags me into that. I say, no, they are acting with the authority of the group CEO. And when she called me, I said, no, that's not the case. Indeed, Chair, one of the reports, and I'll check, I think I may still have it, by the way. When I was getting a report from the legal advisor, it's called litigation matter. It deals with a whole range of issues there, and basically it evaluates for me the litigation strategy that PRASA is following to respond to particular matters. And I don't think, Chair, that there are probably a couple of these matters, Chair. Should also, for example, trace even cases that are before court involving PRASA. So I don't think, Chair, that's what I'd intended. Yes, it was an option, but I haven't at that time come to that determination, as it were. And by the way, the late Ms. Zinde, when she assumed her position, Chair, she was running, and she of course had said that, and again, she's not here, Chair, to speak for herself, but she has spoken about her own difficulties in dealing with some of the things that were there. Even the public affairs portfolio was a relatively new position, Chair. We had also created a new chief strategy officer to accommodate a couple of them. So this was an organization that was evolving. And yes, people may be unhappy about some of the decisions, but you can't then put it and say 15, 17. That's my main objection there. And I'm not saying everything that Ms. Ngoye is saying is false. I'm saying that what she does, she creates a motive, and she wants to fit and try to say Montana, his part was working for this thing. So he's vested in this thing because of that. And I'm saying that I cannot agree with her. That's basically what I'm saying.
Can I ask you, why didn't you, when she raised it with you, Ms. Ngoyi, that this was removed, these files were removed, you say you didn't order the removal. Why didn't you ask Ms. Naidu to return the files to Intersight?
I think this speaks to even a bigger issue about the relationship between Mr. Chauke and her boss, not Miss Ngoye, but Dinde. And I think, Chair, we need to check with the PRASA, probably in their own, employee relation, what information is there and why she was suspended. She says she was suspended for the reasons that are stated there, which I then rejected, Chair, earlier. So, yes, I don't think we took a decision for those files. We spoke about it. I just said we didn't We ended up there, but I think that they continued, Chair, in their own way, what was happening there. But was it in the interest of the business? No, but I think, Chair, people in you have the kind of dynamics where people undermine each other, fight over things around that, but it was never an instruction from me, Chair.
But Mr. Soni's question is, here you find that according to Ms. Ngoye, files that should be at Intersite have been removed, and she was told, according to her, that the instruction came from you, and you know that that was not true, you never gave such an instruction. Mr. Soni's question is, the most logical thing is for you to say, Ms. Naidu, those files must be taken back. Why didn't you say that? That's what the question is.
Chair, I explained earlier on. I think that let's bring back what I said. I hear Mr. Soni's thing. There are two things here. The first issue is that I said Ms. Naidu never removed the file. Even by her own version, in my own version when she spoke to me, Ms. Ngoye, she said Ms. Zinde removed the file supported by or accompanied by Mrs. Naidu. Okay? Then there was a discussion, Chair, a separate discussion with Ms. Zinde, where she said she's trying to get what is called her own hold on the specific matters that she had to deal with, particularly the what is it called as a head of public
Relations.
Public affairs, and that Ms. Martin, who has been transferred to him, who was responsible for some of those activities, was actually not cooperating with him. That was the explanation. And that is why, Chair, the reason why I asked for the letter is because I'm trying to verify exactly how that process, in fact, what was the reason why Mr. Chauke was actually suspended, what was stated in there. Because that will actually, Chair, enable us to answer Mr. Soni's question.
I'm not sure that I follow. Ms. Ngoye calls you and says certain files which belong to Intersite have been removed. And she says they were removed by Ms. Naidu and maybe with Ms. Zinde, I'm not sure, or with Mr. Chauke, with Zinde, in a manner that you agree is unacceptable. And she says to you, Ms. Naidu said it was you who gave instructions for the removal of the file. You say to her, that's not true, I never gave those instructions. You have said you could tell she was unhappy about this. So now I'm not sure that what you have told me in your last answer helps me to understand, because Mr. Soni is in effect saying, you see your Intersite CEO is unhappy, she feels strongly about something, and you agree that it should not have happened. The most natural thing to do is to say, well, those people must return those files, maybe until you are given a proper explanation or something, but they must return them. So the question is, why didn't you do that, say that?
Okay, I think, again, maybe I'm answering in the middle.
Yes.
Let me go back slightly. I was saying, Chair, that there was a process. I said, let's not conflate two things: the moving of the function and the removal of the file. And I said these two things are related, but they can't be explained in the way that she explained them. Now, I think at that time, when we created the position that Mrs. Zinde was responsible for check, so the decision had been made.
Was responsible for what?
For public affairs, Chair, involved, it was mainly our media side of things. It involved some part of advertising. So it was a number of functions that we called public affairs. And then it also dealt with our public image, and when we undertake some of the public campaigns like the Nelson Mandela event. So at that time, Chair, there was no dispute. We've made a decision. Those functions were there. Okay?
Public affairs functions
Public affairs functions.
were with Ms. Zinde.
Ms. Zinde.
Yeah.
You recall, Chair, I said, this portfolio has moved a number of times. At various stages, we're taking a decision around that. Now, Ms. Zinde at that time,
Public affairs, did it include this advertising, outside advertising?
Chair, it included,
Did it include the outside advertising?
it included there were issues about signage, there were issues about some part of advertising, Chair, some part of the broadcasting function.
Okay.
It involved, so there were a number of functions.
Okay.
I'll have to verify it. So that decision had been made.
Yeah.
And I think that was one of the reasons why,
To move the function
to move the function, Chair,
of public affairs.
to public affairs.
To move the function of what to public affairs?
Part of that advertising in media.
Oh,
you
okay.
remember-
Which had been sitting at
At
Intersite.
Intersite, Chair.
Okay, all
At
right, all
Intersite.
right.
That is a separate, it has been made.
Yes, yes.
So the new incumbent at that time says, I'm having difficulties with this.
Ms.
with
Zinde.
Ms. Zinde.
Yeah.
And Chair, that is why I apologize that she's not here to speak for herself. She says, here's a chap who's not cooperating with me,
Referring to whom?
Mr. Chauke,
Yeah,
who's now reporting to her, but who insists on working with, on the other side with Intersite,
with Ms. Ngoy.
with Mrs. Ngoye.
Yes.
Okay? And that decision, so it was not about, we are not moving functions to Mrs. Zinde. So there's a transition there. Now,
No, you mean you are not moving files, you're moving a function.
we're moving a function. Chair.
Yeah, yeah.
Now that function, when it moved, she then said,
Who is she now?
Ms. Zinde,
Yeah.
she's saying that Mr. Chauke is not cooperating, which resulted in her taking the step that she did, Chair. Which is to go and collect.
Take the files.
Because she says, Mr. Chauke is not cooperating with me. He's supposed to report to me. He's not working with me. And then went to the office to collect the files.
So she seeks to solve the problem of Mr. Chauke's cooperation by taking the files.
By taking the files in the chair. That is why I said I didn't support. So I wouldn't then resolve that issue in that way. Ms. Ngoye was not raising the issue about function at that time. She was saying the manner this thing was done, even though she had her own views about these functions, but they'd taken a decision as a collective. So when the files were taken, she says these people, they just can't barge into the office and say, and then she says when Ms. Zinda was doing that, she was supported by Mrs. Naidu. And I confirmed the chair, Mrs. Naidu never collected any files from Intersite. And in the later discussions, that is why I say, I want to see the letter. And part of the letter say it will explain precisely, and I think Mr. Chauke should still have the letter, precisely the reason why Ms. Zinde wanted her suspended or suspended her.
So you think there's a possibility that she suspended Mr. Chauke because of his failure to cooperate with her in relation to
Indeed, Chair.
this function?
Indeed, Chair, but I'm saying those issues are conflated in this affidavit.
Okay.
That's the point I'm making, Chair.
Okay, but now then I shift Mr. Soni's question from Ms. Naidu. Then I say, why didn't you ask Ms. Zinde to take the files back?
Chair, I wouldn't ask her to do that because
Yeah.
I wouldn't ask. I would criticize. I would criticize and say, no, but that's not how we should be doing. We should be managing the transition when we deal with our functions. But I wouldn't say return the function because if they were doing something about the function that was not there, then that was a completely different matter, Chair.
Well, the story that, what you have told me suggests to me that it may not have been necessary, at least at that stage, to take the files, if only Mr. Chauke was cooperating with Ms. Zinde. It was because Ms. Zinde seems to have sought to solve one problem by creating another problem, in the sense that she had a problem with Mr. Chauke not cooperating, and then she thought, well, if I take the files from Intersight, then he will cooperate. And maybe she did succeed, maybe she didn't succeed.
Yeah, that was the complaint by Ms. Goya, I agree, but you didn't solve it by then saying, return the file. That is why the discussion, and I think that the nature, where we are going to get the right answer about who's telling the truth, the answer would be in the reasons provided by Ms. Zinde to suspend Mr. Chauke. Because, and secondly, you recall, Chair, what Ms. Ngoye says is that the instruction to suspend Mr. Chauke comes from Mr. Montana, and she says, but the letter was delivered by Ms. Zinde and Mrs. Naidu. So she's saying that, Chair, I suspended Mr. Chauke. And if I did, Chair, that in itself would have been irregular because a senior manager will not be suspended by Group CEO, Chair. Is suspended or disciplined by the immediate supervisor, as it were. So I don't think, Chair, that the right approach would have been saying return them back when they were transitioning. So the key thing was managing whatever changes that were taking place within the business.
But why would that not be the right thing to do? Because you agree what has been done is wrong. The CEO of Intersight feels very strongly about it. What would be wrong with saying, Ms. Zinde, the way you have gone about this is unacceptable. The files must go back. If there needs to be a discussion, then there can be a discussion. It may well be that later on they can be taken, but then they must be taken in the right way. But let's right this wrong. It was not the right way.
Chair, the discussions about that had taken place subsequently, but I'm simply saying that the answer about five, and maybe, Chair, maybe to with hindsight, when you say you want to what is it called, to remove or reduce the tension and the unhappiness, maybe that would have been a right way, but it would have been symbolic to say, oh, I'm taken seriously, my concerns are being addressed.
I accept that in a situation like that, it may be that somebody who is supposed to resolve the matter might decide, look, in the end, the files were going to end up there.
There, indeed, Chair.
And maybe there is no point in saying they must go back, but the manner in which they were taken is unacceptable. Let's address the unhappiness that's associated with the manner in which they were taken. Assuming, for example, that Ms. Ngoye might not have had an in-principle objection to the files going, but she might just have had an objection to the manner in which this was done.
No, she did, Chair. I think it was in a manner in which it was done.
Yes.
And that's what she conveyed to me, that people just arrived, entered and say, we are coming to take documents. And she says, is this how we work, Chair? Yes, we're taking a decision, but is that how we're going to do it, Chair? Of course, at that time, Chair, I didn't think we should return. There were engagements around those issues on how we dealt with the function. But, Chair, I think the answer to our question lies in this letter of suspension. And that is why I think it would be better if we get it. So I would want to suggest to park it. I'm given, and that when I come back for my testimony, I deal specifically having seen the letter.
Okay.
If it was signed by me, I'll say, Chair, it was irregular. If it was signed by Ms. Zinde, and the reasons for that, Chair, we then discuss it on that basis.
Okay, Mr. Soni, I took over your question.
No. I was going to go in a similar direction, though not as well as you did it.
Okay.
Mr. Montana, I'm not going to deprive you of the opportunity of revisiting this issue. And I know I don't mean it say that you're doing it to avoid it, you're doing it because you want the facts in front of you relating to the letter. But I have a related question, and it is this. The contract that is signed is between between Intersite and Umand.
No, Chair, there are two contracts there. The first contract was initially signed between PRASA and Umjanji Proventage. The second contract is when Umjanji applies to PRASA for the ceding of part of that function, which is the specific outdoor function. Okay, and therefore that was between indeed Intersite and Strawberry.
Now, where was Ms. Zinde based at time, around the time of this?
She was based at the PRASA corporate office.
So, the function was now moved to PRASA.
The function, not change. The full advertising function was initially at PRASA corporate. And when the tender was agreed, was done, I think it was in 2011, it then was then placed with Intersite. And then later on, the culture spoke to the function moving a couple of times. And then it was when the new portfolio was created to say it must manage part of that advertising portfolio, more specifically. And in fact, I think the advertising is one part of a bigger portfolio, Chair, that was there. So I think the then set with the public affairs under group strategy, which was led by Mr. Holele. So Ms. Zinde was the group, was a general manager reporting to Mr. Holele. And I think that's when this issue about files happened in that process.
So on that score, there can only be two possibilities. One is that the files had to move because the function was now at PRASA, not at Intersite. That must be correct, isn't it?
No, that is correct.
Okay.
With a function, yes.
Now, did you tell Ms. Ngoyi that look, at the end of the day, I accept that the files were removed wrongly, but at the end of the day, they now belong to PRASA because the function is now at PRASA.
Yeah, but Chair, that's why I'm saying we are confusing ourselves. Because the issue, and that's the point I've been making throughout the day, the issue of the files and the decision about the movement of functions didn't happen at the same time that today we are making a decision and people know. There's been an ongoing process, Chair, and that is why we need to find the time that decision was made. And I think you asked an important question earlier. Was Ms. Ngoyi part of those decisions that were made about where this function should be? Okay. And that's I think that's a big issue around. It clarifies what needs to be done, Chair. When the position was created, and then somebody was appointed to that position, Chair, then that's where the fight, in fact, happened. Okay. So I don't think that is actually. I think that there are even more possibilities than actually only those two.
No, Mr.
But, I'm sorry, Mr. Sonny. I think Mr. Sonny's question requires that I know whether at the time of the removal of the files, the decision to move the function from Intersite to PRASA had been taken or not.
It had already been taken.
Yes.
And that's the point. It's already been taken,
Yes.
And Ms. Ngoye was part
Was
of that
part of
decision.
that,
That's,
yeah.
that's the point I'm making. And that
Yes.
is why when Mr. Soni asked the question, shouldn't the logical thing have been for you to say, let them be returned? For me,
Yes.
I say, but that is not the solution.
Yes.
Because then you are telling, let us rather manage this thing in a proper, disciplined fashion as a company.
But Mr. Soni's last question says, or suggests that because you knew that the decision to remove the function from Intersite to PRASA had been taken, and because you knew that on your version, Ms. Ngoye knew that as well,
Yes, sir.
one would have expected you, when Ms. Ngoye was complaining about the removal of the files, would expect you to say to her, yes, I definitely agree with you, Ms. Ngoye, that the manner in which the files have been removed is unacceptable, it's wrong. But remember that you were party to the decision. We already made the decision that the function must go to PRASA. They are where they are supposed to be, or they are where they were meant to be ultimately. So he's asking whether you raised that with her.
No, Chair, I don't think I did in that discussion.
Yes.
Maybe I took it as a matter of common cause, that both of us know about it. But that was a decision, Chair, that we made, but the specific discussions that you raised was that,
And you are quite clear that the decision to remove the function had been made. You are not
no, Chair, it was made much earlier.
Much
She was
earlier,
party to that.
Yes,
That,
yes.
and we've made not only this decision, Chair, we've made other decisions.
Other decisions.
Which, that is why I explained that there were other decisions that are related to how do we split the portfolio, for example, and I'm referring to the property portfolio between Intersite and the newly created PRASA Crest. Okay? And there were files, Chair. There were big files because PRASA was being restructured as an organization, Chair.
Now, it's one thing to make the decision that this function should move from Intersite to PRASA. You make the decision today, but there may be the question of from when. Had that issue been also sorted out by the time of the removal in terms of when the function would move, or had it definitely moved in accordance with the decision?
So the functions at that time were being performed in public affairs.
Yeah, already.
Already, Chair.
Okay.
That discussion, and that is why I'm saying the letter that I'm asking for will
May
then help
clarify.
us to bet exactly that
Yes.
this thing, Chair, so that we don't deal with it that Ms. Ngoye didn't know. She was part of it, Chair. We're taking that decision. Ms. Zinde was employed as part of her duties. And when she took that decision, Chair, about Mrs. Chauke, she was saying that she was not cooperative in that particular matter.
Okay, all right. Mr. Soni, I hope I helped to have the clarification.
No, it does, but what it illustrates, Chairperson, and I'll say this to Mr. Montana, is that it seems, if you are correct, that Ms. Ngoyi was not being reasonable at all. So she had no reason to be unhappy, because that, as a lawyer, she would know it's a logical function, that not only must the function move, or a logical conclusion, that not only must the function move, but the file must move, because it's being handled now at PRASA, no longer at Intersite.
But Chair, Ms. Ngoye was not arguing with that. She was saying the manner
in which it was
the
done.
files were moved was unacceptable to her. And I agreed with her in that particular position.
I just refer you to 15.6, but we must leave this now because I want to get on
15.6.
15.16, sorry.
Yes.
Where she is saying even the removal of the function was not in processing.
Chair,
Yes, it reads, the effect of moving the advertising portfolio from Intersite to PRASA is that the management of the portfolio was not in the interest of, I'm not sure that I follow this sentence properly, but she says the effect is that the management of the portfolio was not in the interest of PRASA, and PRASA benefited little, if anything, from the portfolio. From the way she starts the sentence, I expect her to be saying it served the interest of PRASA better to keep the files, the portfolio at Intersite. It did not serve the interest of PRASA to take them to PRASA. But she uses the word management, but maybe that's what she intends, I'm not sure.
Because as I understood, and I've dealt with this affidavit before, but there is a vagueness about it. As I understood it, she's making a distinction between PRASA as opposed to Intersite.
Yes.
Now, if Intersite holds the contract, then all the benefits go to Intersite, and it would do as much as possible to secure the full benefit, whereas PRASA is not receiving any material benefit from the contract, and therefore may not nurture the outcome as well as somebody at Intersite as a competing. That's how I understand that.
But I guess what is also true is that if this is the view, if she held the same view at the time, then one would expect that she would not have gone along with the decision to move the function from Intersite to PRASA. So it would therefore be interesting if the minutes of whatever meeting reveal differently.
Absolutely.
Yes.
Chair, I fully agree with that. I think you raised the issue earlier on this issue. And my view, Chair, I think my answer was very simple. I think the key issue about this portfolio, advertising portfolio, had to do with the maximization of revenue for the company, for PRASA, as a group. So I think it's more of a not PRASA Intersite, but it's a group, PRASA group structure as against Intersite. And it suggests that here, if you look at the previous, because they don't flow logically, Chair. In 15.15, she deal with the issue of the suspension of Chauke. And then she immediately goes and make that big point. And then conclude with 15.17. Okay? Now, so the issue of the portfolio moving and the issue of Chauke are treated interchangeably somehow. And that is why it raises the question, did she actually support the decision? What should we, let's look at the, what is it called, the Eskom minutes, let's look at the Intersite board minutes, then, and as well as the letter of suspension of Mr. Chauke. Those documents will be able to help us to come to a determination and say which version is more probable than the arguments that we have checked.
Okay, all right.
Just one final question on that. Where was Mr. Chauke based? Was he based at Intersite or at PRASA?
At some stage he was based at Intersite, Chair.
No, at the time of his suspension, at the time of this incident.
He made, Chair, I think because the transition was happening, he was reporting to, he was now required to report to Ms. Zinde, but she may have been physically still at Intersite as part of that process.
Would you have the power as the CEO of, the group CEO of PRASA, would you have the power to suspend him, although he's based at Intersite and an employee of Intersite?
No, Chair, I think unless if it's based at Intersite, no, Chair, it will be different, a completely different
entity.
Yeah. But let's make a distinction, sir. You say if he's based at Intersite,
Yes,
You mean in the structure if it's reporting to the CEO of Intersite?
yes.
No, Chair, it will be regular. But if it's physically at Intersite, but it's reporting to, let's say, Mzinde, Chair, the decision is a completely different one. I can't parachute and come into Intersite and suspend an employee when there's a CEO there. It will be inappropriate. But if he is part of the corporate office, irrespective of where physically he sits, he report to the what is it called?
Ms. Cinder.
Mzinde. And Chair, it depends on the nature of also of the transgression, because there are transgressions that may be serious, that may be dealt with at a completely different way. I say this impacts on let's say on the stability, on the assets of the company, and I can take a decision on the employees. And we've seen during strike actions, some of the decisions are made by me because at that time the protection of the assets of the business it sits with me. So again, it depends. But to answer in short, Chair, if he's an employee of Intersite, I can't suspend him, Chair. It will have to be the CEO of Intersite that makes that decision.
And if he was an employee of PASA and reporting to Ms. Cinder,
Zinde.
generally speaking, even if you might ultimately have the power in certain circumstances to suspend him, you would not suspend him.
No,
You
it
would
should
leave
be-
that to Ms. Cinder.
Ms. Zinde will have to do that, Chair. That is why I said it.
Yes.
If I did, and that's the reason why I'm asking for the letter, Chair. Because if the letter says Montana signed and suspended a senior manager, it means, Chair, then I'll have to say to this commission, I concede that I acted at that time irregularly, Chair. Yeah.
But something tells me that you would not forget if you suspended him. Or did you suspend too many?
Chair, I know where you're coming from, indeed, Chair, but that is why I think sometimes I've been hammered by the public protector, where I didn't sign, but I may have said, but you need to take action against this, Chair.
You may have authorized.
Well, no, it's not authorizing, Chair, I would say.
Yeah.
I mean, I go to Park Station,
Yeah.
7 companies don't clean the station, they don't say, I said to the boss, act against this
Yeah,
person.
okay.
When it ended with the public protector, is that the 7 companies were fired by Mr. Montana. I never fired them. I said to the boss of Prosacres, if you don't act against those who don't clean the company, I'm going to act against you. And the finding of the public protector said the dismissal of those companies was done by Mr. Montana.
Okay.
So, Chair, you could have that. That is why I think
Yes.
in this particular instance, the reasons that Ms. Zinde may have advanced, may have justified, what is it called, taking action against Mr. Chowk.
Chowk, yeah.
And she may have said, this is the route that I take, and I may have supported that route, Chair.
Yeah.
But that is why I'm saying I want to remind
see that,
myself
yeah.
and see the letter before I confirm or reject what
Yes.
Mr.
Okay,
Solis
all right.
asking me.
Okay.
We then turn, give us I take it until we get those documents,
Yes, yes, yes.
we
We
are
can
finished
deal-
with
yeah,
paragraph 15.
Yeah, we'll ventilate some of the aspects when we've got
When
those
we've got
documents, yeah. We have gone past 4, we are at 4:30, but I think we need to go at least up to 5. Then I will have the evening session. So we'll have to talk about another day. And Mr. Montana is ready to cooperate.
Yes, no, in fairness, he has been,
Are you going to deny that you are ready to cooperate, Mr. Montana?
Not with you, Chair, except that I would raise the issue of opportunity cost that goes with my testimony, Chair. I was joking with the team earlier on to say, people like us who are hustlers, when I sit in the commission,
Yeah,
the cost...
you don't make money.
You don't make money, Chair.
Yes.
But Chair,
Yeah.
I've committed to
Yes,
assist the commission
yes, yeah.
and to cooperate, and I think
Yeah.
I'll continue doing that.
Yes, okay, no, that's fine. At 5 o'clock, we'll just talk about when Mr. Montana should end. But let's continue until 5.
Mr. Montana, let me express our gratitude to you for your
Thank you.
Now, paragraph 17, we've dealt with some of these matters, and you just tell me where you disagree, Mr. Montana. He says, I first encountered Mr. Montana when I joined Intersight as an executive in the office of Intersight CEO in January 2011. Is that something
No,
you
that's correct, Chair.
And then she says, that appointment was made by Intersight's board, of which Mr. Montana was chairperson. That's correct, please?
That should be correct, Chair.
And then she says, 9 months later, on the 1st of September 2011, the board, still chaired by Mr. Montana, appointed me as Intersight's CEO.
That's correct.
And she says, I was transferred to PROSA with effect from the 1st of September 2014. Now, Mr. Montana, because I just want us to close that gap. As I understand it, you say it was effectively a forced transfer because the board was unhappy with her, and she was unhappy that she was being removed as a CEO of one of the subsidiaries, and although she was an executive, she was unhappy. Does that capture?
No, she was unhappy, Chair.
Just 3 months later, Mr. Montana asked me to act in his position. Well, you've confirmed this, but let me just finish it. For 2 months in December 2014 and 2015. That's correct. Yeah.
Well, the total days, Chair, I think was about 28 days. But of course, they fell in the month of December and January. It was not a full 2 months.
Oh, yes, I understand.
Oh, it was 28 days.
So I think it was in the...
Which straddled
Yeah, it
the
straddled
two.
there. I think it was
okay.
in late December.
Yeah,
And then I think it went to around the 22nd
of January.
of January.
Okay.
He says these are peak periods for the long distance business of PROSA. Is that correct?
That's correct, Chair.
And he says mainline passenger services and autopacks, and it was at a time when the board was considering a very important tender for the construction of the biggest depot for PROSA. Is that something you recall?
Chair, I recall that very well, because in November the board had dealt with the Bramfontein, but I were to learn, of course, later. The answer is yes, Chair, that on the 23rd of December, the board met to discuss this issue again, but I was on leave at that time. So it's correct, Chair.
On his return, Mr. Montana thanked me personally and at a group Eskom meeting for the hard work and having held the fort for him.
That's correct.
Yes, there are two paragraphs in which you are fully in sync with each
Well,
other.
they confirm what a kind man I am, Chair. And I think that should be one of the major findings by the Chair.
Then she says on the 18th of May, now we dealt with this issue to a large extent yesterday, and we can, without avoiding any issues, this is the day on which you sent the email, the email. You remember this? This was in Mr. Dingiswaya's affidavit.
That was,
Is
I
that
think,
the email about the
April.
campaign?
Yes.
The email about the campaign?
Please have a look at it, Ms. Montana.
Yeah, no, Chair, I confirm, but this was a different matter. The email was on the 18th of April. But the matter is the same, it's almost the same matter, Chair. I agree with Mr. Soni.
No, please have a look at page 317.
I seem not to have 317, 316, and 3118.
It is the same email that we looked at yesterday in the context of Mr. Dingiswayo's affidavit, where you were talking about people who you said were on a campaign.
But I remember the email, yeah.
So what I'm saying is it is the 18th of May, not a different.
Not April, okay.
Yes, right. But let's have it in, well, I mean, I don't want to deal with it anymore, but I just want to say that it is the same email, and I'd just like you to be comfortable that that's the email we are talking about.
That's correct, Chair.
Now, he says the contents are self-explanatory. And can I just, well, let's just finish this part. Because the email was sent after the legal function of PROSA through Mr. Dingiswayo and me had indicated that we were not in a position to deal with the Swifambo contract, which required some amendments to be effected to the main agreement that was already in place. Is that correct?
No, Chair. I think, in fact, yesterday, Mr. Dingiswayo says in his affidavit that the reason why I took action, he says it was because I was defending Prodigy. In this paragraph, it is now said it has to do with Swifambo.
Yes. But she comes to that issue in a moment. But you say this had nothing to do with their refusal to be involved in the amendment to the Swifambo contract, which would extend the price of the contract from 3.5 billion rand to 5 billion. You say this had nothing to do with it.
No, Chair. Chair, I think that Ms. Ngoye is confusing things. Okay? And this thing about him not having as a legal function that it questions on the principal transaction to which no satisfactory response was provided. It's just, I think it's just a lie. Chair. You recall that I said Ms. Ngoye was part of this process, part of the bid adjudication committee that recommended this thing to the board.
Yes, you said that.
I said that, Chair.
Mm-hmm. Yes.
Now the issue of the 3.5, and you'll see again in my, and let me explain it, but it's in my annexure. In 2014, Chair, not May 2014, with the board under Mr. Cecil Louwrens.
Under Mr. Butelis.
Mr. Butelis, not Mr. This is 2014, not 2015.
Yeah. Best part of 2014.
Of 2014, Chair, just before the new PRASA board of Mr. Mulek was appointed. We went to the board because we're dealing with the euro rate exchange. And Chair, I think the supporting documents are provided there. Then we took a decision as a board that the contract is 3.5. But it's very important to renegotiate some parts of that contract and pass the risk, because you remember the risk of the exchange rate risk was sitting with PRASA. So we wanted to pass that to Swifambo. But that was in 2014, and I think the documents are very clear. It was in, that decision was made by the board, and the board further said, guys, with all these fluctuations, whilst things are happening, we don't want this contract to shoot off the roof. So it's gonna, you need to cap this thing so that it doesn't exceed 5 billion rand. So it does not say increase the contract to 5 billion. Say try to do that, but manage this thing in such a way that when the road, at that time I think the rand had lost about almost 40% of its value to the euro. So for the same amount of money, we could buy only fewer trains, Chair. So that's what happened. Now I'm saying Ms. Ngoye is confusing this thing because in 2015, May 2015, It was the board of Mr. Molefe. Mr. Molefe and the new board were appointed on the 1st of August 2014. So we discussed that matter 3 months earlier. And let me say, Chair, that at that time, she was not in that same position. She was still at Intersite as things stood. Because she
Now,
remembered-
which time is there? Is it 3 months before Mr. Mulefe's board came on
Yes,
board?
and you'll recall she was only transferred, Ms. Ngoyi was transferred, I think, in September 2014. Okay?
So the discussion that you are talking about would have happened about May,
May
June?
2014.
Okay.
So it's recorded, Chair, the documents, the evidence is there to support that. So it wouldn't have been the reason. The Swifambo matter would not have been the reason at this time because there was a new board. And we knew that the board of Mr. Molefe, when it comes to this issue, had even taken a more hostile approach. And later, I think from December, or rather in 2015. And this reason, Chair, that she's saying that we were not prepared to do that because we were worried about the principal, we didn't get satisfactory responses. Chair. I thought Ms. Ngoyi was going to say Annexure MN10 or whatever, contain a document that was sent to the CEO saying that. Because, Chair, this is created. She's actually creating a reason. Chair,
So part of what you are saying is that she says they sent, you sent your email that we have referred to on the 18th of May 2015, where you talk about the campaign, okay?
Yes.
And then she is saying that email was sent, you sent that email after the legal function of PRAS, I guess that's the legal department, through Mr. Dingiswayo and her, had indicated that they were not in a position to deal with this Swifambo contract, which required some amendments to be effected to the main agreement that was already in place. So what you are saying is your email about the campaign could not have been prompted by their refusal, if there was a refusal, to deal with this Swifambo contract, because they are talking about May 2015, but this was during Mr. Popol Mulefe's board
in 2015, that's
in
correct.
2015. And you say the two
No,
don't
Chair,
go
even
together.
in terms of the timelines, there's no correlation. So, Chair, it tells you
Yes.
that the reason she's advancing, she's actually advancing a reason which she had created thereafter. And this
But
contradicts Mr. Dingiswayo's thing. She's saying, me and Mr. Dingiswayo. Mr. Dingiswayo is saying a different thing. She doesn't take about Swifambo. And even if the two of them were in agreement, that it is about Swifambo, I would say, Chair, it is false, because at that time in May, we never discussed, unless if she wants to be blunt and put it for what it is, Chair, that at that time, she says, we didn't get satisfactory responses. You know what it suggests to me, Chair? That I said, confirms my email. For me, it links to my email that there is now this campaign. Yesterday, I said to the commission, they'd identified contracts. When I came in January to call from Cape Town, a meeting with the chairman and sorting out the ANC's transport plans. They were investigating. So, Chair, this has nothing to do with what she's saying here. In fact, for me, if I were to provide the list of companies to be investigated, it suggests to me that actually she's actually trying to go around that, because this issue was not there in 2015, unless if it was an investigation.
While you were there as Group CEO, to your recollection, was there a time when the legal department refused to deal with the Swifambo contract?
No, Chair, not at all.
That did not happen during your...
Not at all.
Yes.
And I'm saying,
But they did refuse to deal with other contracts, certain other contracts that you know of?
that is why
while
I
you were
wrote,
there?
that is why I wrote, and that is why I called, by even Mr. Dingisoyo's version.
Yes.
When I summoned him to my office that, no,
Yes.
you are now working against the business.
Mm-hmm.
And I said the reason why he acted in that way is because it was part of this broader campaign.
Okay.
Now, this 19 chair, I don't think she had intended to say that. Okay? And she tried to find a reason that didn't exist. And she brought in Swifambo. And I think it's false, Chair. It is false, it's misleading the commission. It's not the truth, Chair.
Now I do remember you did say yesterday that there were certain contracts that they identified, and you talked about them being inconsistent in their approach. Some contracts maybe could be having the same perceived problem or alleged problem, but one gets investigated, another one doesn't get investigated, and that's part of what you had a problem with in their approach. But so you are saying that, but you are also saying that there was a time when there was a decision in terms of which the board said, we don't want to find after some time that the costs relating to this Swifambo contract have shot up. They must be kept. And that's where the issue of 5 billion was mentioned.
Indeed, Chair.
Yeah.
That was in May
Now,
2014.
that would have been the board of PRASA,
Indeed, Chair.
and Ms. Ngoye would not have taken part in that one.
She was still the CEO of Intersite.
Yes, but I thought earlier on you said she would have been part of that discussion about 5 billion or something.
No, Chair.
She would not have.
Chair. Maybe I mixed up a number of things in one in
Yes.
one explanation.
Yeah.
I'm saying where she says we didn't understand the principle. We had several questions on the principal transaction. I'm saying Ms. Ngoye was part of a bid adjudication committee.
Oh, okay.
So
Okay.
if the legal function, which was reporting to her, raises question, she writes here that I didn't have. So she's telling us here that she was part of a bid adjudication committee that recommended something she didn't understand. Maybe that's why she's fighting it. She realized, oh my God, what have I been party to? What have I done? But this cannot be the reason, Chair, that she's advancing here, because this happened a year earlier, May 2014. She was still at Intersite by that time. She wouldn't have been part of that discussion. And my evidence, Chair, that I will submit will provide even the memorandum that was prepared by one Mr. Pure Matobela. It shows the movement of the rand in relation to the euro and the huge risk that we're facing as PRASA at the time.
What is it that you say happened in 2014?
So in 2014, there was a board meeting,
Yes, about this
the rand euro
capping.
exchange.
Yeah, capping the costs.
And the board said, number one, go and renegotiate some parts of this contract, because
Yes.
if the rand, the value of the rand continue to deteriorate, we are going to be in a big problem, because the amount can shoot beyond. So they say, continue doing that, but cap this thing so that it doesn't even exceed 5 billion rand. They were not saying increase it to 5 billion rand. They said, go and negotiate, but we don't want when you come back to us and say, the rand euro has changed to such extent that this thing is 10 billion, as an example. So that's what was happening. You remember, Chair, there's a formulation in the contract where if the rand is at a particular level, we sit with the risk. But if it goes, I think there's an entry and an exit level. So the exit level, Chair, the material conditions have changed so much. And that is why we had to discuss it in May. So we're not changing the contract, but we wanted to make sure that we still get, under the new economic conditions or market conditions, we still get the same value for money that we intended. So that was the discussion in May
Yes.
2014 about the farmer contract.
Then to complete the point, did the legal department, and in particular Ms. Ngoye and Mr. Dingusai, get involved in the negotiations which would have been pursued following that decision by the board, and did they refuse to do anything in regard to that,
No, Chair, I think.
as far as you recall?
No, Chair, you remember when the contract was done, it was signed in 2013.
Yeah,
Ms. Ngoye was part of the bid adjudication committee
Yes.
that recommended.
yes,
But in terms of our SCM policy and the composition of the committees, it requires, of course, that when you consider these bids, what is it called, your finance, your legal, people should be there. It's actually it specifies that. So I wouldn't know, for example, who at that time. Ms. Ngoye was sitting, not even coming from the legal department at that time, because she was appointed even though she was at Intersite. And I think she may have been even appointed before she was CEO, when she was the head of the CEO's office at Intersite. Because this adjudication committee was for the entire group. It involved a number of people at that level. So, Chair, somebody from legal could have been involved in both in the adjudication process, but I wouldn't know, as I sit here, who it was at that time.
What I'm trying to establish is whether she might have made a mistake by dealing with an issue, namely their refusal to deal with this reform contract. She may have made a mistake by saying that issue, their refusal happened in 2015 when maybe it happened in 2014 if the discussion that you are talking about happened in 2014. So I was trying to see whether...
No, Chair. Let me be direct on this issue.
Yeah.
There was no confusion, Chair. There's no confusion when I'm the CEO of a subsidiary. I'm not a trust. Okay? There's no confusion that the new board of PRASA didn't discuss. And where the board of PRASA, even in 2015, Chair, in 2015, discussed the Sufambo contract. That was done by me at the board. And we're not asking for money or changes to the contract. Because the new board had asked to discuss the Sufambo contract in light of what was being reported in the media. And I went there, I took the CEO of the rail division, and I took some of our own engineers, Chair. And that's the day we had quite a lot of even fights about this particular contract. This one, Chair, doesn't relate to any of that. Martha was not part of was not at PRASA, a corporate office. It was still at the Intersite, as an Intersite CEO. But Martha knew about this particular contract because she was a member of the bid adjudication committee that recommended it to the board. And I'm saying the reason she's advancing, Chair, where she says, I sent this particular email because of the Sufambo matter, Chair. I want to argue that with all facts considered, that is actually false. It's a misrepresentation. It was not, it can't be a mistake, Chair. I know that you want to give a benefit of the doubt, but all circumstances show, Chair, that she lied. And if she says in this affidavit that me, and she says it, Chair, through Mr. Fanny Tingisoayo and me, had indicated that we were not in a position to deal with the Sufambo contract, which required, no, Chair.
Yes, no, but the reason why I'm asking is simply to make sure that I understand that from your point of view, you are saying this can't be a situation of her being mistaken or taking something that happened in 2014, thinking it happened in 2015. You say she did this deliberately. She knows the two have no connection, or whether there is room that she might have got mixed up as to when, what happened. So but you are saying there is no, as far as you are concerned, there is no room for her to have made a mistake.
Chair,
She
in the earlier one,
deliberately-
in
yes.
the earlier one where we're discussing advertising,
Yeah,
you recall I said, this may have happened, but she's confusing with them.
Yes,
That I
yes.
accept.
yeah,
In this particular one, Chair,
it's not confusion.
no, it's not correct. And in fact, if she meant what she'd written here, Chair, one of the things she would have said, I annexed her an email here to support what I'm saying. Who did she raise this thing with, Chair? And can you see it's coming out that we were not prepared. We had asked questions, several questions on the principal transaction to which no satisfactory response were provided. Who did she ask, Chair? Because now it's a general statement. Did they ask Lucky Montana? Because, Chair, on Sufambo, Chair, I don't learn, and I think, Mr. Soni, you know, I actually believe that the court judgment is even wrong on this issue. But that is not the point here. They never asked me, Chair, they never sought my guidance. I'm saying, Chair, the only probable explanation is that they were dealing with Sufambo as part of their list of contracts that they've now identified, which led to me writing this particular email on the 18th of May, Chair. That's the only explanation, Chair.
Okay, and I see that in the sentence you are reading, she doesn't say with whom they raised those questions. I think that's one of the points you made.
Indeed, Chair,
I
because
guess because if she said they raised them with you,
yes.
you would then be able to say, yes, they did, or no, they didn't. And she doesn't say they raised them with Ms. Zinde or whoever. She just says they raised questions.
Exactly, Chair. And if let's assume that the teams who are dealing with this matter were not in a position to answer, Chair, the most logical thing would be to say, hey, we think there's a risk, there's a big contract for the business, and we want to elevate this into the group CEO to deal with that. Chair, the intention of this entire paragraph is actually for Ms. Ngoye to dissociate herself from the Sufambo contract so that she can put it as if it's other people who did something wrong. So she's projecting herself, I'm this hero, I ask questions. Now, this contract was recommended by Ms. Ngoye, Mr. Tiro Holele, and his adjudication committee, not for approval by Mr. Montana, but by the board of PRASA.
So when it is said that this contract was irregular, was unlawful, you would say the people who recommended that it be granted must share whatever blame in relation to that, if that is the position.
Chair, you seem to have read my affidavit.
Well, I read your affidavit last year.
Last year, Chair.
I think I told you that on Friday. I read it, but I can't remember everything. But I think
Yes, Chair. The reason why I'm saying that, Chair, is because PRASA, under Mr. Nati Krena, who was the acting group CEO after I left PRASA, when they were busy doing these investigations, they started creating new grounds of why they should challenge the Sufambo contract. These were not, as I said, Chair, they were never raised by the bid adjudication committee, either to me or to the board that approved this thing. They started coming with new things. Oh, there was no proper agreement between Sufambo and Foslo. They created, all of those are created, Chair. I detailed them there. But the most important thing, and here's the issue, Chair. Mr. Nati Krena prepares...
Don't go too far from the mic.
Mr. Nati Krena, the acting CEO of PRASA, who was appointed by the board to act there immediately after I've left, issues letters to all members of the bid adjudication committee and the bid evaluation committee and the bid adjudication committee, and ask them, please write to me and explain why I shouldn't take action if those reasons are true. You know what happens, Chair? Nati gets an email written by Mrs. Erasmus on the instruction of Mr. Bennett Hodges, and saying taking action against these people. So these are corruption busters, people who have been brought to fight corruption. They tell the CEO of Prasa that something that violates the law, that violates the PFMA, if those reasons are true. You can't take action because it will undermine our strategy when we fight this court. And the reason why Prasa didn't act against people like Tiro Holele is because it was the intervention of Werksmans to protect them. The same Werksmans chair that chases other people on other irregular contracts, as it were. So I'm saying that if you look at 19 chair, this was an afterthought. It's manufactured to drive for Mrs. Ngoye to dissociate herself, chair, from the Sofambo contract, and she's an integral part of it, chair, and she must take ownership for that.
Now, you refer to two people. I think they may be from Beckman's, that you say wrote and said action should not be taken against
All those people, chair.
all those people,
It's
which
the-
included Ms. Ngoye.
That included Ms. Ngoye, because already Ms. Ngoye, Mr. Holele, and others had already received letters
Yeah,
from Mr. Kena.
yes.
And Mr. Bernard Hodges instructs, I think it is a PA, his PA, to say, no, send this email. So I think it's dictated to her
That's an attorney from Beckman's.
from Werksman's chair.
But on whose instructions would he have been writing to
For Mr.
do that? To issue those instructions to say don't, I mean, how Prasa or the acting CEO disciplines its employees, that's an internal matter.
Chair, I provide this commission with an annexure. So this I'm saying, Chair, that these people are so truthful to this commission. They are truly corruption busters. They tell us who they are. The first thing, Chair, they will apply the same rule to themselves. So it's quite clear that, and I think when Werksmans, that is why I said I welcome the opportunity to be cross-examined by Werksmans, because I'm going to read to their counsel this email and ask exactly the question, Chair. Somebody lobbied, and because their own people, Chair, people like Dingiswai or people like Martha, Hulele, are part of this group, they felt, oh, we can't discipline here. Yet, they were running a massive campaign at Prasa to discipline people for even things that are not even material and threw them out, Chair. It is part of the list of contracts they were investigating. And I think Mrs. Ngoye, she led with this paragraph, Chair, for me. And when I bring senior counsel to cross-examine, there will never be any other explanation, Chair. She let the cat out of the bag. When you look at the time, Chair, you ask an important question. The contract had already been in place, and I think it was negotiated in 2012. It was signed in 2013, and this is 2015, Chair. So this is, it has nothing to do with Sufambo. It has nothing to do with Prodigy. It had to do with the fact that they were implementing a mandate. They had this particular thing. But for me, when I saw this email given to me by even Werksman's own employees and say, look at what our company is doing. Chair, I provided a lot, and you ask a question. I didn't obtain anything unlawfully. But I want to salute those many employees at Werksman's who say, we work for this company. But we are unhappy. We have seen there are many wrong things that they're doing. This is one of them, Chair. So Werksman's said they're telling us about the irregular appointment of other people, but not theirs, Chair. They're disciplining others for others, and they're intervening that others should not be intervened, Chair. So that is why the Prasa that has been created of corrupt people. And when Martha was here again, Chair, she said, I'm being suspended because I'm fighting against corruption. It's so false. It's not true, Chair. It's not even supported by facts. That is why I offered this commission to present as much information, including this email written by Ms. It's coded, Chair, this thing, but the essence of it is telling Mr. Nati Khena, you can't proceed with it, Chair. And that is why Mr. Khena signed a letter of engagement with Werksmans. That is on their letterhead, on their own terms, which if, Mr. Soni, yesterday we had a huge debate about violation of section 217 of the Constitution. Chair, there's no better illustration of a violation of section 217 of the Constitution than what Versman did in this particular contract. I'll come back, Chair, to testify about it. So I'm simply saying, if we do 19 written by Ms. Ngoye under oath, Chair, she had deposed to this affidavit to this, and this issue was not there other than the investigations that they created with their list of contracts.
Let's go back to the acting CEO came after you. So are you saying in the end, okay, maybe I shouldn't say that, to your knowledge, did the persons to whom he had written letters to say, tell me why I shouldn't take action against you if these reasons are true, did they respond as far as you know, or you don't know?
I don't know, Chair. What I know, Chair, is that
no action was taken.
no action was taken, and that was at the instruction of Versman's attorney, Chair. It's in black and white.
Yes.
And I hope when now Mr. Kena comes here, he'll be able to say, I wrote back to Mr. Hotz and told him that what he's saying is completely out of order. I'm proceeding. Even after the matter has been finalized in 2017, the judgment on this issue happened in 2017, Chair. And most of those people were still employed at Plaza, including Mrs. Ngoye, including Mr. Holele. And other people are still there that I know, who served in the bid adjudication committee. Chair. Yet, the legal department, when Mr. Molefe first made the charge on Swifambo, they even said Swifambo and Siangena were approved by Mr. Montana. When they know that they recommended to the board and this were approved by the board. So they withheld even vital information from the board of Mr. Molefe, as it were.
So, speaking about the Swifambo contract, only leaving out others that you can deal with, you are saying, yes, I approved the Swifambo contract, but I didn't just approve it. There was a recommendation coming from, is it the bid adjudication committee?
No, Chair, I'm not saying that.
You're not saying that?
I'm saying I didn't approve the Swifambo
Okay,
contract.
you didn't, yeah.
It was approved by the board at
By
the
the board.
recommendation of the bid adjudication committee,
Which included?
which was chaired by Mr. Holele, and it involves other people, including Mrs. Ngoye.
Okay, okay.
And so you can see, Chair, so when you say that, you can't then say, we had asked several questions on the principal transaction to which no satisfactory responses were provided.
So what you are saying is, part of what you are saying is how, insofar as the questions that she is talking about, that she says they raised, may have related to how PASA awarded the Swifambo contract. She couldn't have raised those questions because she had been part of the people who recommended that Swifambo be awarded the contract. That's part of what you are saying.
Yes, Chair. If, let's assume, Chair, they were not involved in the negotiation. Okay? But here she's talking about the principal transaction. The board approved the principal transaction, which, let's assume she doesn't even attend the, let's say, the bid adjudication committee. But when documents are served, they are served to members of the committee as a committee, and they correct, they present that to the board. So, Chair, I'm simply saying, this 19, it's a manufactured story, and it also tells you, the Chair, that it's not Montana against Ngoye. It's, in fact, if you take it, it's Ngoye against Dingiswayo, Chair, because they provide different reasons for that. But I'm saying that with 19 couldn't have been, because the discussion on Swifambo, and I know the details on this thing at the back of my hand, Chair. The details on this thing was discussed in 2014. May 2014, the chairman was still Mr. Swiso Telezi. In 2015, it was Mr. So this was part of it. And for me, Chair, there's only one conclusion. And so I'm blunt on this, Chair. I'm saying Ms. Ngoye lied to this commission. He needs to be asked to explain this. And I'm hoping that my friends from Vexpan, when they come, Chair, they'll be able to explain simple things. On what basis did they write a letter instructing the CEO not to discipline people? Because we said we want a culture of accountability. We want, what is it called now, into the consequence management. Okay? So, but it doesn't apply to the people we love. It must apply to Montana. We even tell the board to go to court to say Montana approved a contract of 3.5 billion, which is beyond its. So they manufactured the reason check. When you look at and I explained on Friday, I went to a legal firm. I asked our procurement.
I want to stop you now because of the
Chair.
time. Yeah.
Thank you, Chair.
Mr. Soni, I know you may have still wanted to ask something, but I say we are way beyond 5 years. Let's talk about if I were to be available, Mr. Montana laughs. If I were to be available this coming Saturday, just that I don't know if I will be available. If I were to be available this Saturday, is there a chance that we could continue starting in the morning? Maybe we see how far we go, maybe up to lunchtime or so. From your side, Mr. Sonny? Yes. From your side, Mr. Montana?
Well, Chair, I'll be guided by you. I'll be available. I know I just have to confirm though, Chair, because I know that this weekend is my turn to look after the kids, Chair. So
Okay.
I think that may be an issue,
That might be an issue,
but
yes.
I can quickly negotiate that and see if I
Okay.
can come out and honor, Chair.
Okay.
Because I think it's very important that we
No, it's
conclude
it's very important.
this matter.
Okay, I'm going to indicate, and you will be informed if I am available for Saturday. But if I'm not available for this Saturday, unless something unforeseen happens, I would be available Saturday of next week. So maybe if we don't sit this Saturday, we could sit Saturday of next week. Does that sound?
No, Chair. I said, Chair, of course, that I'm losing money as a hustler.
Yeah.
But I think this, from a
It's-
national interest point of view, it's my priority, Chair. So I'll come.
Yeah, no, that's fine. As for next week, I will check what the situation is about evening sessions. My impression is that it's full already. But if I do have a space, so we might explore even sitting during the evening. Yeah. But thank you to everybody. We will then adjourn the hearing of Mr. Montana's evidence, and then arrangements will be made for him to continue on another day. I will adjourn this to allow the evening session team to get ready so that we can then start with the evening session. Thank you very much, Mr. Montana. You are now excused. We adjourn.
Chairperson, can we, from the process stream, be excused?
You are excused as well.
Thank you,
Yes,
Chairperson.
thank you.
afternoon, DCJ.
Yes. Are you ready?
We are.
Good afternoon, Dr. Dintwe. Your mic is not on.
Good afternoon, Chair.
Yes. The oath you took yesterday will continue to apply today. Okay?
Thank you.
All right.
Thank you, Chair. Before we continue with questioning, may I place something on record?
Yeah.
We received a communication from Sean Pillay attorneys on behalf of a party that is implicated in the evidence of Dr. Dintwe. They have provided us with a statement attested to by their client on behalf of a company, both of which are identified in the statement under pseudonyms. They say in the letter, we attach here to a statement by our clients which must be carefully studied, as we are not certain whether any of the information contained in the statement falls in the category of being classified. And then they continue to say, we take no responsibility in that regard. The first thing that we need to place on record, Chair, is that the fact that they purport to absolve themselves of any responsibility is not a statement that we accept that responsibility. It
Can't
remains
like
with
that.
them.
Yeah.
But nevertheless, we are checking the statement carefully. We will check it with the SSA so that we don't inadvertently release any confidential or classified information. For that reason, despite the invitation to put the statement to Dr. Dintwe in evidence, we will not put it at this stage, but at a later stage.
No, that's fine.
Thank you, Chair.
Okay.
Dr. Dintwe, are you at page 789 of Exhibit YY15, where we left off yesterday?
Yes, I'm on that page.
And you deal in paragraph 52 with the topic, as you describe it, executive overreach.
Yes, I do.
Evidence has been given on the topic of executive overreach by more than one witness to date, and there is an opinion that has been expressed that it is undesirable for a minister to become involved in the operations of the SSA. Another view that has been put is that there's nothing that makes such involvement in operational affairs unlawful or improper, but that such practice has been avoided by at least one minister who has testified, or by the minister who has testified, or the previous minister who has testified. What is your view in that regard?
And Chairperson, my view will be firstly be confined to our role as an oversight body and what problem is being posed by that kind of involvement or the executive overreach in general. The first point is that you have a situation where the ministers bring themselves into our oversight space. So ordinarily, we will not investigate the ministers, we will not even make findings as far as they are concerned. But an example of what the legislation provides is that the Minister of State Security shall have superintendence over the agency, over the intelligence service. Now, that superintendence, the examples thereof is that the minister gets involved in issues such as purchasing and leasing of property. And I'm just going to take that example and try to demonstrate our problem as the oversight. Now that we deal with maladministration, let's say, for instance, a property is being leased in KZN, and they do not follow the procurement process and so forth and so forth. It means that as and when we conduct our monitoring or our review, If we find that that particular process, I mean, the procurement process was not properly followed, it will mean that we will have to make a finding against the minister, because it will be the minister who would have made that kind of a decision. So that is a problem as far as we are concerned of that executive overreach or the involvement in operations, because we oversee operations in general.
Yes, we will, in due course, place before the chair an analysis of the legislative provisions dealing with the powers and duties of the minister in relation to the operations of the SSA. We're not going to deal in detail with it here, Chair, but merely to give this evidence, because the legislation does, at least on the face of it, give the minister direct oversight powers and responsibilities in relation to matters falling within the purview of the administration and operation of the SSA, at least at an oversight level. How that is applied, of course, is a matter of controversy, and certainly one of our submissions may be to you, Chair, in due course, that these issues should be clarified one way or the other.
No, that's fine. But let me ask this question, Dr. Dintwe. Why would it be a problem for you as an oversight body to make a finding against the minister?
It is because, Chair, the Oversight Act says that we shall monitor, review, and investigate complaints which involves the heads of services. So the heads of services are defined as a Director General in the case of SSA, as the Divisional Commissioner of Subsea Crime Intelligence, and also that other. So there is no provision, basically, which says that we can investigate, monitor, or even review their actions.
Oh, okay. No. Then I understand. But obviously, if a minister does what the head of the department is supposed to do, and in doing it, he or she acts improperly or breaches the law, then obviously you can say that what you were investigating was matters that fall within your jurisdiction. It so happens that one of the players is somebody who should not have ventured into that kind of issue. And then he ventured into it and you have to pronounce, but you didn't go out of your sphere of operation to deal with matters that were outside of your jurisdiction. So the subject matter would still be within your jurisdiction, but the person who would have acted in breach of the law or improperly would be a minister. Or are you saying your understanding is that the moment you hear that in this operation the minister was involved, you have to leave it because you don't have jurisdiction over a minister, even if the subject falls within your jurisdiction, subject matter?
I know that I would have provided the chairperson with a pedantic view.
Yes.
As far as the provisions are concerned, but
yes.
We have dealt with that issue.
Yes.
I have received complaints against the ministers
Yes.
previously,
Yes.
and I've worked on them.
Yes.
The position of the office is that we do not follow the rank.
Yes.
Or a person or an
Yes.
official.
Yeah.
We follow the activity.
The activity.
And
yes.
and that is the advice that has been proffered
Yes.
to myself. The Joint Standing Committee on Intelligence also asked our office whether they could refer certain matters that involves the ministers. But I think that the reading of the legislation, and I think that the legal team here will assist,
Yeah.
is to say that we look at intelligence and counterintelligence activities.
Yeah.
So it doesn't matter who's doing it.
Yes,
In fact, I think that even in the spirit of the legislation, if you like, it even goes beyond, because there is a provision here which says that I may also invoke the provisions of the Criminal Procedure Act if there is any other organization which is not the three that I've mentioned that gets itself involved in intelligence. So you can see that the intention of the legislature is to make the scope a little bit broader. We have dealt with the issue, and I think that our position, Chairperson, is that we follow the activity and not the person.
Okay.
So if a minister, by their action, brings himself or herself within the purview of the IGI's office, you will investigate, as I understand it.
That's exactly what I'm saying. And the example that I was giving, Chairperson, was to say that, let's say, a lease of a property. So there I'm not concerned who's doing it. If it's done by even a private citizen, as long as it is one of the resources that belongs to intelligence services, it will be an activity that I can investigate if there is any maladministration coming out of it.
But that does not mean to say that the legislation could at the very least be tidied up.
I've never ever had a challenge. I wish for a stage where there will be findings against a particular minister and maybe they take us on review. But from where we are sitting, because I think that a person sitting somewhere may think that now that the legislation does not say that you can investigate a minister, that then it means that we cannot investigate.
Well,
But
we'll leave that to a later
All right.
stage. Would you
Sure.
then deal with the examples you give in paragraphs 53 and 54 of your affidavit?
all right. Now, according to the Intelligence Services Act, as well as the regulations of the SSA, specifically here, is that when a member gets dismissed, for an example, and this is a case that I would have worked on, it was based in the Western Cape, then that member can appeal to the minister. And our view has always been that, but the Director General, the moment you say that the minister has superintendence, it means that a dismissal that is meted out by the Director General is tantamount to a decision of the minister, if they have superintendence. So it creates a problem because then the minister becomes a player and a referee at the same time, because it says that then that member will have to lodge an appeal with the minister.
The SSA member so dismissed may lodge a complaint then with your office, and that minister's decision may then be subject to your oversight, as I understand is what you're saying in paragraph 53.
That's exactly also what I'm referring to, Chairperson.
And what if a minister were to involve himself or herself in the operational matters of the services that fall under their superintendence? Would you investigate such a matter if a complaint arose?
I don't have a choice. I'll investigate it, but then you can understand the quagmire that I'll find myself in, because it will be almost like double jeopardy. The minister would have committed an error the first time around and the second time around. And in any event, the end result is that I have to recommend to the same minister again to rectify.
Now, you deal in the next section of your affidavit, Dr. Dintwe, with the ministerial delegation of powers and direction of payments. And you make out the case that this document, or this direction of payments document, has been used or even abused to undermine the provisions of the Oversight Act and the Intelligence Services Act, and to undermine the oversight role of the IGI. Would you explain, please, as succinctly as possible to the Chair how this comes about? And you deal with it in paragraph 55 onwards.
All right. Now, my submission there, Chairperson, is that these MPDs have been manipulated and used to undermine primary legislation. Because this is a document developed by the minister, and its main purpose is to delegate certain powers to the Director General. So, which means that basically the Director General does not have any powers to run that institution. So the MPDs are used to delegate. So it will be written there to say that, for instance, any procurement which is less than 500,000, the Director General can make a decision. Procurement of buildings for the provinces will reside with the Director General. We don't have a problem with that. It's a good instrument of punishment, a good one. But now it has been used over and over again to undermine and to blur the lines between what the role of the Director General is and what the role of the minister is. And it's creating a serious problem for us as an oversight. Because then we cannot really tell whose decision is it. Because if you delegate a power, the power still remains with myself. If I delegate the power to a manager in my office, I'm still a decision maker in that instance. I don't know if you wanted me to go a little bit deeper than that.
Well, do you have any examples of how this delegation has been used? As I understand it, paragraph 57, you say that paragraph 1.1 of the MPD reads, delegation refers to an institutionalized activity whereby certain activities and authority are handed down from the minister to the Director General and by the Director General to subordinate members of the agency. Do I understand you to be saying when the minister hands down one of his or her powers in relation to their authority over you, you might find the Director General or the Director General subordinates exercising that authority over you?
Exactly my point.
And that, I understand you to say, is undesirable because, in fact, you have oversight over those persons who may be exercising authority over you.
Yeah, that is our submission, Chairperson.
And you say that that has actually happened in your statement.
It has happened. There's a specific incident of December 2017.
December 2017.
Yes.
What happened?
All right. Now, in December 2017, we had a minister who served for a very short stint there, called Advocate Bongani Bongo. When he got there, he clearly had an instruction, Chairperson. I would have had some engagements with him, which were not recorded, unfortunately. But that was the period that they wanted to remove me from the office, that they didn't want oversight. And what happened is that...
If I may just interrupt, that is your opinion, an inference you draw from what happened.
It is an inference that I draw from that.
Yes, okay.
Yes, all right. It's an inference. Okay,
Yes.
now, what he did is that he then amended the MPDs. And they never told anybody what was wrong with the MPDs which were in place. And there were few amendments there, and I'm going to give an example of one, where they said that the Inspector General of Intelligence shall be clothed with the powers similar to those of a Deputy Director General. Yes, so let's call it a demotion. Like they started by demoting myself to say that now I'm a DDG. And in that MPD, obviously, the point that I think that we're trying to drive home here is that the MPD is secondary to the Oversight Act, which doesn't put me at that level. So that was the first problem. The second problem with the then MPDs was to say that in my absence, and the absence was not qualified, so I could be sick, I could be on leave, I could be on suspension and whatever. They said that the Director General of the SSA shall have the power to appoint an acting Inspector General of Intelligence. So they write there because they've been struggling. The Oversight Act does not, and it's a point that we conversed yesterday, to say that in my absence, no one can even appoint somebody to act in my position. I'm the only person who can do that. So I don't know if the Commission will see it as an inference, because I mean, it was straightforward that these are the people who want to action something, but they are preparing the ground so that when I'm not there, there will be MPDs in place, which will then say that Mr. Arthur Fraser at that time will then appoint an acting Inspector General of Intelligence. And that I'm actually subordinated to him because now I've been demoted to a level of a Deputy Director General or a head of a spending center, as they called it.
Well, let's just summarize that then, to show how the MPD was used or even abused, depending on which way one looks at it. You say in paragraph 62 that the MPD provided that your powers would be such that you would have the administrative authority and financial limits of a Deputy Director General of the agency. That would, in effect, make you subordinate to the Director General of the agency. Do I understand it correctly?
That's correct.
Over whom you exercise oversight.
That is correct, Chairperson.
Because he would then be the accounting officer and he would be senior to you.
That is correct, Chairperson.
And in relation to your appointment and your standing, you're appointed by the President. You're accountable to the JSCI, and your appointment and the appointment of the office, the person who occupies the office, is approved by Parliament.
That is correct, Chairperson.
The effect of the amendment to the NPD, you've noted, is that in your absence, the person being monitored appoints your replacement, even if on a temporary basis.
That is correct. That's exactly what happened, Chairperson.
And you have drawn the inference from those facts that these efforts or these amendments to the MPD were directed at undermining your authority. Do I understand your opinion correctly?
You understand my opinion correctly. Maybe also to add, to say that as we get deeper then towards the end of my evidence, you will see that there were other activities that were being carried out by the Director General and the Minister, which were sort of supplementary to this particular taking or amendment to the MPDs.
Right, you make the point in paragraph 63 that the MPD is subordinate legislation. You call it secondary legislation. And you make the point that for it to be valid, it must be consistent with the enabling legislation, the Oversight Act, and indeed the Constitution.
That is my submission, Chairperson.
Right.
One second, Mr. Victorious. You said yesterday in answer to one of my questions to Dintwe that the IGI is ranked at the level of Deputy Minister. What is the basis for saying that? Is it the remuneration, or is there some document that says that?
It will be the remuneration, that's how they determine that.
Oh.
But as I said, is that then we will develop something which looks like an agreement. So,
Yes.
because I'm not appointed in terms of the Public Service Act,
Yes.
we will have a document which is actually an agreement between myself and the employer.
Yes.
And in that document, it will tell me exactly what level am I and so forth. Now,
Yes.
the Act only says the conditions of service shall be determined by the President in conjunction with the Joint Standing Committee on Intelligence, and they shall not be downvariated, I have to rate, but they don't really use that word, by anybody during the tenure of the IGI. Yes. Maybe in the meantime I could be fine
Okay,
with that.
okay,
yeah.
no, that's all right. Thank you.
You detail your inference in paragraph 64 of your affidavit on page 792 and 793. And you say in short that the amendment to the MPD was part and parcel of concerted efforts by Mr. Fraser and later Minister Bongo to remove you from your position. Now, and if this failed to negate your oversight powers, that is quite a strong inference to make from the facts. Why do you draw that inference?
It is because it is based on the first sentence, which says that the mentioned MPD was issued by Minister Bongo following a flurry of recalcitrant correspondence received by the OIGI from Mr. Fraser regarding the complaints lodged against him.
Right.
And that formed the basis of that, because you could follow the letters. The letters would have started earlier, where they will say that I am not competent to possess state secrets, that they've got some intentions to revert myself, that I was spotted somewhere sitting with the members of the opposition. So you could see where these people are going, and the letters in my bundles, I mean in my evidence, will show you exactly that there was a concerted effort to remove me from my position.
You rely on what you've told the chair together with other evidence which provides the context for what you've told the chair, including other evidence from which you conclude directly that there was an attempt to remove you from your position. Do I understand you correctly?
I'm understood.
You refer,
That's
for example, in paragraph 64 to correspondence marked SD4. You don't by any chance have that letter with you there? Or must we wait for the bundle to be prepared before we place that letter on record? You see, if you look at paragraph 64, you annex copies of the relevant correspondence marked SD4. Do you see that?
I see that, Chairperson.
That correspondence will be in the bundle that you are going to hand up to the chair in due course.
That is correct, Chairperson.
You don't have it with you there.
I always keep those letters.
No, but as you sit there...
I don't have here.
Can you just summarize for the chair what that correspondence says?
All right. Now, in that correspondence, Chair, Mr. Arthur Fraser was telling me that he is going to revert me. And it was followed by a letter which then said that my security clearance has been withdrawn. I put them in a single annexure because it's three letters which follows each other.
Perhaps you should explain to the chair what preceded these activities on the part of Mr. Fraser, the fact that you were investigating complaints in regard to him. If you could just explain that to the chair. That's an important contextual fact.
Thank you very much. It started in a meeting, Chairperson, where I met with Mr. Arthur Fraser, his office manager, an office manager from my office and myself. And in that meeting, Mr. Arthur Fraser told me that the caucus of the African National Congress in Parliament had told him that he should tell me to withdraw or to stop the investigation. Because he said that the investigation that I was busy with was now becoming personal because it was a repetition of what was investigated. So I understood him to refer to the pen, which, yes, of course, was investigated. But he misunderstood which complaint I was investigating. The complaint that I was investigating was from a leader of the DA in Parliament, who said that this issue was never followed through. May you please investigate what happened? Because there were recommendations which were made. So what happened? So in that meeting, I disagreed with Mr. Fraser on the basis that you are not my messenger, you are not even my supervisor. I'm reporting directly to Parliament, and if the committee really wanted me to stop this investigation, they must tell me directly. So I'm not going to stop any investigation. And mind you, at that time, the committee members were not there. So that's where the problems started.
Okay.
Because I made him aware that I am investigating this particular complaint, and when I went back to the office, I wrote a letter because he had misunderstood what I was investigating. So it was a courtesy letter to say, this is the complaint as received from, I think I can mention Mr. Steenhuisen here, as received from Mr. Steenhuisen.
All right, then you can go back to the stage where you drew the conclusion that action was being taken. And the aim of that action was to either undermine your investigative capabilities, scope, or to remove you from office. That's
Yes.
the conclusion you drew.
Yeah, the conclusion that I then arrived at was to say that is either I should give in and say that I'm not going to continue with this investigation, or that I was going to be removed. But then the latter actually materialized, because then I started receiving then a flurry of correspondence, and they were saying only one thing, to say that I am not competent, because if I do not have security clearance, then I cannot continue to occupy this position.
All right, well, we'll come to the security clearance issue in due course. Let's just complete the fate of the amended MPD. You mention in paragraph 65 that you made a presentation to the next minister, Minister Letsatsi Duba, on the 6th of April 2018. What did you say to her?
I told her that her predecessor, so there was a frequent change of ministers during that period. So you had a minister in December, and then you had the other minister in April. So when I was still busy dealing with this issue, there was a new minister. So I went to make a presentation, in fact, to say that these are the MPD's minister, and we have serious reservations about this provision and that particular provision. And I also informed her that we were intending to go to court, because that was the advice that I had received, to say that we really need to go and challenge these MPDs because they were ultra-vires, but they were also inconsistent with the national legislation.
The primary legislation, the empowering legislation.
The empowering legislation.
And what did the minister then decide to do?
A day or three later, there was a message which just circulated on our intranet, because I'll be on the same intranet, to say that those MPDs have been withdrawn and that we are reverting back to the ones before the arrival of Minister Bongo.
So the MPD to which you objected, or the amendment to the MPD to which you objected, was withdrawn.
That's correct, Chairperson.
Let's then go to the next topic, the weaponization of vetting or security clearance. What do you mean by that? You deal with that in paragraph 66.
The chairperson would have had evidence where they say that there were parallel structures in the State Security Agency. One of the parallel structures was a structure that was used to vet different categories of people, let's say 2. Now, you will have that group that was seen as the opponents of state capture. I'm expressing an opinion here, Chairperson. And then you have the other group that could facilitate it. So we wouldn't be vetted by the same team or the same structure. You'll have the other structure which will deal with David because David is not liked. And then you will have the other one which will deal with Joseph because Joseph is liked. So they've been using vetting or the security clearance as a weapon to fight against those who were opposed to corruption and malfeasance in the State Security Agency.
Was this occurrence a rare occurrence? Was it a more frequent occurrence? Was there a pattern? What do you conclude from what you learnt in office?
It was a pattern. In fact, when we wanted some information, we got to the other office, and there were no less than 12 files that were never seen by the adjudication committee. So they will have an adjudication committee, they use the other term there, but after the investigator, the vetting investigator, and the polygraph and all those other things, they will then take it to this mini committee to then make a final decision before it gets signed. So we had files which were no less than 12, which were never seen by anybody, and they were being dealt with by this other structure that we say was parallel to the other main structure.
Right. You then, in your statement, in the paragraphs which follow, give 3 examples, and we will deal with those now, because those examples have been raised in other evidence before you, Chair. In paragraph 67, you make reference and you cite the Intelligence Services Act at section 14. That is the section which provides for the vetting of SSA members by the Director General of the SSA. Am I correct?
You are correct, that's correct,
Right.
Chairperson.
And because there's a provision in the legislation that says that you must also have a security clearance, similar to the security clearance that a member of the SSA must have, are you subject to these particular provisions that you quote here?
Yes, I am.
So who performs your security clearance, or who is responsible for your own security clearance?
It is the same person that I oversee, is the Director General of the SSA.
All right, and then you deal in paragraph 69 with another section, 14.8a of the Intelligence Services Act, which deals with the facility of an appeal to the minister in relation to anything that happens to your own security clearance, for example, if it's been degraded, withdrawn, or refused. You see that?
I see that, Chairperson.
And you refer in paragraph 70 to a related regulation under Chapter 26 of the Intelligence Services Act, which also deals with the possibility of a security clearance, including your security clearance, being withdrawn or downgraded.
Yes, I'm also subject to those regulations.
So if the Director General decides to withdraw your security clearance, that is in effect removing you from office. Is that not so?
It amounts to that.
All right. And we'll come to what happened in that regard in your case in due course.
But may I please also impress
Yes,
upon
please.
the Chairperson that it should not have been the case. Because there is a difference between the regulations which deals with the members of the service. I am not a member of the service myself. So the provision which deals with the regulations is found in the Oversight Act, Section 7(8), which says it deals with the regulations.
Section 7(4).
7(4), yes. It says a minister acting with the concurrence of the committee may make regulations regarding, and then you've got paragraphs A, B, C. I want to go to F, which says security clearance for the Inspector General and members of the committee. So these regulations were never promulgated since 1994. Yesterday I was counting the number of ministers there. We don't have those powers, but we've drafted them more than once. And because they deal with important issues, they also deal with the performance of the functions by the Inspector General, the reports submitted by the Inspector General, the suspension or removal from office of the Inspector General, and the termination of employment of the Inspector General. So in the absence of these regulations, which were never promulgated, they then revert to the regulations which deals with the employees of the service, as if I am an employee of the service.
So, as I understand what you are saying to the chair, is that properly regarded, there is no legislation which would allow the Director General effectively to remove you from office by withdrawing your security clearance.
That is correct.
Or there's no valid legislative or regulatory provision to that effect.
There is not.
Right. And we will later deal with an example where, as I understand your evidence, an attempt was made to do precisely that.
Exactly, and they invoked the same regulations which deals with somebody else other than the Inspector
Okay,
General.
we'll come to that in due course, but I'd just like to place on record, Chair, Section 7(4) of the Oversight Act, which reads, the Inspector General may be removed from office by the President, that is the body that appoints you, but only on the grounds of misconduct, incapacity, withdrawal of his or her security clearance, poor performance, or incompetence as prescribed.
That's what I can
So,
confirm that.
if your security clearance is withdrawn, it remains the prerogative of the President to remove you from office, as I understand that section.
That's correct.
Is that your view as well?
That is my view as well, Chairperson.
All right, let's deal with paragraph 72 and following, and that is the issues surrounding the security clearance of Mr. Robert McBride. What happened there? You deal with that at paragraph 72 and following.
I'm saying that it's a notorious fact that the tenure of Mr. Robert McBride as the Executive Director of the IPT was not renewed after the expiry of his contract in 2017. And if you follow the reason that was provided by Minister Becky Cele was to say that Mr. Robert McBride did not have a renewed security clearance, or he was not revetted. In the meantime, Chairperson, he had applied in time for the renewal. He did not have control over that because the State Security Agency is having that mandate to also deal with what you call external vetting. It will be a vetting of other officials outside the agency.
Including
itself.
IPID.
Yes.
Yeah. And including you, in fact.
Well, of course, yes, I will be falling under the external
Yes, but we've
vetting
made
as
that
well.
point.
Yes.
Did the matter then arrive on your desk?
And then before it arrived on my desk is that the decision was made in Parliament and he was given that reason and so forth. And I think that he was contemplating going to challenge that decision. But then he complained to me on something else. His complaint to us was to say that there was a team that went to this foreign country that I want to call Jupiter. I don't know how it was changed there. Yeah, but that country. So they went there, and the allegations were that Mr. McBride was working or was in cahoots with some people who resided in that particular country or in Jupiter, which is not a problem. The problem is that you cannot go and investigate an individual without having a registered project to say that we suspect that Dintwe, yeah, I think this is in the public domain. People have been accused of being handled by foreign intelligence agencies. So the moment there is that allegation, they must register a project, they must follow the operational directives, and it must be approved by the highest person in the SSA, who happens to be a Director General or his delegate. But in this instance, nothing of that sort was done. But there was a second problem. A second problem is that the people who were sent there were then accompanied by a certain gentleman that we refer to.
Don't mention the name
or
the company.
Yes, we are using a pseudonym there. I think we call him Mr. Ivano.
Yes.
Now, Mr. Ivano is a director of a company called Icebox Incorporated.
Both are pseudonyms.
It's also a pseudonym.
Yeah, it's very important to mention if it's a pseudonym.
Yes.
Otherwise,
I'll
certain
do that.
people will accuse the commission of not being responsible and mentioning
We will
names
get a
that should
complaint
not.
from the real Mr. Ivanhoe.
Yeah. Okay, continue.
But who is this Mr. Ivano? Mr. Ivano and his company were being investigated by the OIGI, my office, and they were also being investigated by IPIT, by Mr. Robert McBride. He had provided some equipment to the crime intelligence, and the procedure was not followed. There were also findings by a treasury that there was contravention of some of their directives and so forth. So that brought about that problem because obviously then it was Mr. Ivano who informed the State Security Agency that Mr. McBride was not upright. So in the meantime, Mr. McBride could not get his security clearance. His tenure could not be extended at IPIT because he was fighting against this person who is connected. There is evidence later which shows his political connections and to what extent was he involved also in fleecing the crime intelligence.
Yeah. As in many spy stories, they get quite complicated and it's difficult often to follow the plot. But as I understand it, Mr. McBride was investigating this company.
That's correct, Chairperson.
This company, or the director of this company, Mr. Ivanhoe, then lodged a complaint against Mr. McBride, which accused him of nefarious dealings in a foreign country.
That's correct.
So the very company that was being, and person that was being investigated by IPID under Mr. McBride was at the same time reporting to crime intelligence, I think it was, that Mr. McBride was not behaving appropriately or properly or lawfully in relation to activities in a foreign country. Do I understand it correctly?
But maybe we should add that it was not only a complaint, he then becomes a source or an informer who then even accompany the team that was going to investigate to Jupiter.
So the company or the director being investigated by IPID and Mr. McBride is now a source, protected as a source, and accompanies the investigators of crime intelligence to this foreign country. Do I understand that correctly?
You
That's
understand
the-
correctly.
That's the additional part of the plot that you
Yes.
delineate.
Yes.
Right, what happened?
And then they get to that country at the cost, full expenditure being carried by the SSA. And they get to Jupiter, they meet with the people that he had informed the investigators here that they have evidence of even offshore accounts that belongs to Mr. McBride. But they returned empty-handed because that was never, it was never reality, it was never the truth.
Yeah.
In essence.
But there's a further twist, and that is that this director and this company are actual service providers and potential service providers or bidders to the extent of tens of millions of rands to the security establishment. Am I correct?
For crime intelligence, to be specific.
To crime intelligence. And that you'll deal with in due course.
We will deal with that in due course.
Is there anything you wish to add then in relation to?
There is a damage. So they come back and they say that no, the information was negative. But by that time, there is somebody already appointed to act at IPIT. Mr. McBride is out already. So they've done that, and it is one of what we can call a modus operandi. They just besmirch you, and they just delay things, and they know that there is no truth in what they are alleging, but the prejudice was still suffered. Maybe we may not even call it prejudice to Mr. McBride, but maybe it is a prejudice to the citizens of this country, because at that time he was fighting tooth and nail to make sure that he reverses the damage caused by state capture, corruption, police brutality, and all those issues.
We've summarized these events, but they are detailed in your statement, and the chair has it before you. Let's
That's
move
correct,
on then to the facts surrounding the security clearance of Mr. Nkasana. You deal with that in paragraph 82 and following. What happened there?
In Mr. Nkasana's case, Mr. Nkasana gets appointed, they open a file to vet him, he signs, he consents to everything, and then they go through all the processes, and at the end, they qualify him, he then gets awarded top secret. There is communication to the minister, the then Minister of Justice, to say that no, this candidate is now okay, and then he resumes his duties. And then something happens between himself and the former president. There's a disagreement, there is a mistrust that he could charge the former president. They do not come back to him and withdraw the security clearance. What they do is that they then request his file, because then the file will be stored for the coming 5 years or until such time that you want to reinvestigate or withdraw. They go.
When you say they, you mean people within SSA?
Yes, I just want to see if the name, we didn't use the name. There are two names that I mentioned there, but they are senior
Obviously,
people.
pseudonyms, obviously.
No, those will not be pseudonyms.
Or those will be real names.
Oh, no, they are pseudonyms.
Okay.
Sorry,
As I
Chair.
recall, Chair, Mr. Kasana may have named those persons, or those persons may have been named, the persons
Yes.
who dealt with his security clearance. They were not operatives.
Okay.
But I'm not sure whether Rule 3.3s have been issued in that regard.
Let's look at.
Well, they're not named here anyway.
87.2. No, 87.2. The last but one sentence on page 801.
801.
Yes, Chair.
87.2.
It will be the first sentence on that page, actually. So it will be paragraph 872, which starts on 800.
The name in paragraph 87.2 can be mentioned He's received a 3-3.
Okay, that's the,
But anyway, you tell the story.
instead of the pseudonym. You say,
No, there's no pseudonym here.
on mine, there is a pseudonym on
Well,
paragraph 87.
there is a pseudonym for the first person mentioned in paragraph 87.2.
Yeah.
That pseudonym should remain. The second person mentioned in paragraph 87.2 has received a Rule 3.3, and you can mention that name. And they're two different people, although they,
Okay.
yeah, they're two different people, although mentioned in the same context.
All right. Thank you. So, Chair, after the 6th of March 2014, which was the date that the certificate was issued of top secret to Mr. Ngasana, few days later, and unbeknown to Mr. Ngasana, the then general manager, we call him Denny, in the SSA, gave instructions that further investigations should be conducted on Mr. Ngasana. The file was then allocated to a different vetting investigator who interviewed certain unidentified referees in KwaZulu-Natal, and those referees had been identified by Mr. Thulane Dlomo, who was then the Deputy Director General in the domestic branch of the SSA. Now, vetting is intrusive. They even ask funny questions. Sometimes they ask, are you a humanizer? Have you ever had a problem of drugs and so forth? So it's an intrusive kind of a method. Now, the reason why you've got a form that you sign, you are consenting, that you can go to the banks and check my transactions, you can do this, you can go even talk to my referees. Here in this instance, Mr. Ngasana's consent ends on the 6th of March when the certificate is issued. But then this general manager called Denny then takes the file again, gives it to a different vetting investigator, and gives them instructions that Mr. Thulane Dlomo will give you names, you must go and talk to these people in KwaZulu-Natal.
Oh, did you investigate this vetting process or this re-vetting process?
I investigated that and I called for some documents during the course of our monitoring.
Yes. And did you look for the file?
We could not locate the file. We could only get some other documents which were then given to us. Some of those documents, suspectingly, were not even signed. I think there's one letter that was not signed.
So the evidence which would have assisted you in your investigation to what you regard as an improper or unlawful re-vetting process, quite frankly, disappeared.
That is correct, Chairperson.
What do you say in paragraph 87.6 then?
Right. Now, what we found to be very strange was that when we looked at the digital vetting file, so remember that we could not get the physical file, but we could be assisted to get onto the system and check what they call digital. So because they cannot delete that, there will always be an auditable trace there. What we found was a letter which was uploaded there, which said that Mr. Ngasana's vetting process was not complete.
Is that correct statement of the facts? Was that a correct statement of the facts?
It cannot be a correct statement because there was a certificate issued and signed on the 6th of March 2014.
Correct. Was that letter ever signed?
This letter was not even signed.
So someone put that letter in a file, presumably intending it to be signed at some stage, but it never got to be signed. Is that correct?
It never got to be signed, and the chief directorate dealing with that advised or informed us that they had no knowledge of the author of the alleged letter.
Yes. You say in paragraph 87.6, the management of the chief directorate stated that the issue of the denial letter remains questionable. That means the denial of the certificate, does it?
That's correct, Chairperson.
There was no letter of denial written by the Chief Directorate, External Vetting and Advising. That does not mean to say, of course, that some parallel vetting process might have drafted that letter.
Look, certain letters, like in my office, you will
But
have...
that may be an unfair inference
Yeah.
on my part. So
I
perhaps-
understand, but what made it more strange was that if an official in my office writes a letter, they will write on top the reference or inquiries at least, even if I send that letter. This one did not indicate who at least the drafter is in the bare minimum.
All right. The conclusion you drew after all your own investigations in relation to whether Mr. Nkosana had a valid security clearance or not, what was that?
I would like to read that one because on paragraph 87.7, I think you are referring to that.
Yes.
Yes.
It is noteworthy that Mr. Thulani Dlomo's name featured prominently in the findings of the HLRP, the panel, concerning the rogue intelligence unit within the SSA, and reportedly took instructions from and reporting directly to the then president, Mr. Zuma. President Zuma,
Just before you go on, what is your source for that conclusion?
it is the high-level review panel. It is there.
Well, it may not be stated in the higher level review panel in so many words, but we can always check it. But what you're saying is you're relying on what is stated in the HLRP report. Is that correct?
That's correct, yes.
Of course, we don't have the full report. Certain portions of that report remain classified even to the Commission. But I'm concerned that conclusion that you draw may not be accurately reflected in the report. Are you satisfied that it is?
It is fun, Chairperson, I'm always amenable to us putting it on hold until we've checked those facts. And you are raising, Advocate is raising a very important issue. So I'm sitting with an unredacted version of the HLRP. And I think that everyone else may be having a redacted version.
All right. The second sentence, how does that read, or what does it read?
The second statement.
In 87.7.
All right. President Zuma relied upon the alleged lack of security clearance of Mr. Nkosana as a basis for instigating an inquiry into his fitness to hold office, notifying Mr. Nkosana of his intention also to suspend him.
So, your understanding of the facts which you investigated is that Mr. Nkosana was issued with a valid top secret security clearance.
That is correct.
Subsequent to that, a further investigation into his security status was conducted. You say that that was improper or not properly authorized. Am I correct?
That is correct.
So that his original security clearance remained in place.
It remained in place as far as my investigation could establish.
Notwithstanding that, you say that the issue of the security clearance, its status, its validity, and question marks around an alleged lack of security clearance were used as one of the reasons for questioning Mr. Nkosana's fitness to continue to hold office as NDPP, National Director of Public Prosecutions. Am I correct?
Yes, that's correct. Wouldn't maybe the Commission want, Chairperson, allow me to just mention that there is an abstract that I would have taken from an opinion piece, but it says here, it is absurd to suggest that a murder charge which resulted in an acquittal could conceivably affect a person's security competence. So the second round of vetting then revealed this charge of Mr. Nkosana, from which he was acquitted.
Yes, that's been canvassed in evidence. In fact, thank you, Mr. Lomo, but you say, as I understand it
I'm not
in
Mr.
your
Lomo,
statement,
Chairperson.
that
You said Mr. Dlomo.
Dr. Dintwe, you said Mr. Hlomo.
I'm very sorry.
You didn't even say Mr. Nkosana.
All right, let me repeat all that. It's noteworthy that the grounds on which the subsequent investigation into whether Mr. Nkosana should retain his security clearance or not was based on grounds that you say are entirely fallacious.
That's correct, Chairperson.
And you detail that in these paragraphs of your statement.
That's correct, Chairperson.
Where were you reading just before Mr. Torres asked you, where you say it, you started with it is, I'm not sure what you...
No, all right, yes.
Charge of murder.
Yes, it will be paragraph 85, where I refer to a statement made by Mr. Paul Ngobeni of the Progressive Professionals Forum, Western Cape. And then I had just went, it says a lot there, but I had turned to the next page, which will be page 800. And it will be line, not even a sentence, 1, 2, 3, 4, 5.
Oh, now
6.
I can see where it says it is absurd in the middle of a sentence.
Yes, perhaps for the sake of completeness, that comment should be placed on record, Chair.
Yes,
In paragraph 85, you say, Dr. Dintwe, that it is my submission that the vetting and security clearance of Mr. Nkosana was not properly handled. And you're referring there to the continuation of the investigation after the issue of the certificate, I presume.
That's correct.
The statement by Mr. Paul Ngobeni of Progressive Professionals Forum Western Cape elucidates my submission, that's your submission, as he writes, and I quote, or you quote, "It is disconcerting that Justice Ministry officials appear to conflate the issue of whether an NDPP is fit and proper with the issue of his security clearance. These are not the same. Security clearance is simply an official document indicating the degree of security competence of a person. This reflects a person's ability to act in such a manner that he does not cause classified information or material to fall into unauthorized hands, thereby harming or endangering the security or interests of the state. Security competence is normally measured against certain criteria focusing on his susceptibility to extortion or blackmail, amenability to bribes, susceptibility to being compromised due to compromising behavior, and loyalty to the state or institution. Measured against these standards, it is absurd to suggest that a murder charge which resulted in an acquittal could conceivably affect a person's security competence. In similar vein, a killing committed when Nkosana was a teenager long before he qualified to be a lawyer and before he was declared fit and proper by a court during the attorney admission process cannot be grounds for questioning his fitness now. As I understand it, you endorse those comments.
I endorse those comments.
I hope that clarifies that issue, Chair.
Yes, no, I understand the issue, yeah. I just hadn't seen where he was reading from.
Yes.
But he has told me.
Right. Then you deal in paragraph 88 and following with your own security clearance. Would you tell the Chair about that, please?
Yeah.
Before we do that, you've made it clear to the investigators and the legal team all along that you're not here to raise personal grievances.
That's correct, Chairperson. But before I go there, if you allow me, Chairperson, can we go back to 87.7 to say that the issue of Mr. Nkosana took the other turn and it ended up, I think, in the highest court of the land. I think that during my investigation, I would have also made some reference because by that time, when I was doing this affidavit and when I was doing that monitoring, that decision was then made. And the involvement of the SSA and the endorsement to say that it's so surprising that why would you go for the second round of vetting investigation without even informing the subject. It could also be part of that, and I will request Advocate Paul Peterson, but maybe we need to look at those decisions and just check what were some of the facts that could have influenced my submissions there.
Well, to the extent that you may be referring to the judgment of the Constitutional Courts, we have dealt with it. Mr. Pretorius was the evidence leader. We have dealt with it in relation to Mr. Ngasana. So Mr. Ngasana himself gave extensive evidence, but obviously he wouldn't have known some of the things that you discovered, I think, in your investigation. But he has given extensive evidence, and we have looked at that judgment. So we are quite familiar with it.
Thank you, Chair. So an earlier question.
Maybe I should just say also, not only are we familiar with the judgment, we are familiar even with the affidavits that were filed in that matter and the record of the Constitutional Court. The Commission has got all of those affidavits that were before the courts in relation to this matter.
Thank you very much. Yeah. So, Advocate Pretorius, Chairperson, had prefaced his question, his next question, by saying that, again, this should not be taken as a personal grievance. What I've done here, I've taken examples of different people that, in my opinion, were opposed to fraud in government, malfeasance, state capture, corruption, if you like. So I've taken them and I'm trying to create a pattern here so that the chair can see how did this parallel structure operate.
Yes, well, I would say while there is certainly something to be said for the view that it shouldn't be seen as personal grievances. On the other hand, it's important to make sure that you don't end up not putting before the Commission what should be put before the Commission in the interest of the office, as opposed to in the interest of a particular incumbent, but in the interest of the office, because you're now too apologetic that you may be seen as ventilating personal grievance. So it's a striking of the balance. Okay.
Thank you, Chair.
Yeah.
And of course, these matters do deal with the Office of the Inspector General of Intelligence and the vulnerabilities related to that office.
That's correct, Chairperson.
Would you then tell the Chair what happened in this regard as you deal with it in paragraph 88 and following?
So my security vetting was done and it was completed. There was, in fact, I think some threats from the other political parties who were saying that the president was taking too long to appoint me because the parliament had already voted in November of 2016, and here we are talking around January, February of 2017. So my security clearance was done in an extraordinary kind of speed, if you like. I think that they had a little team just to deal with that. So I got the certificate. Yes, of course, there were some issues there, but they were not worrisome. So I got the certificate. The problem only arose at a later stage.
So you were duly vetted before you assumed duties as IGI, and you were given a top secret security clearance, correct?
That is correct.
What is the period of validity ordinarily of a security clearance certificate?
It is not legislated, but they will write it there. They will say that this will be valid for 5 years.
And you raise the issue of the exercise of a power or an alleged power to re-vet you. And that occurred during 2017 and 2018, correct?
That's correct, Chairperson.
What was the
Few months
background?
after the occupancy of the office.
So you suddenly find yourself subject to a re-vetting process, is that correct?
That's correct.
What were the circumstances surrounding this? You deal with that in paragraph 90 and following.
90 and then follow it, yes. May I please just refresh my mind? So I think that I would have dealt with paragraph 90 where I said that Mr. Fraser was aware of the investigation that I was busy with.
So you were investigating Mr. Fraser based on a complaint received by your office, is that correct?
That is correct.
Right.
And he was aware of that because I would have written a letter to him saying him that this is courtesy.
Right.
I am in receipt of a complaint which implicates you.
Right. Did he make any requirement of you in regard to the source of your information?
Yes, then he wrote to myself saying that he has a counterintelligence mandate, and his interpretation thereof was to say that if somebody comes to my office and reports, I must tell him if they happen to be in possession of classified information.
So he says, well, I have a counterintelligence mandate, you must give me all the information concerning the complaint against me.
Exactly, and the reason why he was saying that, he knew that that matter had to deal with the PEN investigation. So the PEN investigation had lots and lots of documents that were classified.
All right. Just maybe opposite to mention it now, but I understand it from a source in the public domain that at least one of the PAN reports, or part of the PAN reports, was leaked to the Amamogani news service. Is that correct? Am I correct?
That is correct.
Right.
But there would have been a leak in 2014 before I came to that office in the city press in that instance.
Right. Did you accede to
Just one
Mr.
second,
Fraser's
Mr.
demand?
Just 1 second, Mr. Proterius, for the transcribers, the reference to PEN report and PEN investigation is PAN, just for them when they do the transcript.
And they call it a principal agent network.
Yes. Okay.
Did you accede to Mr. Fraser's requirement that you disclose this information to him?
No, I refused. And I wrote to him telling him that his belief was erroneous, that I should report receipt of all classified information to his office, and that would defeat the purpose for which OIG I was created.
What happened after the lodging of the complaint that you were investigating in respect of Mr. Fraser? What happened thereafter?
He then wrote a letter to me saying that he is instituting what he called, he launched a counter investigation against.
On what grounds? On what alleged grounds?
In the first letter that I received on the 8th of November 2017, I'm taking an extract out of that letter. He said that the Inspector General had met representatives of political parties in Parliament and had on that occasion received classified information, which information relates to the State Security Agency and its activity. So that was the accusation.
So let's just put that in context so we understand the plot here. The Office of the Inspector General of Intelligence receives a complaint.
That's correct, Chairperson.
Included in that complaint is the disclosure to you of a classified document or documents.
There wasn't, in fact. His moles got it wrong.
All right.
Yes.
Well, that's an incorrect fact upon which Mr. Fraser appears to have acted.
Yes.
But there is an allegation then. Let's get it step by step.
That's
straight.
correct, Chairperson. It's an allegation that is making
The
against
Office
him.
of the IGI receives a complaint. It is alleged or believed incorrectly that as part of that complaint you received classified documentation.
That's correct, Chairperson.
You are then requested by Mr. Fraser to give that classified information which he incorrectly believes you've received.
That's correct, Chairperson.
You refuse.
That's correct, Chairperson.
He says then immediately after that that he's launching a counter-investigation against you for receiving classified information as part of the complaint which you're investigating against him.
That's correct, Chairperson.
All right, I think we understand that. What happened then?
That is after he had launched
You're
the
referring,
counter-investigation against you. What happened?
All right, but I would have wanted to deal with the latter part of the same letter.
yes,
Yeah.
so
Of
please
the-
do so. You deal with that in paragraph 91.
Yes, of the 8th of November. That paragraph further said, Section 26 of the Intelligence Services Act, 2002, 65 of 2002, and Section 4 of the Protection of Information Act, 1982, Act 84 of 1982, and I think it's an SIC there, but that's how the letter was, and undermines the agency's ability to fulfill its counterintelligence responsibilities as defined and set out in Section 21B of the National Strategic Act 1994, which includes information security.
All right, well, let's just briefly examine the logic of Mr. Fraser's stance here. The Office of the IGI must investigate the activities of these security services, including the SSA, correct?
That is correct, Chairperson.
Does that mean that you would inevitably, seems logical to me from the outside, that you would inevitably have to have access to classified information?
Always, it's a daily thing.
And there could be no reasonable interpretation of your powers and duties to say that you can investigate the procurement of stationery and leasing of buildings, but you can't deal with classified activities.
There wouldn't be. That is why you can see the Chairperson on paragraph 91 that is struggling, is bringing in the laws that are not even empowering, that are not even establishing the Office of the Inspector General of Intelligence, that does not even deal with the appointment of the incumbent and so forth. So those laws may not be applicable to myself in any way.
So, but it seems that they're interpreted and applied in such a way as to say that if you receive classified information in the course of a complaint being made to your office, you are somehow transgressing the law.
Yes, that's exactly what the purport of that letter was.
Well, I'm sure that the chair will, with our assistance, deal with the legalities there. Right. What happened then? You refer in paragraph 92 that there
Yes.
were further letters sent to you.
Now, on the 13th of November 2017, remember the first one is the 8th of November. On the 13th, he then writes a follow-up letter in which he reiterates that I was in receipt of unlawfully obtained classified information from representatives of political parties in Parliament.
Right. And you, at the top of or at the end of paragraph 92, what did the Director General state in addition?
He then refers to section 710 of the Oversight Act, and only that line, which says that the Inspector General shall comply with all security requirements applicable to the employees of the agency.
So he was saying that the fact that someone had a classified document, you must now report to someone else.
That's correct, and a failure to do so will be in contravention of 710.
Right. Now, what was the culmination of this series of events? You deal with that in paragraph 93.
Okay, then, and Chairperson, I mean, they were following each other. That's why I said earlier that I think the Commission would decide if it was an inference that I was drawing with regard to the MPDs. Because you can see the frequency of the letters there. One message and one message only. Then on the 15th of November, again, he writes, in which I get informed that SSA will be revetting me because I had not reported or disclosed to the Director General the fact that I was in receipt of unlawfully obtained classified information.
Right.
But there is something very interesting about that letter. This letter gets delivered by the DG himself. We are not in Pretoria, we are in Cape Town, so we've got offices on the 18th floor. Mine will be on the smaller passage, his will be at the corner. And his secretary or PA then tells me, knocks at my door and says that the DG would like to see you. And I said, no, it's okay, maybe in 10 minutes I'll be done with what I'm doing because I was doing some preparation. Then he comes there with that letter, he puts it on the table, somehow violently, and he says that, sir, I have decided to revet you. And he observes me, he was looking at me. And I think that I made him very angry because I then took that letter and I'm demonstrating, Chairperson, I just put it aside and said that, hey, I will see that when I get back to Pretoria. So I did not show him any signs of frustration or of fear and whatever. He actually left my office an angry man on that day.
But he didn't want any delay in you receiving this letter.
There was no reason. Our headquarters are in Pretoria.
Yeah.
When we are in these even smaller offices,
Yeah.
just for the administration to go to the committee, make your report and come back here.
Yeah.
In fact, our trips were not even arranged collectively. He went there and I happened to be there. I think that earlier that they said, oh, this man is around, let's type this letter. And sort of spoil my stay in Cape Town.
So, just to summarize then, Dr. Dintwe, you receive a complaint from a member of parliament.
That's correct.
That complaint deals with the principal agent network.
That's correct.
We know from other evidence, at least in principle, that implicated in the PAN report was Mr. Fraser.
That's correct, Chairperson.
Mr. Fraser then says, I want classified documents that you've received as part of the report. Correct.
That's correct.
He then, you say you're not going to disclose the contents of the report to him at this stage, or whatever you say to him.
That's correct. In fact, if this was not a leader in parliament who is a well-known prominent person, if it's other complainants, I don't even disclose the complainants beforehand to the implicated parties. I assure them confidentiality.
Anyway, it seems that Mr. Fraser is concerned, to put it at its lightest, that you are investigating this complaint without disclosing information relating to the complaint to him.
That's correct, Chairperson.
He then decides to revet you.
That's correct.
And the grounds for the revetting are exactly your handling of the complaint against him.
That's correct, Chairperson.
And then what happened what happened shortly thereafter? You refer to a telephone call you received in paragraph 94.
Yes, so when I was about to leave, and I was then in the aircraft coming back to Pretoria, then I received this telephone call. The person informs me that he was instructed that I should be revetted. So he's introducing himself as a vetting investigator, and he's asking me, hey, what is your availability? How soon can you get to Pretoria so that you can fill in the form?
Then what happened on the 3rd of December 2017?
Now he writes again on the 3rd of December 2017, and he advises me of an impending investigation by the SSA regarding the leaking of a classified OIGI report, a copy of which letter is annexed, so I annexed that, okay, but I don't have it here, Chairperson. He mentioned that he was informed that I had been uncooperative with the revetting efforts of the SSA. So in other words, that was just another follow-up letter without giving me further reasons, but here he's trying to bring something again and say that the OIGI report was leaked.
You then deal with the applicable legislation.
Yes.
Did Mr. Fraser give you an instruction, or did he purport to give you an instruction that is referred to in paragraph 98?
Yes, it was. I saw it as an instruction. May I continue and just...
Yes,
read
please,
that
you
part?
tell your story.
Okay.
And if you need to refer to the legislation and its import, please do so.
No, all right. I don't know, I will be directed by the evidence leader, but I think that I've submitted earlier to say that, in fact, there are no regulations which deals with my vetting in any event. They are just absent. Yes. So I was instructed by Mr. Fraser to cooperate with the SSA in the process of my revetting and the imminent investigation into my alleged conduct. And in the letter that was later sent to me, I would like to read that into record. It's just a paragraph, Chairperson, if you allow me. It will be on paragraph 98. The above notwithstanding, your attention is drawn to the media reports of today, 3 December 2017 in the Sunday Times, concerning classified reports of the Office of the Inspector General for Intelligence, IGI. It has now become as a cause for concern that classified reports of the IG have been leaked some 4 years after its finalization. You are hereby advised that the matter of the said leakage will be investigated, and as such, the cooperation of the Office of the Inspector General of Intelligence is required.
And then in paragraph 99, you received further information.
And then I was further informed by him again that I was to be revetted, because now he's adding something novel there. He says because he was in receipt of disturbing information, impacting upon my security competence. Yeah. But he never told me what is that information to date. I don't know.
Did you later find out what the disturbing information was?
No, I've never established to date, Chairperson.
You refer in the second sentence, paragraph 99, to disturbing information. What is that?
It's a recollection that I make, because the first letter was saying that I was in receipt. So I'm saying that the only inference that I could draw from that is that this disturbing information is about me receiving, because there was no intervening an issue where he would have amended or changed the initial accusation.
So this was a suspicion that you had, that this was what he was referring to?
Yes.
He never told you what he was disturbed by?
No, he never told me.
You drew the conclusion that it was that you'd met members of parliament? You assumed that or suspected that.
I actually just assumed.
Yes, and you do say that,
Yes.
and you say some credence for my suspicions was confirmed in the report of the high-level review panel,
Yeah.
where it is recorded that Mr. Fraser had alleged that I was, quote, spotted, unquote, meeting members of the opposition. What do you say to that?
Chairperson, it's a disturbing thing. I hope that one day, even if it's not myself, that somebody in that office or that office will say that we've been very mild about what happened here. And again, generally, what is happening in the country. How do you follow a head of a constitutional body, surveil them, intercept them, and even spot them, and you even confirm? I think, Chairperson, that may be treasonous, to say the least. I think that it's just sheer criminal. And I'm also able to refer to some of the other occasions where he would even write a letter to me and make me aware that we are aware that we've been meeting this and other person. I'm in possession of those letters. The team is in possession of those letters. I think it's a serious thing. I really got disturbed here to say that how do you spot a person who's doing his job?
Yeah, no, it is quite something quite serious.
Right. So you say, and you stress, in fact, in the last part of paragraph 99, that, of course, it's your responsibility to meet with members of the public, with the responsibility of members of your staff to meet with people who are raising complaints and to receive information from them, whether classified or not.
That is correct, Chairperson.
You've given that evidence.
Yeah.
And you also refer in paragraph 101 to section 7(8) of the Oversight Act, that where you receive information, the disclosure of that information is controlled by the provisions of section 7(8). You can't just willy-nilly give it to anybody.
If I had to follow that process before I come to the commission, you can just imagine the accusations that I was going to get if I disclosed to Mr. Arthur Fraser. It means that before that disclosure, I am enjoined by that provision that I should follow. I should inform the Minister of State Security, and I should also inform the President.
Yeah. But as I understand, the Director General's retort to your position was that his powers overrode any other provisions.
That's what he was telling me, and it was in the letters also. Chairperson, may I say that these letters were part and parcel of my application that I would have placed before the North Gauteng. So
Yes.
they are, majority of them are declassified. So that we just wanted to clean our house and tighten few screws. But you can see that I'm quoting extravagantly from them. It is because they are actually declassified.
Right. In paragraph 103 and following, you deal with the legal provisions and you give your interpretation of how these should be applied to the particular facts that you have related to the chair. You see that?
I see that. And those are the intelligence services regulations. Yes.
And in paragraph 106, you say, beyond the clear conflict of interest apparent in Mr. Fraser's claim to information in this instance, of course, he was claiming information relevant to your investigation of him.
Yes.
It is stressed that the IGI does not report to the Director General or any of the ministers responsible for intelligence services, should read. He, she is accountable to the JSCI. There is no legal provision requiring me to account to the Director General on any information acquired in the course of the discharge of my duties. Correct.
That's correct.
And his claim to have counterintelligence responsibilities, in your view, doesn't supersede that.
Not at all, Chairperson. It does not supersede that.
But in any event, arising out of all this, Did Mr. Fraser then initiate a process regarding your security clearance?
That's correct, Chairperson. I'm dealing with that, I think, on paragraph 108.
What happened in paragraph? What happened on 28 March
Okay.
2018 as you described in paragraph 108?
On the 28th then of March, Chairperson, I was served with a letter from the Director General, signed by him, informing me that the security clearance had been withdrawn with immediate effect, based on the following reasons. Very interesting. The first one was to say that failure to exercise my duty to report and action breaches of disclosure of classified information in or from the Office of the Inspector General of Intelligence. That was the first reason provided for the withdrawal.
So every time you receive a complaint, which might include classified information, according to this, you must go and report immediately to the SSA Director General, whom you might be investigating in that very complaint.
That's correct. And it was now becoming a harassment, Chairperson. You can see it's different letters, one accusation. I'm trying to write back to him. I'm trying to educate him, basically. Because at a particular point, I said that maybe I should sit down and assist this gentleman. And that was one of the reasons. The second reason was that I failed to execute my fiduciary duty as the Inspector General of Intelligence towards the intelligence services by obstructing the due administration of justice. The third one was that I defeated.
I'm sorry, that second one,
Yeah.
the allegation was that you had failed to execute your fiduciary duty as the Inspector General of Intelligence towards the intelligence services by obstructing due administration of justice. What did you understand that to mean? Or did you?
I never even bothered to understand that, because I mean, I was talking to my colleagues and I was saying that now he's even accusing me of criminal offenses.
Yes.
That is actually a criminal offense. So I was telling somebody, my legal advisor, to say that if Mr. Fraser was my employer or my supervisor, he wouldn't even be able to charge me with this. So the reason why I decided not even to want to understand that to date, it is because it was clear that he was clutching at straws and he was just acting ultra vires. He could not find any piece of legislation really that he could use to deal with me.
And the third one was defeating or obstructing the ends of justice by such failure. And the fourth one, failing to comply with the request to submit to revetting. Those were the four.
Yes, the fourth one at least I understand. The fourth one I understand again. The third one, defeating and obstructing the ends of justice. This was a sign of a person who had started to harass me, a chairperson. He went beyond that. It was just a pure harassment.
All right, so to summarize the facts, at least up to this stage, you receive a complaint from a member of parliament.
That's correct, Chairperson.
That complaint concerns Mr. Fraser, the Director General of SSA.
That's correct.
Part or involved in the complaint is the PAN Principal Agent Network report.
That's correct, Chairperson.
You immediately then are instructed or required by Mr. Fraser to disclose what he says is classified information to him.
That's correct.
And he gives the reasons that he has given. But the culmination of this exchange between you, the investigator, and Mr. Fraser, the person being investigated, As I understand, the train of facts that you're giving now is the withdrawal of your security clearance.
Yes, that's correct, Chairperson.
Right. These facts, of course, may be contested by Mr. Fraser, but he'll have every opportunity to come and do so. But as I understand your evidence, it's based or corroborated by documentation in your possession, which you will attach in the bundle to the chair.
That's correct, Chairperson.
Right. What happened then on the 5th of April 2018?
Now, that's what actually broke the camel's back, Chairperson. On the 5th of April, then, I received a letter which barred me from my own office, from my own premises, Chairperson. An extract from that letter, it said, "You are hereby advised that as your security clearance has been withdrawn, you are no longer authorized to access classified information and restricted premises."
Would that include your office?
It will include my office because I'm in restricted area. I'm sitting in the same office with the minister, with the deputy minister, with the head of National Intelligence Coordinating Committee, with the head of the ICCS.
Right. What is the effect of that communication for the occupation of the office of the IGI? I'm talking about office here in the official sense.
It was brought to its knees. There I was, Chairperson, and of course, I didn't go to the office because I was scared that there could be standoff, maybe a physical fight between my protectors and the security officials. So I wanted to act as a responsible person, and I decided then to take that.
Let's just understand the import of these communications to you. It was effectively to remove you both from your physical office and from your office as Inspector General.
That's correct. But my other import is that even go beyond that and close that office, because that will be the ultimate impact.
It could not operate without you.
Without the increment.
Yes, so there is, in fact, not only you are removed from the office, but the office is effectively shut down.
That's correct.
And of course, the complaint against him could not be investigated further once you were not there.
That's correct, Chairperson.
Because even if you could authorize somebody in your office to conduct the investigation, they would only conduct it on your behalf. And if you are not there, you have been removed, nobody can conduct any investigation lawfully.
I've been warned, Chairperson, not to decide what will be relevant and irrelevant.
Yes.
And let me also mention that there was an email, an Outlook email, which got sent to the EXCO, my EXCO now, my managers in the office, informing them that they should not provide me with anything. They should not even communicate with myself because my security clearance has been withdrawn. That Outlook is available also. So I think the point that you are raising to say that I will not be able to delegate, but again, he's cutting the communication between myself and the other members who could then continue with the investigation in my absence.
Yes, okay.
After this series of events, did you approach the courts?
That's correct, Chairperson.
What relief did you seek?
It was a Part A and a Part B, and Part A was on agent basis. Part A was just to say that my security clearance should be reinstated.
Right.
And along with that, there were some issues of security. So he would have worked on my security.
Yes. Did the then minister intervene?
And then the then minister
What did she do?
Yes.
What did she do?
She reinstated that on the 11th hour. So we arrived at court because the matter was set down.
You had
Was it
already
opposed?
launched.
Yes, there was an opposition
From
from
Mr.
Mr.
Fraser.
Arthur Fraser.
So he opposed your application to, amongst other things, restore your security clearance.
That's correct.
What did the minister do? Was this at the doors of court?
Let's say that, because when I was there, then they called, and my legal representative was saying, we think that part A of your application may have turned, mute, if you like. I don't know if they use that word, but then they said that there is no need for us because they've given you exactly what you are praying for.
So the minister then intervened, reinstated your security clearance certificate
Yes,
or status.
yes.
Yeah, let me just go back. You launched your application in the High Court. Is that
That's
right?
correct. Yes, correct.
Did Mr. Fraser launch any affidavits to oppose that application?
That's correct.
And was he the only one who was opposing, who launched papers to oppose?
Chairperson, I really can't remember
can't
my
remember.
application. My court application is part
Okay,
of the
no,
bundle.
We
Yes,
don't
the
have
papers
to
will
check.
I
all
can't
part of the
remember
bundle.
if, I don't think he was the only respondent.
Okay, no, but we don't need to check. I just want to get that
Oh,
ready.
okay, thank you.
And you had not filed a replying affidavit, you had filed a replying affidavit by the time
I had,
you had.
yes,
And the matter was to be argued.
that's correct.
Yes,
Chairperson.
and then the minister intervened. I assume the minister was one of the respondents.
The minister was one of the respondents.
Yes, but she had not filed any papers.
The legal representative, as and when he was communicating with mine, he was indicating that he was representing both the minister and Mr. Arthur Fraser.
Oh, okay, but you
But there was no affidavit from the
from
minister.
the minister. Okay, all right.
Yeah.
And the effect of the intervention of the minister, was it that your security clearance would be reinstated, therefore there should be a settlement and a withdrawal of the application, or was it that an order was granted by consent?
There was no order. They were very allergic to that,
Oh.
because there was other issue of security that I
Yes,
think they were
yes.
very much worried about.
Yes.
So they did that, but we just felt that there was sufficient intervention, and I was satisfied with that.
Okay.
Maybe also to mention that it was on the same day that then I get called by the then chairperson of the Joint Standing Committee on Intelligence, Mr. Charles Ngakula, and I'm not implicating him here, who then said that there is a decision to move Mr. Arthur Fraser from the state or out of the state security agency.
Oh, okay.
So those things happened
things happened at the same
simultaneously,
time,
and
yes.
I thought that
Yeah. So
it's
ultimately,
fine.
you withdrew the application, or it was just postponed Senate year and it was not pursued?
It was postponed. I remember I said that no, for now we will not be
It's fine,
withdrawing.
yeah.
Yes,
Okay.
but we have never ever really pursued even the
Yeah.
part B of that.
Okay, no, that's fine. Mr. Pretorius, I think let's take some adjournment.
Sure.
Let's talk about how far we will go so that we are all on the same page. Otherwise, I just push everybody to 12 midnight. I don't know, Mr. Pretorius, what your own assessment is.
Chair, we
But,
can go as far as we can
Yeah.
to whatever time you deem necessary.
Yes, yes.
You know my views on this, they haven't changed. But we won't finish tonight.
Yeah, no, I think we won't finish tonight. Maybe we go up to 8:30, on 9.
I'll take your main prayer, Chair, not the alternative.
Okay, all right. Okay, let's take a 10 minutes adjournment, and then after that we'll come back and go up to 8:30 and then take it from
Thank you, Chair.
there. Yeah. Okay, we adjourn.
hour, I think we might get quite far.
Sorry?
evidence that you've just given, perhaps, because it's well set out there, you should, if you will, read that paragraph onto the record.
Paragraph 11, I'm saying that I am required by law to serve impartially and independently and perform my functions in good faith and without fear, favor, or prejudice. This requires the protection of the basic tenets of an independent institution, namely the manner of my appointment, my security of tenure, and then in brackets I also say, and due to the nature of my work, my security of person, the budget of my office, and the manner of and the grounds for my removal. The importance of the independent and autonomous functioning of an oversight body is underpinned by the international best practice and has been applied by our courts to corruption-fighting institutions, as in the Glenister case, and oversight bodies of other state institutions, as in the case of McBride. In view of this, the power of vetting and determining security competence given to the SSA should not be permitted to be used in order to undermine the independence of the OIGI or stifle its investigations.
You deal in the next section, Dr. Dintwe, with what you term questionable intelligence reports. And you say in paragraph 112, mysterious intelligence reports have been used repeatedly to deal with or target those who are regarded as opponents. And you set out in the following paragraphs some examples of this. Perhaps you could summarize these for the Chair.
I'll summarize, Chair. The first example is what happened in 2017. So in 2017, I received a complaint, this time from the Democratic Alliance, and it was followed by the other one from the South African Communist Party. And the third one was from a private citizen residing somewhere in Gauteng. And in that complaint, I was requested to investigate the veracity of a report that was used by the former president, Jacob Zuma, to recall Minister Prof Gordhan and his then deputy, Mr. Mcebisi Jonas. And I want to just quote what it said because it's very important later. It becomes very important later. It says, an investigation into allegations surrounding an intelligence report allegedly used as a pretext for the recall of the finance minister.
What was the allegation? You can summarize it because there has been evidence before the Commission. You deal with that in paragraph 114.
The allegations were, and it was open because South African Communist Party went onto the media to report that they've reported the matter to the OIGI, and the person who was speaking on behalf of the organization was the now deputy secretary, first deputy secretary, Mr. Mapaila. And he had said that in one of the meetings of the top 6 at Luthuli House, they were briefed verbally by the former president that he is in possession of an intelligence report which alleges that Minister Pravin Gordhan and Mr. Jonas were overseas and were going to meet with some foreign agents who were calling for a regime change in South Africa. And he also informed them that he was going to recall them from the trip, not a recall from their positions. They use the same word. But yes, of course, I think it's a matter of public knowledge that they were then recalled. He never told them what was the source of that report. Because I think that, and they say that the expectation will be that it will be coming from one of the three state security intelligence services. But they were not in knowledge of who exactly would have briefed the president on that.
It was referred to or assumed to be an intelligence report of sorts.
Yes, according to the witnesses that I talked to, and in high place.
Right. But in any event, you were asked to investigate the source of this report.
Yes.
And did you investigate?
I investigated the matter.
And you say in paragraph 115, the core issues that needed to be investigated were the origin, authenticity, and veracity of this alleged intelligence report. Who, to your knowledge, was the person, or who were the persons in possession of this report?
It was only President Zuma who said that I'm in possession of that.
Did you ask him for the report?
I then requested a meeting and requested for that report.
And what happened at that meeting, and what was its conclusion?
In that meeting, he was welcoming. It was a very, very, very nice meeting that I had with the president. And he explained to me that when time is right, he will then write to me, and he didn't say he will send me the report. In fact, maybe let me paraphrase what he said. He said that he is hearing people saying intelligence report and so forth and so forth and so forth, and that report may not be existent because he's not only dependent on written reports. And he said that I saw something on the website, somebody was waving a report. I remember the incident where somebody was waving the report. It was Minister Pravin Gordhan who was having a one-pager typed in very, very, very big
I also seem to think I've seen on television somebody saying.
Yeah. So the president in that meeting never said that there's a report that he will send to myself. He only said that when the time is right, he will explain this so that I understand that matter. And that's how I left his office.
So you went to him as part of your investigation?
That is correct, Chairperson.
And did you ask him whether there was such a report, and you asked him to give it to you, but he didn't commit himself to whether it existed or not, or what was it?
I did that, but our engagement was followed by a letter. So in a letter where I was requesting a meeting, I had already put a paragraph there which says this is the purpose of the meeting, and I request the president to favor me with that report so that I can check its authenticity.
Yes. So that was before you actually met him. That was a letter that was requesting a meeting.
That is correct, Chairperson.
Yes, and subsequently you met with him.
That is correct, Chairperson.
But in the meeting, he did not commit himself to whether such a report was in existence or not. Is that right?
He did not commit himself to that. Safe to say that he is aware that people are saying there is a report somewhere.
Yes, okay. And then he said when the time is right, he would write to you and explain, or he would explain to you.
He said he will explain to me. So I just took that maybe they will invite me by way of a letter to come there, or I will get a letter which explains that.
And did he give an indication of the time frame, how long it might take for him for the time to be right?
He did not, Chairperson. This is the reason when I got to the office, I realized that I did not understand him. the nation will forgive me.
Yes.
I realized that. But what I did is that I then wrote another letter when our discussion was still fresh in my mind. Basically because no minutes were taken of that meeting. So I wanted to put it in my own record to say that, Mr. President, we met on this particular day and this is the discussion. And let me also remind you that I'll be waiting for that engagement. And I also indicated that I wanted to conclude that investigation as soon as it is possible. And so that's how I dealt with it, but there was never a commitment in terms of the time frame as to
Yes.
when he was going to explain that, Chairperson.
And which year was it when you were having this engagement with him? Was it 2017? Well, the complaint was given to you in April 2017, so it must have been in 2017.
Yes, it was in 2017,
Yeah,
Chair.
you say actually in Prof 114. Oh, no, you talk about a meeting. No, it's not your meeting with
No,
President
it's
Zuma.
not that one.
Yeah, but it must be sometime in 2017.
Yes, Chairperson.
Okay, Mr.
Two issues, Mr. Dintwe. Firstly, this correspondence to which you refer, do you still have it?
That's correct, Chairperson.
And it could be provided.
It is, I think, in the documents that I've provided already.
No reference is made to it, but perhaps we'll check.
But I do have that letter,
Please.
I'm sure. I'm
Would
very,
be
very,
useful to check.
yes, I'm very, very.
Actually, both letters, the one that went when you requested the meeting and the one that you wrote after the meeting.
It will be two
Yeah.
letters. Because the other one, I can't remember if it was the one I was getting worried whether that I can't just keep it open. So we can even see it as a follow-up, letter. So I will always keep those kind of letters.
Yeah, okay.
Then in paragraph 115, and I need to ask whether this is accurate or not. Line 4, you say, or line 3, sentence begins, despite numerous requests, including one at a meeting with the former president, and despite his promise to provide a copy of the report, nothing was forthcoming. Is that correct, or does it need correction?
Let's qualify it. I'm sitting with the president. He says, when time is right, I will explain to yourself. I hear people saying there is a report somewhere. That report may not be existent because as the president, sometimes I get verbal. But I never wanted to conclude that the report was non-existent because he said it may not be existent. So I was still harboring under that. I will just see as and when it happens, what comes to me.
Well, Mr. Pretorius, we have an affidavit. We have affidavits from Mr. Mantashe, Dr. Zwelin Kize, if I may recall correctly, and Ms. Jessie Duarte. If I'm not mistaken, all three of them have deposed to affidavits at the request of, at my request, maybe last year sometime, or maybe 2019, where they were asked to give their account of what Mr. Zuma said to them at a meeting of the top 6 the day before I think he recalled, or the day before he fired Mr. Godani. They've put up affidavits. I may be wrong. We need to check whether in their affidavits they talk about him having a written report in their hands, in his hand, which he did not give to them, or whether they simply said, he said he had a report, but did not make it available to them. Because I do recall that it wasn't given to them, but I don't recall whether they said he had it in his hand, or whether they just said he had a report.
My own recollection, Chair, is that there has been evidence of the existence of a written report. Yes, Operation Checkmate, it's called.
Yes, and I seem to think that the current president, there was he gave an interview to one of the TV channels around the time of the dismissal of Mr. Gordhan, because you might recall he went public to say he was opposed to it. I may be wrong. I seem to think he may have spoken as if he had seen the report or had sight of some parts of it. I'm not sure. So there is that clip, so one can check.
I can assist the commission further then, maybe taking the talk from what the chairperson just said. So the current president, at that time, the deputy president, was also interviewed for this investigation. And they wrote to myself through her legal advisor, but the report was never provided to myself. So that one I still remember succinctly. His responses will be in the file, because it will be the file from different witnesses that I would have spoken to.
Yes, but you recall whether he said he did not have it, because that would be one thing, or whether he said he did not have it and had never had sight of it or anything. Because I'm just not sure. Somebody has spoken about, as mentioned, I think, on television, pictures of it. Pictures of it. So, but it's okay. We can check.
Yes, Chair, and it does appear in certain media reports, or not the report itself, but copies of a person holding the report.
Yeah, or holding an alleged report.
Allegedly holding the report.
Allegedly holding the report.
Well, let's just summarize it then. You were asked to investigate the origins and authenticity of this report.
That's correct.
You interviewed various people, including the former president.
That's correct.
You had a discussion with the former president about the existence or otherwise of a report.
That's correct, Chairperson.
A report which you were investigating.
Yes.
Did you ask him for a copy of the report?
Yes, I asked him.
Did he ever give you a copy of the report?
Not at all, until he left the office, Chairperson.
Did anyone ever give you a copy of the report?
No, no one. There was only that badly written document which was on social media.
Right.
Yes.
And you say at the end of paragraph 115, we were of the view that we could not simply rely on the report leaked to the media in order to authenticate the veracity of the report allegedly provided to the former president. Was that the outcome of your investigation?
That was the outcome of the investigation, and that statement, I mean that what we had then was what we downloaded like anybody else.
Right.
And the president had not taken ownership of it. So I said that you can't deal with origin of a document, you can't deal with the veracity if it's unowned at all.
In your view, did you ever get a full and satisfactory report from the former president?
Not at all, Chairperson, until he left the office.
Paragraph 116, you refer to another so-called intelligence report.
Before you go to that one, Mr. Pretorius, you referred to Dintwe to his departure from office. Do you know of anything that would have prevented him from making arrangements to ensure that he provided you with the explanation or the report even after he had left office if he wanted to assist your investigation?
No, I am not aware of anything that would have prevented him from doing that.
Okay.
Would you
Maybe this point is also important that amongst the people that I would have talked to, again, I wrote to the three intelligence services and I informed them, I mean, it was in their knowledge and so forth, and all of them said that that report was, the report and the briefing was not given by any of them.
So all the intelligence services in the country said they never gave such a report or briefing to the former president.
That's correct, Chairperson. In fact, the head of defense, they call them CDI, Chief Defense Intelligence, he even requested that should I come across that kind of information, I should try to put them in the loop. Because I think that it could lead to embarrassment if somebody had to provide me the report and none of the intelligence services in the country was aware of such.
Okay.
So, do I understand it correctly? You could conclude after your investigations that it was not an authentic report emanating from any of the state security agencies?
No, my finding was that I could not reach a finding because I did not have any document that I could verify its authenticity and its origin.
But nevertheless, the information you received during the course of your investigation from the intelligence agencies under your watch was that it didn't come from them?
That's correct, yes.
Okay. All right.
But remember, that could not be a finding because I would have developed a hypothesis, or if you like, a question that I want to answer. And the question that I want to answer was, is this a report originating from any of the three? Is it an authentic report? And are we able to verify it, like the veracity thereof? So the finding, I will only mention those points in the analysis of the evidence that I got, the witness and so forth, but it will not come there because I wanted to answer a specific question.
Well, there was the question of the authenticity of the report. There was the question of the allegations made against the Minister of Finance, Mr. Godan. I guess the allegation or allegations would be, or there would have been, what those who were in a meeting with the former president say he said, namely that he had an intelligence report to the effect that Minister Godan and Deputy Minister Jonas, while they were outside of the country, they were going to meet with, they were going to attend certain meetings, which he viewed as unacceptable, or threatening the security or whatever. I guess that's the allegation that you would be looking at. And in the course of investigating that allegation, obviously you want to see the report on which the allegation was made, or in which the allegation was made.
Yeah.
Is that right? Insofar as the allegation is concerned, you had interviewed the person who had made that allegation and said it was based on the report. That person being Mr. Zuma. And he had not given you anything to substantiate the allegation. You had, I don't know if you had interviewed Mr. Godan and Mr. Jonas, because it seems to me that you ought to be able to say, you ought to have been able to say, if you had interviewed all the people that you identified, to say, has this allegation been substantiated or not? And if it has not been substantiated, then you say the allegation has not been substantiated. And part of the reason why it has not been substantiated is because those who could have furnished you with the report that would have had information about that had failed to.
I did not go there, Chairperson,
Yes.
and I remember the reasons. Because, not that we are not careful with other complaints, but this one I remember that I had several meetings with my team and we brainstormed. The first reason why we could not look at the allegations is because the complaint was not even coming from Mr. Gordon or Mr. Jonas. So I declared them victims, if you like, but they were never my complainants. The complaints came from somebody else. But the second reason why we could not investigate the allegations was because Mr. Gordon himself and Mr. Jonas cannot be viewed as, say, members of an intelligence service, or they cannot be seen as a head of a service. And our investigation will be about the intelligence and counterintelligence matters. So there is that little bit of confinement, and we just didn't want to go out of that.
Yeah, well, I'm not sure whether it was right to approach it that way, you know. I can understand when you say, I couldn't make any finding or make any pronouncement on the authenticity of the report because I didn't get the report. That I can understand. The fact that I got some alleged report from whatever source that you downloaded, you know, wouldn't help in terms of the authenticity of the report. But in terms of the allegation, I would have thought that you would need to talk to Mr. Godan and Mr. Jonas to say, I'm investigating this allegation that when you people were overseas official trip, you were going to meet with certain people for whatever purpose. They might say, if you tell them, they might say that's nonsense, or they might say yes, we were going to meet such people, but we're going to discuss legitimate issues relating to our ministries or government, you know, and you could have information from them saying there was no such thing as was alleged. You have nothing coming from Mr. Zuma, who had made the allegation, and I would think that they should be entitled to being cleared because Mr. Zuma has provided no evidence to substantiate the allegation. But I accept that you may have looked at it in a certain way, and but I'm just saying, you know, it just seems that might be unfortunate if some allegation that is not being substantiated by anybody seems to be left hanging instead of being dismissed if there is no evidence to substantiate it in circumstances where those who are in a position to provide evidence have been given an opportunity to do so and they have failed.
Chairperson, I may have omitted something, and
Yes.
I don't want to do this when I'm giving evidence.
Yes, no, that's fine.
Going back, but
Yeah.
I was only saying that I declared them as victims other than complainants.
Yes,
But I've met with Mr. Gordon,
yes.
and he was even in the in company of his legal representatives.
Yes.
In Pretoria. We are also in possession of a transcript, both a recording and a transcript that was done by his lawyers,
Yes.
where he denied those allegations. I had extended the same invitation to Mr. Jonas, but it was at a period, I think he was appointed to go and deal with some investment, something. So he was just not available, but I tried that, and I also used the cell phone, because I just wanted the record to say that, but I've given you some kind of an Audi, you know, even if you are not an implicated person. So we have those records. I don't know why did I omit that. But part of my, and I accept criticism, you know, easily, part of my findings did not really deal with that.
To the merits of the allegations.
If there is any information there, you'll find it somewhere in my report, but not under findings.
Yes, okay, no, that's fine.
In paragraph 116, Dr. Dintwe, you give two further examples of the use of so-called intelligence reports, whether genuine or fake. Would you tell the chair about those briefly, please?
Yes. And maybe let me preface just by saying that I'm also observing the modus operandi here. I think the chairperson remembers when I said that they besmirch you, you suffer the consequences, and then there is nothing that actually implicates. They even go to an extent of saying, it was a wrong alarm bells. But by that time, the two people that I've referred to were out of their positions. Now, the same thing here. There were allegations, there was a report, and in that report there were allegations that crime intelligence in this instance, during their course of monitoring, they came across an alleged plot by the following members: General Shadrach Sibia, Mr. Robert McBride, and Mr. Paul O'Sullivan, and others, and that they were intending to overthrow government. This report purported to be that report, as well as further reported into the alleged unlawful rendition of foreign nationals involving Generals Dramat and Sibia, were questionable and have recently been proven to be untrue. The first one that I dealt with, they were saying that there was a meeting somewhere in the East Rand where these people that I'm mentioning here met, and that they were plotting to overthrow the government.
And the bundle of documents will include examples of these reports.
This one will include the example of that.
Perhaps the conclusion that you reach in paragraph 117 of the existence of these reports and their use and outcome is summarized in paragraph 117. Perhaps you should read that on the record, if you will. Paragraph 117.
These reports, and it's very strange, it's only these reports that raises suspicion. They are often prepared in a very clumsy manner, with a lot of spelling errors, and sometimes they are even incoherent. And I'm also using a word there to say that they are also unintelligible when you read that. And that becomes a common denominator. It does not even matter whether they were coming from State Security Agency or from crime intelligence. So you will not have those reports which deals with the domestic intelligence as far as the defense is concerned. And there's a reason for that. They fall under a particular regime. But that's how these reports are. You're asking yourself who's writing them, and if they're submitted to anybody, what are those senior officials saying about these reports? Not that I want them to be coherent and so forth, that I'm setting a standard. No. They are dealing with lives and rights of individuals.
No, but they must be coherent. They must be coherent, and they must, when you look at them, when you read them, they must show some seriousness, because they deal with serious issues, and as you say, people's lives, and if they are to be taken seriously, I would have thought that any report that is going to be sent to the president of the country would be a proper report and not something that really looks like something that has not been prepared by people who are serious.
In addition to the features you mention here in paragraph 117 that the identity of the compiler of the report is more often than not stated or evident.
Yes, it is not. It's not stated in those reports. I understand the security requirements, but you cannot just have a report that you do not link to anybody. There should at least be a code name or even a number. These people, they will have numbers, so that they can know when they pay me, when they grade my report, they know that I'm the one who compiled that report. But this one, the one that was dealing with General Sibia and Mr. Robert McBride, in fact, it was written, a compiler, but it was left blank. Not knowing that when it was given to me, maybe they would have T-Pexed that, but I was expecting that the bare minimum, at least, I could find at least a code name or a number linked to the compiler.
Yes. And the chair has pointed out something which I think is very important and bears repeating, that what is significant is not only who compiles the report and how the report comes about, but the fact that people in senior positions are prepared to make use of such reports to take action against people.
That is correct.
Perhaps you can go on from line 3 of paragraph 117 and just put that on record, please.
You wanted me to read from?
Yes, please. Line 3. You've dealt with the first 3 lines of 117.
There seems to be no recourse for the citizens whose integrity and careers are destroyed by these reports, even in cases where the compilers are known. It is my view that these reports are relied upon fully knowing that they will not stand up in court as they achieve, and they may not achieve the desired effect of removing key persons who stand in the way. May I please just repeat that? I made a mistake.
I think read that sentence
Yes,
again. You
it
put
is
a
my
not
view
in
that
there.
it is my view that these reports are relied upon full knowing that they will not stand up in court as they achieve the desired effect of removing key persons who stand in the way of state capture from their positions. The deleterious effect of this is that the names of these persons are irreparably besmirched by these reports, as by the time the cases are withdrawn against them, it is too late. Their careers have been ruined.
Thank you. In paragraph 118, Dr. Dintwe, you deal with a new topic, and that is irregular appointments.
Just before you proceed, Mr. Furious, can I ask this question? To the extent that during your term you may have had the experience of investigating reports that are legitimate, that legitimately come from the intelligence services, the clean services. Are you able to say, generally speaking, those that are legitimate do not have these features that you have identified in regard to the reports that seem not to be legitimate?
That is correct, Chair. The other reports will go through a rigorous process that I do not want to divulge here.
Yeah, no, that's
but
fine.
it will not move from person A to person B and end there.
Yes.
There will be checks and balances throughout the system.
Yes,
To an extent that some of them, I think that they will be discarded.
yes.
And
yes.
if they were compiled by somebody who was expecting some kind of remuneration, they will not then be remunerated because they will be useless in inverted commas. And you can see that distinction. It's only that in this instance you want to look at those reports that as suspect. Those reports that you could have some allegations that it was used knowingly to really deal with somebody who was standing against malfeasance or corruption. So there is a clear distinction between the
So
two.
you say generally they will, legitimate ones will have a compiler, even if it's the code that's given in terms of the compiler or the author. And then you say, even in terms of the quality of the report, it's different from these other ones in terms of how professional they look.
It is
Chalk and
far better. In fact, Chairperson, they made a presentation to me with regard to an issue then which came into the public domain about the intention of some grouping in Bloemfontein who wanted to attack the conference there in 2012. Very professional, even including the slides, where it started, where they registered the project and so forth. I was so much impressed.
Yeah.
And when you take that report and compare it to these ones that I've been mentioning here, you can just see that no. This one did not really go through the ordinary process of producing an intelligence report.
Okay.
Chair, in relation to a query that you raised and comments made earlier about the so-called checkmate report that was used at the meeting of the top six, or referred to at the meeting of the top six, if I can just place on record, and it's perhaps apposite to do so in this context.
Yes.
I have in front of me the affidavit of Ms. Duarte, and at paragraph 10 of that affidavit, she says, at a meeting of the officials on 27 March 2017, former President Zuma informed the officials of an intelligence report which made reference to a meeting that Minister Gordon had attended in London. He did not produce the report, but said that the contents gave him great discomfort. That evidence is confirmed by Mr. Mantashe, who says in paragraph 10 of his affidavit, and I'll put the references on record.
Yeah.
At a meeting of the officials on 27 March 2017, former President Zuma informed the officials of an intelligence report which made reference to a meeting that Minister Gordon had attended in London. He did not produce the report, but said it gave him great discomfort. And then it goes on.
Okay.
And
That's
those are
helpful,
in
yeah.
exhibit JGZ. I'm not sure that these page
Well,
references will...
Yes,
be
yeah, I
of
think
use
those
at the moment.
affidavits haven't been, as far as I know, haven't been admitted as
Yes, well, perhaps they should be. But I'll-
well,
I'll
they should in due course, but my recollection is that they have, there's not been an occasion for them to be admitted, but we have obtained them.
We'll see to that. We'll
Yeah.
discuss that with you in due course.
Yeah.
In paragraph 118, you deal with a new topic, and that is instances of irregular appointments within the intelligence services. Would you tell the chair about those, please?
Yes. The problem about irregular appointments, Chair, is that they create instability, firstly, but they also create a fertile environment for state capture itself. Because sometimes it's not only about this irregular appointment, but it's about the person that is being put in that particular position. So we've made several adverse findings with regard to both the State Security Agency, but also with the crime intelligence, where recruitment procedures were not followed. In certain instances, there will be no criteria at all. You will ask, which criteria do you use to recruit these people? They will just say that, no, it is not there. Some of the positions will not be advertised. And those are the examples. But I've got a specific example here because it is of a senior person who was appointed.
All right, you give several examples, but as I understand the point you make in the paragraphs that follow paragraph 118, is that where proper procedures aren't followed, it does open the door to undue influence being exercised and other irregularities occurring. Do I understand you correctly?
That is my submission and my argument.
And you give those examples in paragraphs 119, 120, right through to paragraph 124. Is that correct?
That's correct, Chairperson.
All right. Is there anything you wish to emphasize there for the Chair?
Let me emphasize this other one because it is done by Minister Bongani Bongo, the former minister. So there is this position.
Is that paragraph 119?
It will be paragraph 119. So there is this position at NICOC. So NICOC, National Intelligence Coordinating Committee, is led by a Director General, but it is seen as part of the intelligence service. No. Yeah. The Director General of the State Security Agency is the accounting officer for NICOC. So,
that's the National Intelligence Coordinating Committee.
Yeah, the Intelligence Coordinating Committee. So, in that, they had there was a vacancy, but they did not advertise that particular vacancy. And what happened is that Minister Bongo, on his third or fourth day, we can check because I have the full report in the bundle there.
And you investigated this?
I investigated and I produced that report. So what happened is that he met then with the head of NICOC and he instructed the head of NICOC to produce a submission, which then will come to him for approval, but obviously it will go through the other signatories like a recommender, it will be a compiler, a recommender, and I think maybe sometimes a second recommender, maybe from HR, and then it will be approved. Appointing this particular member to a level of a program manager. And the reason that he provided to the head of NICOC was only to say that he knows this gentleman and he also knows that this gentleman is raising his kids alone because he lost his wife. So his argument, I think that it was just to say that put him somewhere because he does not have a secondary income like other families will have. That was the reason that was provided to the head of NICOC.
Right. However kind-hearted the gesture may have been, what are the dangers that attach to that sort of conduct?
It is that obviously those people will be gratified to the appointing officers, so they can be told to do anything, and they will really, really do that because, I mean, this was unexpected, and it created a lot of problems also because there were then grievances from the other people who said that we could have contested for this position.
Was this person who was the beneficiary of this decision, was it somebody that was a member of SSA already, or was it somebody from outside?
No, a member of SSA already, a chairperson, but then placed at NICOC.
It was a question of them then being put into NICOC?
No. What? He is in NICOC.
Yeah.
And then they are taking him from, let's say, level 2 to level 3 within NICOC.
Just so that they can earn higher.
Exactly, Chairperson.
Okay.
Right. Did you make any recommendation as a consequence of your investigation?
I made recommendations, but I should have mentioned that he only spent a week in that promoted position, to the position that he was promoted to, and then he was then appointed to become somebody higher than an acting deputy coordinator.
So he received 2 promotions.
2 promotions in a space of a month. And yes, of course, I sent the recommendations to the Minister of State Security.
You sent a recommendation to remedy the position or the situation.
That's correct, Chairperson. Our recommendations was that the appointment to that level should be withdrawn. Secondly, that it should be advertised so that everyone can take part on that. But there was something where we also recommended some kind of disciplinary measures to be taken. Because one of the junior members who works at HR in that entity, his signature was then forged in that submission.
To recommend.
I think it will be a compiler, but somewhere he will be
okay.
a line of signatories. That's why I'm saying that he doesn't make decisions, but normally it will go to him to check whether the recruitment process, the selection process was. So when he affixes signature, is to say that I've assisted my principals to ensure that all processes are followed. But during that time, he could remember very well that he was in Cape Town. He was not in Pretoria. So his signature was forged.
And how long ago did you submit your report to the minister? More or less? Or which year were you investigating this matter?
I do have in hand paragraph 120, I've got some few dates there. It's something that I will need.
So this must have been latter part of 2019 and 2020, the early part of 2020.
Yes. So, Chairperson, I investigated that matter. I made recommendations, but at the time that I was writing this affidavit, those recommendations were not yet implemented.
Well,
And as far as you know, as you sit there, have they been complied with?
No, not at all.
Have you been
Chairperson.
told that maybe the minister doesn't agree with your recommendation for the following reasons, A, B, C, D, as she told you? Anything along those lines?
Yeah, no, Minister Ayanda Dlodlo, then after, I think several follow-ups, she wrote to me agreeing with our findings and our recommendations.
that's on the 22nd of February 2020.
Yes,
Those recommendations have not yet been implemented.
not yet implemented.
Yeah. So she has agreed with your recommendation, but the implementation has not taken place almost a year after she indicated that she agreed with them.
That's correct, Chairperson.
Yeah.
So there were 2 problems, as I understand it. One was your finding that a minister had exercised what I presume you regard as undue influence, is that correct?
That's correct,
In the
Chairperson.
process of appointment, but secondly, that the process itself was irregular.
That's correct, Chairperson.
And your recommendations have not been implemented yet.
The recommendations are not yet implemented. But there was a serious attrition of ministers during that period. It gets, the appointment is done by Minister Bongani Bongo, and then we had Minister Letsatsi Duba. She wasn't there for long. Really, I cannot recall whether I would have written to her, but then she gets replaced by Minister Ayanda Dlodlo, whom I'm certain that I would have written to her, not once, Chairperson.
And then in paragraph 121, you refer to another example.
I think Mr. Pretorius, it might be appropriate to establish from ministers also what the position is, because I think that when these oversight bodies make recommendations, the relevant authority should apply their minds, take a view whether they have a problem with complying, and if they think they have a problem, at least they should say so and give their reasons. And it may well be that in regard to some of these, maybe they might have to go to court to set it aside, I'm not sure, but one shouldn't have a situation where there is absolute silence or there's agreement with the recommendation, but for a long time, nothing happens.
We'll do a request for information, Chair.
Yeah,
I'm sure we'll get a response.
yeah.
A similar circumstance arises in paragraph 121, but I see we are over time.
I was thinking maybe I shouldn't say anything as long as you continue.
Well, Chair, I'm in your hands.
No, because I think I promised that we would adjourn at 5:30. Let us adjourn. But there are going to be days when I'm going to ask everybody that we all be strong and move beyond 8, go to 9, and so on. So
I will inform those accordingly.
and yeah, but that's fine. Let's stop now. I think we should talk, Mr. Pretorius, to arrange another evening session for Dr. Dintwe to try and finish his evidence.
Yes, Chair, if we are able to start around, we will definitely finish in one more.
Yeah. So, but there's a possibility that my evenings next week are full. There is that possibility. And if they are full, I was thinking whether it might not be a good idea to look at a morning, in terms of which we could say let's start at 8. So by 10 o'clock we might be done, and then I continue with the witness for the day. If we arrange that, how does that sound to you?
Yes, Chair, that's fine, as long as it's after the President testifies.
Oh,
As long as it's after the President testifies, we're obtaining the statement.
Yes, okay. All right. Okay, thank you very much to everybody. We'll adjourn. And then for the benefit of the public, I just point out that tomorrow I will hear the evidence of Mr. Anuj Singh under the Transnetwork stream, as well as on Friday during the day sessions. And tomorrow evening, I'll be hearing the evidence of the former Minister of Public Enterprises, Ms. Lynn Brown. That's just to inform the public. Thank you very much. We adjourn.
Thank you, Chair.